ಮೇಡಮ್ ನಾಳೆಗೆ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ತಗೊಂಡಿದ್ರೆ ಮಾತ್ರ ತಗೊಳ್ಳಿ. ಅದರ್ವೈಸ್ ನಾಳೆ ಆಲ್ರೆಡಿ 240 ಮಾಡಿದ್ದೀವಿ, ಇದಾಗಲ್ಲ. ಕಾಲ್ ದಿ ಕೇಸ್. ಏನ್ ರಾಜಶೇಖರ್ ಗುಂಜಳ್ಳಿ, what is this being spoken to?
Well, the state has moved this matter.
Why?
The reason is that, my lord, this court has granted the interim order on 27/12/2024, saying that results can be announced. So already result has announced, and the certificate has been issued. After issuing the certificate, the meeting dispose agide. They participated. They participated in the first meeting. They declared as the director. Now
So,
this.
what is wrong with this now?
Now we are not brought to the knowledge that now there is a direction to include the votes cast by the petitioners.
ಅಷ್ಟೆಲ್ಲ ಆಗೋಗಿತ್ತು.
Already ಎಲ್ಲ ಆಗೋಗಿದೆ. That we fail to bring to the knowledge of this honorable court.
It's not my order.
This is your order.
ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, final order ತಮ್ಮದೇ.
Final order
ತಮ್ಮದೇ.
Yes sir. ಎಲ್ಲ ಆಗೋಗಿದೆ. Whatever you want, avail of such remedy as available.
Please, under section 70.
Where is the order, madam?
So the liberty to challenge.
BMSPG order follow ಮಾಡಿದೀವಿ.
ಅದರಲ್ಲಿ please.
Our mistake.
ನಮ್ದೇ.
My mistake, your lordship.
These petitions were disposed by an order dated January the 28th, 2025, on the submission that the matter stood covered by what was ordered by the coordinate bench in so and so the petition act. The state has moved a memo of being spoken to on the score that there was the submission appeared to be contrary to the facts, as the elections were over, results were declared, and the direction is now to count the votes of the petitioners, votes of the petitioner which was kept in sealed, which was kept separately in a sealed cover. Since the counting is over, results already declared, the direction would run counter to what has already happened. In that light, leaving open to the petitioner to avail of all such remedy as is available in law, the petitions would stand disposed. The orders on being spoken to the body, so and so. This order shall be treated as part and parcel. Alabeda.
With my lord's kind permission, if I have not
1
interrupted.
minute. ನೀವಿದ್ದೀರಾ ಇದ್ರಲ್ಲಿ?
ಇಲ್ಲ, I'm sorry, my lord. I was mentioning.
Wait, sir.
Great.
Yes. The order so and so stands recalled, and the order and this which shall be the petition stand disposed in terms of the subject order. Not a correct order.
Sorry.
Review act, not this.
Sorry.
Anyway.
Sorry, your lordship.
No, being spoken to ಮಾಡಕ್ಕಾಗಲ್ಲ.
Cell number 5, FE Patil.
Yes, Arbati or ಏನು, 1 ನಿಮಿಷ.
Not only, my lord, the other day, my lord pronounced the orders, my lord. In that matter, I forgot to request for
Release ಆಗಿದೆಯಲ್ಲ?
investigation records. I just wanted.
Somebody, whom do I give it?
My lord, my IO inspector is there, my lord.
Where
you
is
can collect it.
Where is the investigating officer?
My lord, Mr. Anil Kale will not identify him, and it can
Who
be.
are you?
Sir, ನಾನು police inspector sir.
Remove your cap. Have you come on a jaunt or to the court? How can you wear a cap and come? Huh?
Sorry.
This is the attire you come to the court. What cadre are you in?
Sir, ನಾನು police inspector.
Police inspector. This is what you know about the court. In cinema theatre walk ಮಾಡ್ತಾ ಇದ್ದೀರಾ, ಕೋರ್ಟ್ಗೆ ಬಂದಿದ್ದೀರಾ? Yes. ಏನು ಹೇಳಿ?
Sir, documents ಕಳಿಸ್ಕೊಟ್ಟಿದ್ದಾರೆ sir.
I will give it in the afternoon because we need your acknowledgement. Can I hand it over to him?
Very well, my lord. Mr. Anil Kale will also be there, my lord. I will.
Anil Kale is not here anyway. 1:30 ಗೆ ask Anil Kale to come to the chamber at 1:30.
Grateful, my lord. I will request.
Yes.
Very happy.
Yes.
Cell number 5, FE Patil, Ramchandra Mali.
For the petitioner, my lord, but on last occasion, my lords heard this matter for some time. Lord, this is a matter where, my lord, without there being any order on the increments, the respondent, my lord, has withheld the increments of the petitioner, that too after the retirement. Lord, Annexure J, my lord, page 39 is under challenge.
Ah, withholding of increments.
Withholding increments without there being any
recovery of-
order.
recovery
And
of-
also recovery, my lord.
No inquiry?
My lord, no inquiry. My lord, what had happened? In 2004, my lord, petitioner was working as a professor. Based on some students, my lord, had made some sexual harassment allegations. A departmental inquiry came to be held. My lord, the operative portion of the order is at, my lord, page number 17,
17.
of my petition.
Oh, this is that sexual
Ah,
harassment committee.
Please, my lord, please. Lord,
Sir, Girish.
Millards, the order of Millards, the impugned order Millards paying his pay and grade reduced to the professor. And also the minimum scale fixed at the scale of raider Millards, not entitled for any promotion in future Millards.
Anta ಇದೆ.
Please Millards,
What is
these all orders are being challenged Millards in by the petitioner herein. And order Millards, the penalty number 1 and 2 came to be modified Millards.
Came to be modified where?
Please Millards.
Where is the order
Millards,
modification?
came to be sustained Millards. 3, 5,
Appeal ಹಾಕಿದ್ರಾ?
petition has been filed by the
Lord,
petitioner herein.
last section, I had handed over a copy of the order.
Oh,
Right,
that-
my
this is Ravi Malimat ಅವರು. ಹಾ.
Please Millards.
Yes.
Please.
Thereafter Millards,
Now what
the
remains?
My lord, 1 and 2 is confirmed. 3 and 4, 3 and 5, my lord, had
The
become
1 and 2 under
inconsequential.
page 17 ಗೆ ಬನ್ನಿ.
Please, my lord.
17 what is confirmed?
My lord, his pay and grade is reduced from professor to reader. It's
So
confirmed.
that is over.
Please, my lord.
All
And his pay will be fixed at maximum pay scale of the reader. That also confirmed.
That is consequential ಅದು.
Please,
Yes.
my lord.
Hmm.
And punishment number 3, my lord, he will not be entitled for any promotion in the
He had
future.
retired by then.
Retired by the
All right.
inconsequential.
Hmm.
My lord, suspension period is treated as that is set aside, my lord.
Ah.
And fifth punishment is also become inconsequential.
All right. So only thing remains is
1 and 2.
1 and 2 already ಆಗೋಗಿದೆಯಲ್ಲ.
Ha, confirmed.
ಮತ್ತೆ ಏನ್
My
ಮಾಡೋದು?
lord, now my lord, what had happened after the retirement, my lord, he sought for pensionary benefits. Pension benefit was withheld, my lord. Thereafter, my lord, we gave a representation. An office order was passed stating that, my lord, he is not entitled to any increments and increments were wrongly given. And my lord, the respondent sought for recovery of the
Wrongly given
increments.
ಯಾವಾಗ?
My
When
lord,
were they given?
2010, my lord, page number annexure B, my lord, page number 18.
2010
my lord.
Page 18 is it?
Page 18, annexure B, my lord, 23 January 2010. My lord, this is for the first time, my lord, I was given with the increment in the 2010. My lord, relevant page is page number 19. The lordship may kindly see the table, last portion. 58,980, that's the increment which I was withdrawn. My lord, till 2012, my lord, I have withdrawn that increment. Annexure C, my lord, page number 20. One more increment was given, my lord. I have withdrawn 69,329. That's my second increment at the time of retirement. My lord, after this, my lord, page number 24, annexure E, my lord, an office order was passed for recovery. My lord, this official order, my lord, we challenged before. Date, my lord.
Office order is page 24,
24, my lord, annexure E,
2013.
2013. My lord, this order came
Payment was given in the year 2010.
and
10 and 11.
12. And thereafter, my lord, this office order was,
Did you retire?
my lord, retired
2012 Millards. 2012 Millards.
31, 2012, my lord.
31st January,
31st January, 2030.
12, 13.
2012, my lord, sorry, 2012. Lord, thereafter, my lord, annexure E was challenged before this honorable court. That official endorsement was set aside with this honorable court. My lord, page number 25 is the order. Thereafter, my lord, liberty was reserved in favor of the respondents to issue a fresh show cause notice. My lord, along with this fresh show cause notice, they have annexed the copy of the, my lord, audit report. My lord, it's at, my lord, page number
31 Millards.
31, my lord.
In compliance to the order Millards. He has
My lord,
submitted the objection.
My lords may kindly see the last paragraph. My lord, may I read, my lord? ಮೇಲ್ಕಾಣಿಸಿದ ಆದೇಶದ ಪ್ರಕಾರ ಅವರ ವೇತನವನ್ನು ಪ್ರವಾಚಕ ರೀಡರ್ ಹುದ್ದೆಯ ಗರಿಷ್ಠ ಹಂತವಾದ 18,300 ದಿನಾಂಕ so and so ರಿಂದ ಅನ್ವಯವಂತೆ ನಿಗದಿಪಡಿಸಲಾಗಿರುತ್ತದೆ ಮತ್ತು ಗರಿಷ್ಠ ಹಂತವಾದ ₹18,300 ಗಳಿಗೆ ವೇತನ ನಿಗದಿಪಡಿಸಲಾಗಿದ್ದು ಅದರರ್ಥ ಅವರಿಗೆ ಭವಿಷ್ಯದಲ್ಲಿ ಯಾವುದೇ ಪದೋನ್ನತಿ ಲಭ್ಯವಿಲ್ಲವೆಂದು ಸ್ಪಷ್ಟಪಡಿಸಲಾಗಿರುತ್ತದೆ. ಅದರರ್ಥ ಅವರಿಗೆ ಯಾವುದೇ ರೀತಿಯ ವೇತನ ಬಡ್ಡಿಗಳಿಗೆ ಅವಕಾಶವಿಲ್ಲವೆಂದು ಆಗಿರುತ್ತದೆ. My lord, this, my lord, authority constitute as if, my lord, my increment has been withheld. My lord, only promotion was withheld. That too, my lord, set aside by this honorable court. My lord, there may be increments in the
Yes,
same
sir.
post.
Ashana. The petitioner is before this court calling in question. 2013 da idu.
Millards, I'm relying two judgments.
My lords.
Allah, my lords, just,
12
my lords,
years.
only on the reason that, my lords, they, without taking into consideration of the order, my lords,
ಆಯ್ತು, 12
the
ವರ್ಷದಿಂದ
revision or increment was given, my lords,
Right,
erroneously.
sir, why is it pending for 12 years for this small issue?
Please, my lords, my lords, thereafter, my lords.
The
Only, my
petitioner
lords.
is before this court calling in question an order dated 23/3/2013 by which the increments that were drawn by the petitioner in the year 2010 on 2010 are sought to be recovered. Stay there.
ಇಲ್ಲ, stay ಇಲ್ಲ.
ಮತ್ತೆ
My lord,
recover ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
Annexure J, my lord, increment is reduced, my lord. Now I have withdrawn 69,000, my lord. Now they have reduced to 52,390. My pensionary benefit has to be calculated.
Petitioner heard so and so. Facts in brief germane are as follows. The petitioner was at the relevant point in time working as professor in the postgraduate department of geography in the respondent university, Karnataka University, university for short. Owing to certain allegations of sexual harassment at workplace, the penalty after the inquiry so conducted, the petitioner was imposed the following penalty. Page. The subject penalty comes to become the subject matter of challenge before this court, before this court in writ petition.
12100, my lords, of 2007.
In writ petition 12100 of 2007, a coordinate bench of this court allows the petition in part by the following order. Para 6 in the end or haki. The effect of the order is that the penalty aforequoted are in the penalties aforequoted, few of them were set aside, few of them were found to be unnecessary to even be granted. The penalties that are set aside are that the petitioner's grade and pay is that is affirmed. Is it set aside?
1 and 2 affirmed, my lord.
The petitioner's grade is reduced from the post of professor to reader was affirmed, and the consequential pay that was fixed had to be fixed in the scale of reader is also affirmed. What is held to be unnecessary is that the petitioner would not be entitled to any promotion in future, as the petitioner by then had retired on attaining the age of superannuation. His suspension that was directed to be treated as leave is set aside. The other penalty that he would not be entrusted with any administrative or examination work in future had also become superfluous, as the petitioner had already attained the age of superannuation by then. So what remains is the effect of the reduction of pay of the petitioner from professor to reader, and the pay to be fixed at the maximum scale of pay of reader. Next paragraph. The petitioner at the university on the pay being reduced, the university grants the petitioner 2 increments for the year 2000,
2010, my lord. Annexure B.
2010 and 2011 in terms of an order dated 23rd January 2010. The increments in total that was drawn by the petitioner was 52,390. The order also indicated the future increments. Long thereafter, i.e. after the retirement of the petitioner, the said increment is sought to be withdrawn by an office order observing that it was erroneously paid and it had to be readjusted. The office order reads as follows. In the light of the office order, the pension of the petitioner is now sought to be varied, as the pay is fixed at 52,390 as
My lord, Annexure E was challenged, my lord, before this honorable court.
which court?
This honorable court, my lord. Annexure F is the order. It was set
Innone
aside.
madidra?
Ha.
Yes. One nimisha. The pay was fixed at 52,390 with effect from 1/1/2006 with a particular pay band. This again becomes the subject matter of challenge before this court in writ petition 75447 of 2013. The subject petition comes to be disposed or comes to be allowed by quashment of the order that reduced the pay of the petitioner, observing as follows, page 2930. A direction was issued to the university.
To provide an audit report.
So, a direction was issued to the petitioner.
To furnish audit report, my lords. Third line.
The petition comes to be allowed and a direction was issued to the university to furnish all the documents that led to passage of the order impugned therein, which reduced the pay of the petitioner. Then comes show cause notice amal kotidda.
Ha, page number
Then
31.
comes the show cause notice dated 9th March 2013. After the show cause notice comes the impugned order dated 23rd March 2013. The order reads as follows. Page 3940. The university construes that what was imposed upon the petitioner was stoppage of increments as well, or the increments had to be stopped as a consequence of affirmation of the penalty from professor to that of the reader. The opinion in, the opining of the university in the impugned order is on the face of it incorrect, as the penalty was his reduction in rank from professor to the reader, and the fixing of the pay scale in fixing of the pay of the petitioner to the maximum scale of pay of the reader. It is ನೀವು ಯಾವ ಕೇಡರಲ್ಲಿ ತಗೊಂಡಿದ್ದು increment?
Lord,
She was then associate professor, my lords.
ಅಲ್ಲ ಅದು
annexure B, my lord.
reader
fixation-
ಅಲ್ವಾ?
Reader, equivalent post, my lord. Fixation
of
of
course.
pay in the post of associate professor and equivalent posts, incumbent readers, lord, it's equivalent. Annexure B, page number 18, my lord, subject.
There is no indication in the penalty or as affirmed by this court that the increments of future increments of the petitioner would be stopped. What was ordered was reduction in rank from professor to reader and fixation of pay in the scale of reader. There was no penalty of stoppage of future increments, and therefore the order that directs refixation of the pay of the petitioner and consequent refixation of pension on the ground that the pay of the petitioner has been reduced to 52,390 as against 62,580 at the basic is on the face of it erroneous as observed herein above. In that light, the petition deserves to succeed with the prayer of the petitioner to be deserves to succeed. For the aforesaid reasons, the following order: allowed, quashed, a direction, a mandamus issues to the respondent to rework the pension of the petitioner and pay the arrears of pension to the petitioner from the date it fell due till the date of its fell due till today. Yes.
Lord,
Arrears ke bharat problem.
my lord, may I request for a time limit, my lord? It's
The
already retired.
Aforesaid, since the petitioner is retired 13 years ago, the order shall be complied with within 3 months from the date of receipt of the copy of this order. ಕೊಡ್ಲೇಬೇಕಲ್ಲ rework ಮಾಡಿದ್ಮೇಲೆ.
Please.
Yes.
Yes, my lords.
ಅದಕ್ಕೆ you should not keep these matters pending. Arrears ಯಾರು public money sir.
Please, my lords, but
13 ವರ್ಷ ಪೆಂಡಿಂಗ್ ಇಟ್ಟಿದ್ದೀರಾ ಇದನ್ನ ಏನಿದೆ?
there lies an ambiguity, my lords, so for that reason. Please, my
Yes.
lords.
Oblige, my lord, oblige.
Proceedings, Vipin Kulkarni, Viresh R. Budhia.
Please.
Respondent, yesterday I filed the document.
Hello.
Yesterday I filed the document.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟು?
ಅದೇ, ನಿತ್ಯಾನಂದ ಅವ್ರ ಮಗನಿಗೆ.
Case where, my lord, the application for training order is rejected. Training to the, my lord, family member of the land losers.
ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಂಡಿದ್ರಲ್ಲ ನೀವು
Partition ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. Now, my lord, my learned senior friend has produced document. In effect, my lord, to show that the grandson of the original land loser, that is my mother's brother, was granted a training order way back in the year 2010 and, my lord, employment order in the year 2011. My only, my lord, confusion is, my lord, Statement of objections was filed in the year 2022. And now these orders are placed on record.
All right, so they are orders. Sir.
No, that's why I'm not
They
Murad,
are
respecting.
facts are
Only
stubborn.
my
whenever they
submission
come
is,
about
Murad, on the last date of hearing, after Murad, I made a submission
Are
that,
you saying that the orders are generated now?
and I can't say so.
ಮತ್ತೆ?
ಮೊದಲೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ನಾನು ಇನ್ನೊಂದು ಸ್ವಲ್ಪ I could have tried my best because 2013 writ petition.
ಆಯ್ತು ಬೈ, ಏನ್ ಉಳಿತಿದೆ?
Only Murad, my respectful submission is, Murad, my mother's right having been Murad recognized and indemnity bond and all other compensation having been paid to her, let them Murad reconsider my Murad representation. That is what I can say, Murad.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಎಷ್ಟು ಕೊಡಕ್ಕೆ?
ಅಲ್ಲ ಇನ್ನೊಂದು ಡಬ್ಲ್ಯೂ
ಅಲ್ಲ, admittedly Murad, ಇದು ಲ್ಯಾಂಡ್ ಅರ್ಧ ಡಿವೈಡ್ ಆಗಿ ನನಗೆ ಬಂದಿದೆ
ಆಯ್ತು,
to my
grants
mother.
ಅನ್ನು ಕೊಟ್ಟಿದಾರಲ್ಲ,
Please,
ಗ್ರಾಂಟ್ಸ್ ಅನ್ನು ಕೊಟ್ಟಿದಾರಲ್ಲ.
but what had happened is Murad, in fact 300 to 400 families Murad were involved when this land acquisition was taking place. But only on the ground that Murad they promised to give employment, Murad, these lands were given.
Which is your representation?
Please. My representation,
Litigation ಆಗುತ್ತೆ ಗಿರೀಶ್, and nothing else.
page number 20.
One more litigation, it may help you, and you don't need that.
No, of course not on Murad, my personal this thing.
Hmm.
He is also the petitioner number 1 is also Murad very serious even as on today about getting the Murad training order. Because he firmly believes that Murad the land, his mother Murad agreed to give the land only on the Murad promise that Murad he will be given an employment. Otherwise Murad those families would not have parted with the land at all. After 14 years, 15 years, they come and say that no, you are the sister's son, therefore you can't be given employment. Murad. That is the Murad.
And is given ಅಲ್ಲಪ್ಪ.
But what can be seen from their own endorsement is, ಬಂದಿದೆ.
ಮತ್ತೆ?
What can be seen from their own endorsement is that Murad, the partition was prior to the date of notification. If it was so, Murad, then they could have.
Appointment, sir. ನಿಮಗೆ ಕಾಂಪನ್ಸೇಷನ್ ಬಂದಿಲ್ಲ ಅಂದಿದ್ರೆ ಎಸ್, ಒಂದ್ ಫ್ಯಾಮಿಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಆಲ್ರೆಡಿ.
ಅಲ್ಲ, ಅದರ್ 1 ಎಕರೆ ಏನಿದೆ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. My mother's brother's son, grandson has been given.
she has received compensation also.
So only Murad, let them Murad consider in this background. That's what Murad I can make submission.
ಸುಮ್ನೆ ಮತ್ತೆ ಇನ್ನೊಂದು ಲಿಟಿಗೇಷನ್ ಅವ್ರೇನು ಕನ್ಸಿಡರ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ, that's going to be their
Yes,
endorsement.
that is.
They can't go beyond the objections by giving an endorsement contrary to that.
Authorities usually Murad, they don't go back on their own Murad. That is also acceptable. I can't say Murad.
Why generate litigation? No, ಯೋಚನೆ ಮಾಡಿ. If you want to talk to your client and come back. you
Please,
can.
please.
Yes,
Kindly pass over Murad.
yes.
Bill number 7, Sridhar Srinilokar, Santosh Bhimane.
2014.
for the respondent.
ಇಲ್ಲ ಅವ್ರದೆಲ್ಲ ಅದು. ಇಲ್ಲಿ ವೇರ್ ಇಸ್ ಹಿ? ಹಳೆ ಮ್ಯಾಟರ್ ಬರಲ್ಲ. ಕವರ್ಡ್ ಅಗೇನ್ಸ್ಟ್ ಹಿಮ್.
ಇಲ್ಲ, ಅದು ಇನ್ ವ್ಯೂ ಆಫ್ ಮೆಲೋಡ್ಸ್ ವಿಡ್ರಾಲ್ ಆಫ್ ಮೈ ರಿಟ್ ಪಿಟಿಷನ್, ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಅಲೌಡ್ ಮೆಲೋಡ್ಸ್.
ಎಸ್,
ರಿಮಾಂಡ್ ಮ್ಯಾಟರ್ ಇದೆ ಫೈಲೇ ಇದೆ.
ನೋಡಿ ತಗೊಳ್ಳಿ, ಪಾಸ್ ಓವರ್. ಪಾಸ್ ಓವರ್ ಬೇಡ, ನಾಳೆ ಅವ್ರು ಕೊಡಿ ನೋಡ್ಲಿ. ನೆಕ್ಸ್ಟ್.
Bill number 8, Amir Ahmed.
No, it's covered by judgment.
Covered by judgment?
Touching-
What covered by?
Your lordship. Serial,
ಕೊಡಿ.
I'll,
Where is the judgment?
serial number 8 and 8.2, your lordship. In those matters, your lordship, the petitioners are government school employees, your lordship. And this annexure E, your lordship, that applies only to the grant-in-aid teachers, your lordship, not to the government school teachers, your lordship. And the notifications, your lordship, it applies to the period for 1974 to 1987, your lordship. In between.
Madam,
that
state
period-
saying it applies to aided institutions and not to us. Very
No, your
surprised.
lordship. The petitioner, the challenging this order, your lordship, that annexure E, your lordship, that applies to grant-in-aid teachers, your lordship.
Hmm.
And the period between which they are out to pass, your lordship, that is for 1974 to 1987, your lordship. And these petitioners, your lordship, though being the government school
ಮುಂಚೆ
teachers.
ಫೈಲ್ ಮಾಡಿದ್ರ petitions ಇವರು? You had filed earlier petitions here and was it dismissed?
No, your
No,
lordship.
no, no. That annexure E has struck down, my lord, by the Justice Magdum in that I have given the.
That does not
judgment in
apply
that.
to these petitioners at all, your lordship.
aided institutions. sir.
Aided
In that
ಇವ್ರಿಗೆ
it
ಮಾತ್ರ
is, entire things I have covered in that
And
judgment. Your
justice,
No, now what is quashing the amendment brought to the Education Act? The amendment is quashed here.
Honor. Yes. Your
please your
Right.
lordship, ಅದನ್ನ
Fine.
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ಅವರು.
No, earlier we have filed, subsequently order has passed. Based on that order, I have produced that citation.
Madam,
Please.
which is the one that is quashed in this amendment Education Act or Civil Service?
Annexure E is challenged in these petitions, your lordship. ಆಮೇಲೆ these petitioners are government school teachers, your lordship, and moreover, your lordship, they have passed these qualified exams in the year 2014 and 2009, your lordship, and beyond that period, your lordship, 1974 to 87, they ought to have passed, your lordship, but they have passed in beyond that period also, your lordship. In otherwise also, they are not eligible for the increment, your lordship.
Where is the complete order?
Can you pass over, madam? at that time?
Kerala pass over.
No, my lord, sir, that library.
We'll
was-
dismiss it. It's a lengthy order, ಹಿಂಗ್ ಮಾಡಿದ್ದೀರಾ ಮತ್ತೆ?
I'm not getting on
Get these
web, my lord.
petitions madam. ಧಾರವಾಡದ ಇದೆ ತಗೊಳ್ಳಿ. So first prayer is to be allowed. Next. Now annexure E is not applicable to them. Ma.
Please, your lordship.
Why?
May I take your lordship to?
Now how have you denied them?
Please, your lordship.
How have you denied them?
No,
Now
we have
increment
not
for
denied it all. They
Kannada
are,
language examination pass ಆಗಿಲ್ವ ಯಾರು?
ಅಲ್ಲ ಪಾಸ್ ಆಗಿದ್ದಾರೆ.
ಹಾ.
They are government school teachers, your lordship. ಇದು 87 ಏನ್ ಹೇಳತ್ತೆ ಅಂದ್ರೆ?
ಮತ್ತೆ ಇವ್ರಿಗೆ ಯಾವ್ದು applicable?
ಅಲ್ಲ, ಆದ್ರೂ ಕೂಡ they ought to have passed in between 1974 and 87, your lordship. May I take your lordship to page number 14, your lordship. Annexure B. Annexure B, page
One minute,
number
madam.
2, para number 2, your lordship. ಸದರಿ ನಿಯಮ 6ರಲ್ಲಿನ ಮೇಲೆ ಹೇಳಿದ ಅವಕಾಶವನ್ನು ದಿನಾಂಕ 1987ರ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ so and so.
Get the detailed judgment madam. ದಿನ ಹಾಕ್ತಾ ಇರ್ತೀನಿ ನಾನು, ನಾಳೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ. List tomorrow in the fresh matters list. Don't bring piecemeal. Yes. Next.
Till 9, HVK Murthy, AS Patil, NVRG.
In this matter, my lord, I am the proxy for the respondent. I am seeking weak accommodation.
No sir. Debate, yes.
Kindly have it on Monday or Tuesday.
No sir. Okay, what's the matter?
The order of dismissal is called in question.
Union Bank of India.
Union Bank.
What is your ground, sir?
Lord, the allegation is that of misappropriation. Lord, your lordship sees, Lord, the articles of charges.
Page.
Lord will get it at Lord's page number. Kindly see, Lord, the inquiry report itself at page number 60.
Where is the charge sheet?
Charge, yes. Page number 33 minutes, annexure G. Lord, the statement of allegations, imputations, page 35. They say that a sum of rupees 3 lakh was withdrawn from the account of one MM Hireman by manipulating the records.
All right.
Now, this person had given a statement saying that
Where is the statement?
my lords will get his millets at annexure. K millets.
Page.
Page number 57 millets. Typed copy as page 58.
What statement after the charge sheet, after the inquiry, when was it given?
It was given on 1/7/2011 millets.
What is that after the inquiry, is it?
No, before, during the course of inquiry. This was produced and marked as exhibit millets.
I had given the check for collection, so and so, I requested him to give credit, and I said, I went out to station, ordered my office boy to correct it. 1 month later, they came and told me to adjust the amount because check was not available. I paid the amount, and so now I am giving this bank statement. Bank amount was used by me and refunded by me. Cash withdrawal check has to be signed.
So, millets, now this is disbelieved by the inquiry officer on the ground that he has colluded with the petitioner and issued this notice. This is the finding recorded by the inquiry millets officer at annexure M, page 60 millets.
Now, what is the other? He manipulated the account.
The other charge was that I have opened the account of my wife without obtaining the signature on the form. This was the second charge. Now, the third charge was that the PL encashment was availed.
No, come to he borrowed an amount of 3 lakhs from a branch customers and deposited the same in the SBI account of Miriam.
That is the same billets, the first allegation.
Then collusion 100%. Amala, yes, next.
This PL encashment was billets obtained without the required declaration and without undertaking.
So it's not that, it is not that it is the only charge.
The 3 charges for that.
Now, where is the report of the inquiry officer?
Your Lordship, page 60 minutes, next AM.
Page?
Page 60 minutes, next AM.
16.
The 60 minutes.
60.
So for his first charge is concerned, my lords, findings will be commenced from page number 67, the findings. On perusal of the deposition of management witness in examination chief and in cross-examination and documents on record, it is observed that the Sri Gopal Beligikar debited the banker's account to the extent of 3 lakhs and credited to SP account of Sri Hiramat. In order to cover up his misdeed, he had borrowed 3 lakhs from the borrowers and got it credited in Hiramat's account, and thereafter on 18/8/2010, an amount of 3 lakh was debited to SP account number so and so of Mr. Hiramat and credited to banker's account along with inward clearing instrument by transaction ID dated so and so, loose check number favoring
penalty and dismissal.
Dismissal. In fact, there was no show cause notice issued.
For what, sir?
Second show cause notice was not issued.
Where is the order of the dismissal authority?
Order of dismissal, your lordship will get at page 73 minutes.
73.
3 minutes, yes.
Where is your reply?
Sorry.
Where is your reply to
I'm
the?
sorry.
It starts at 70.
No, 70 minutes. I'm sorry. It starts at page 70 minutes. Next AM.
Where is the reply to the findings of the inquiry officer?
No, show cause notice itself. Second show cause notice itself was not given. Illa. There is no reference to that also in the impugned order of dismissal.
Appellate authority, you raised this ground in the appeal?
That was not specifically raised.
Criminal case acquitted, huh?
Acquitted.
Where is the order of acquittal?
I have produced it along with the memo. 2/11/2022 I have produced it. In fact, all the transactions were pursuant to the authorization given by the manager. He was also arraigned as an accused. He got the proceedings quashed before this honorable court on the ground that it was not brought to his notice.
Yes, sir. ಇದು ಇವತ್ತು ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿರೋದಲ್ಲ, ಮೂರನೇ ಸರಿ ಬರ್ತಾ ಇರೋದು.
Second notice is that second notice is not issued after the
ಮ್ಯಾಟರ್ ಹೇಳಿದ್ದು ಮೂರನೇ ಸರಿ, ಸೆಕೆಂಡ್ ನೋಟಿಸ್. I will not grant time.
Kindly pass over. I will go through his record, sir. I'm the proxy.
Proxy?
Narayan Yaji is on record. He is SVH.
Oh, sorry. Sorry, I'll take it at 2:30 sharp.
Kindly put on Monday.
No.
Okay. Please, I will go through his record.
2016 matter. You want to go through, you go through.
I go through his
Otherwise,
record,
the petition will go through. Yes.
I will go through his records.
Yes. I am not granting time in old matters.
Bless.
As I am myself not convinced to pass an order today. Yes. 2:30 correct agi.
Please.
For the petitioner. Appointment of the Asha worker Muladi.
Appointment of?
Asha worker Muladi.
Asha worker. ಏನು ಆಸೆ ನಿಮ್ಗೆ? ಯಾರಿಗೆ ಮಾಡಿದ್ದಾರೆ ಈಗ?
6 and 7 Muladi.
Police client?
They are not eligible Muladi.
Not eligible.
Please, as per guidelines Muladi.
Why?
Muladi, the minimum age of the candidate is 25 years.
Minimum age?
Minimum age. Maximum 45 years. Sixth respondent 18 years. Seventh respondent 24 years.
Oh. Seventh respondent ಎಷ್ಟು?
24.
24. Where are the rules?
Annexure A Muladi guidelines.
Page?
Page 10 Muladi.
ಏನಿದು?
Type copy Muladi page Muladi.
ಆಶಾಗಳನ್ನು ಆಯ್ಕೆ ಮಾಡುವ ಮಾರ್ಗಸೂಚಿ. ಸದರಿ ಗ್ರಾಮದ ಸ್ಥಳೀಯ ನಿವಾಸಿಯಾಗಿದ್ದು 25ರಿಂದ 45 ವಯಸ್ಸಿನ ಮಹಿಳೆಗೆ ಆದ್ಯತೆ ನೀಡುವ. ಪರಿಣಾಮಕಾರಿ ಸಮಯ ಕೌಶಲ್ಯ ಉತ್ತಮ ನಾಯಕತ್ವ ಅದೆಲ್ಲ ಏನಿಲ್ಲಲ್ಲ? ಓನ್ಲಿ ಫಸ್ಟ್ ಕ್ಲಾಸ್.
Petitioner is my lord, the married woman, my lord, the 38 years at the time of
ಯಾರು petitioner?
petitioner
ಈಗ 2015 ಇಂದ ಪೆಂಡಿಂಗ್ ಇದೆ.
pending.
ಈಗ ಎಷ್ಟಾಗಿದೆ ವಯಸ್ಸು?
ಈಗ my lord 46.
46.
46.
ಇನ್ನೊಂದು 5 ವರ್ಷ ಇದ್ರೆ ರಿಟೈರ್ಮೆಂಟ್ ಏಜ್ ಬಂದಿರೋದು.
There was an interim
The
order.
most it is the recommendations only.
What recommendations?
No, no. Where my lords page. My
What
lords,
recommendations?
recommendation my lords by the panchayati members to the district health welfare officer.
Oh.
And ultimately still
ಈಗ
it is
ಬೇರೆ
pending.
ಸೆಲೆಕ್ಷನ್ ಪ್ರೋಸೆಸ್ ಏನಿದೆ ಆಶಾ ವರ್ಕರ್ಸ್?
It is stay has been granted by this court.
ಹಾ,
They are not able to move my lords. Let them decide the
ಗ್ರಾಂಟೆಡ್.
yes.
Stay granted.
ಅಂದ್ರೆ ಏನೂ ಆಗಿಲ್ಲ ಈಗ.
Entire resolution was stayed. Resolution by the Gram Panchayat
8
members.
ವರ್ಷದಿಂದ ಏನೂ ಆಗಿಲ್ಲ. ನೀವು ಮೂವ್ ಮಾಡಲ್ಲ, ನೀವು ಮೂವ್ ಮಾಡಲ್ಲ.
So let
5 ನಿಮಿಷದ ಕೆಲಸ ಇದು. 5-minute job.
it is listed in the B group my lords. Many times it is listed.
That's precisely why I'm getting it listed. in
Yes,
such
yes,
matters.
absolutely. Let the appointing authority may decide on the looking into the notifications. Either he is eligible or my eligible or someone who are the
Fifth
applicants.
respondent without following the guidelines, my lord, this so much of to pass a resolution.
We'll see. But you are admittedly on the 18,
Please,
ಒಬ್ರು 18, ಒಬ್ರು 24.
Annexure G, my lord, the produced documents.
Page.
Page, my lord, the 22.
mine 7.
Annexure
Annexure G, my lord.
SLC.
It's a Muscat. Date of birth, my lord, 2/2/1998.
ನಿಮ್ದು ಎಲ್ಲಿದೆ?
My lord, annexure E, my lord.
ಇವ್ರದ್ದು?
Annexure G and my lord, the J.
So it's admitted fact. One is who is 18?
18 is my lord, the sixth respondent.
7th?
Seventh respondent, my lord, the
24.
24 years.
At the relevant point in time.
Please,
You were 38.
38 years.
ಈಗ they have become 38 and you have become 48. Yes.
My lord, the one more thing is my lord, they are not a married woman. My lord, the petitioner is
Married
only
woman ಅಷ್ಟೇ, women's.
woman. My lord, the petitioner is a married woman.
ಹಾ.
My lord, the first preference given to the my lord, the married woman. As per guidelines.
The petitioner. Anything ಕೊಡ್ಲಿ?
Please.
ಇನ್ನೇನಾದ್ರು ಉಂಟಾ?
No, no. Only it is only a resolution passed by the members of the Gram Panchayat, where the recommendations, those who are all the applicants, where my lords, the respond number 6 and 7 are eligible candidates. Kindly may look into the facts and lords decide. Where that is only the recommend, where there is no such an order as such. Kindly see my lord.
ಸೆಲೆಕ್ಟ್ ಮಾಡಿರೋದು ಯಾವುದು?
ಇನ್ನು ಯಾರು ಮಾಡಿಲ್ಲ.
There is a resolution.
Annexure N, my lord, page
N.
31.
51.
31, my lord.
31.
Type copy page 34.
34.
Who is the appointing authority now?
Respondent number 5,
5, my lord.
our served and unrepresented.
Respond Taluk Panch Health Officer 4.
We have issued the guidelines to the Panchayat, your lordship.
Who issued the notification for appointment?
Second respondent.
Second respondent.
Project director.
Project.
Yes.
Director.
Annexure A and B are the directions, your lordship, to the respondent number
petitioner.
5. May I submit, your lordship, one more thing?
Yes.
As per the guidelines, your lordship, age can be relaxed, your lordship, if the
ಯಾಕೆ ಮತ್ತೆ ಯಾರು ಬೇಕಾದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ.
in some
ಎಲ್ಲಿದೆ ರಿಲ್ಯಾಕ್ಸೇಷನ್? ಎಲ್ಲಿದೆ
produce ಮಾಡಿಲ್ಲ ಅವ್ರ guidelines ಇಲ್ಲಿ
ರಿಲ್ಯಾಕ್ಸೇಷನ್? ಎಲ್ಲಿದೆ?
ಪ್ಲೀಸ್, your lordship,
ಕೊಡಿ, ನಿಮ್ ಫೈಲ್ ಇದ್ರೆ ಕೊಡಿ.
ಇದ್ರ age and education criteria can be relaxed, your lordship. And
ಅಷ್ಟೇ ಹೇಳ್ಬಿಟ್ರಲ್ಲ. If no suitable woman is available.
please,
ನಿಮ್ಗೆ ಹಂಗೆ ಬಿಟ್ಬಿಟ್ರೆ ಎಲ್ಲ ರಿಲ್ಯಾಕ್ಸ್ ಮಾಡ್ಬಿಡ್ತೀರಾ. ಅದಕ್ಕೆ ರೈಡರ್. ಎಸ್ ಸರ್, ಅಷ್ಟೇ.
Wait a minute. When so far as respondent number, I am appearing for the respondent number 7. That is.
ಅಂದ್ರೆ you are appearing for 24 years.
Yes, sir. I am
18.
eligible.
18 served unrepresented.
Only 6.
18 ಯಾರು?
6. Respond number 6.
ಅದೇ ಅವರು ಸರ್ವ್ಡ್.
ಅಲ್ಲಿ ಹೌದು.
18, my lord, the
Third, my lords.
served and unrepresented.
Thank you. Irli. ಎಲ್ಲಿದೆ ಮೇಡಮ್ ಇದು?
Please,
ರೂರಲ್ ಆಶಾ, ಅರ್ಬನ್ ಆಶಾ ಎರಡಿದೆಯಾ?
madam.
ಇಲ್ಲ ಇದು
Only
ಇದು
one
ಗೊತ್ತು
copy.
ಇಲ್ಲಿದೆ. ಬಟ್ ಈ ಏಜ್ ಕ್ರೈಟೀರಿಯಾ ಇಲ್ಲಿದೆ.
Please.
Criteria for selection. Thank you. Yes. Disposal ಗೆ help ಆಗುತ್ತೆ. The petitioner is before this court calling in question a resolution which seeks to recommend the appointment of 6th and 7th respondent as Asha workers in which village? Savadi village,
Savadi.
Gadag Taluk. Alla, Round Taluk, Gadag district. Heard so and so. Facts in brief, germane, are as follows. Asha workers were sought to be appointed in the precincts, PRECINTS, precincts of the Gram Panchayat. In furtherance whereof, the second respondent, project director of the National Rural Welfare Services, notifies certain guidelines for appointment of the aforesaid workers. Pursuant to the notification of the said guidelines, the respective Gram Panchayat issued certain further guidelines seeking for appointment of Asha workers. The issue in the list revolves around the claim of the petitioner and respondent 6 and 7, all of whom, finding themselves eligible pursuant to the notification, applied for the post of Asha worker in the aforesaid village. After the process of selection, it transpires that the Gram Panchayat resolves to recommend the names of the 6th and 7th respondents to be appointed as Asha workers. The recommendation has landed the petitioner at the doors of this court, calling in question the said resolution which recommends the appointment. The learned counsel, Dharwad, representing the petitioners, would vehemently contend that even the recommendation of 6th and 7th respondents is contrary to the guidelines issued by the state for the purpose of notification, which clearly depicts that the selection criteria for appointment of the workers should be between 25 to 45 years, apart from the fact that they should be married. The ones who are now sought to be selected by the resolution/recommendation are 18 years and 24 years respectively, which according to the learned counsel is erroneous. The learned counsel Anand R. Kolli, representing the 7th respondent, would however seek to defend the action on the score that it is only a recommendation and the direction be issued to the second respondent or the 4th respondent, as the case would be, to consider in terms of the guidelines. The learned HCGP would also seek to defend the action of recommending 6th and 7th respondents on the score that the guidelines permit relaxation of age and educational qualification. Therefore, would seek dismissal of the petition. I have given my anxious response. The afore narrated facts are not in dispute. The guidelines notified, since the issue revolves around the selection criteria for the post of Asha worker in the village aforesaid, I deem it appropriate to notice the criteria for selection. It reads as follows. The criteria for selection would be that the Asha must be a woman resident of a slum or vulnerable cluster belonging to that particular vulnerable group and has to be identified for selection. She should be married or a widow or a lady divorced or separated, and preferably in the age group of 25 to 45. No doubt the educational qualification, no doubt the educational qualification age criteria as submitted by the learned HCGP can be relaxed it cannot be a norm. It can only be when there is no suitable woman with the qualification available in the area among that particular group. The petitioner and the sixth and seventh respondents apply to the post of Asha in Savadi village, Round Taluk, Gadag district, coming within the precincts of the Gram Panchayat, so and so Gram Panchayat. The recommendation is made by the Panchayat to select respondent 6 and 7. Respondent 6 and 7 admittedly are 18 years and 24 years of age at the time when the recommendation was made. The petitioner was 38 years old and married. The clause as quoted herein above would clearly indicate that preference should be given to married women and between the age 25 to 45. Relaxation is available only if no qualified woman is available for selection. The petitioner is at all times was available. Therefore, it is ununderstandable as to how the Gram Panchayat could have recommended the names of 6th and 7th respondent to be appointed to the post of Asha. As admittedly they did not come within the tenor of the criteria for selection noted herein above. Therefore, on this short ground and admitted so that the 7th, 6th and 7th respondents are at the relevant point in time, 18 and 24 years of age and were not married.
No,
and
I am
the,
married.
Seventh one is married. And of age, though the 7th respondent was married and not the 6th, the issue boils down to a direction to the respondent, second respondent. Issue boils down to a direction to the Gram Panchayat to redo the exercise of recommendation of 6th and 7th respondents and include and consider the name of the petitioner as well to the post of Asha as at the relevant point in time, Asha worker. At the relevant point in time, she was eligible on all fours FOURS. The criteria for selection. For the aforesaid reasons, the following order. The petition is allowed in part. The so and so stands quashed. The Gram Panchayat.
Saudi,
Which respondent?
fifth respondent.
The 4th and 5th respondent shall now reconsider the applications of the petitioner, 6th and 7th respondent, bearing in mind the observations made in the course of the order. The outer limit for such reconsideration and the necessary action is 3 months from the date of receipt of the copy of the order, if not earlier.
So far age is concerned, but now 46 years for the petitioner.
The candidature of the petitioner cannot now be turned down on the score that she is overage, as at the relevant point in time. At the relevant point in time, she was of age, and the 6th and 7th respondents were underaged. Yes.
Film 11, Shivraj Siballaki.
Matter, my lord, pertains to audit of accounts of cooperative society. Petitioner is a agriculture credit cooperative society. My lord, the petitioner has resolved, my lord, appointing one of the chartered accountant, Tippeswamy, as their my lord, auditor. For the
challenge
Lord, annexure A, my lord.
What is annexure A?
My lord, my audit for the year 2016-17 has been held as void because, my lord, I have not done the audit from the chartered accountant, my lord, whom I had appointed for earliest point of time in the general body meeting.
You are the?
But I'm the petitioner, my lord, cooperative society.
You are the CEO of PCRD.
Yes, Agriculture Credit Cooperative Society.
Primary Agriculture Cooperative.
But during general body meeting,
sir.
At page number 14, my lord, operative portion, Adesha, lordship gets it.
ಸನ್ನದ್ದು ಲೆಕ್ಕ ನಿರ್ವಹಿಸಿಕೊಂಡು ಕರ್ನಾಟಕ ಸಹಕಾರ.
But the chartered accountant which we, my lord, was appointed during general body meeting, but he refused, my lord. Thereafter, my lord, we have held a special general body meeting. There another chartered accountant from the panel itself was appointed.
Where is it? Where do you get all that?
My lord, lordship, annexure E, page
Page.
number 18.
Page?
18. Married, madam. Son 15-16 ಸಾಲು ಮತ್ತು 16-17 ಸಾಲು.
ವಿಶೇಷ ಸರ್ವಸಾಧಾರಣ ಸಭೆ.
ಜಿ ತಿಪ್ಪೆ ಇವರನ್ನು ವಾರ್ಷಿಕ ಮಹಾಸಭೆ ನೇಮಕ ಮಾಡಿಕೊಂಡಿದ್ದು, ಆದರೆ ಅವರು ಲಿಖಿತವಾಗಿ ನಿರಾಕರಿಸಿದ ಕಾರಣ 21-7-2017 ಕೈಗೊಂಡ ನಮ್ಮ ಸಂಘದ
ಲಿಖಿತವಾಗಿ ನಿರಾಕರಣೆ ಎಲ್ಲಿದೆ?
Lord, page number 17, my lords.
ಲಿಖಿತವಾದ ನಿರಾಕರಣೆ.
Please, ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಮ್ಮಲ್ಲಿ ಕೆಲಸದ ಒತ್ತಡ ಹೆಚ್ಚಾಗಿದ್ದು ಹಾಗೂ ಸಿಬ್ಬಂದಿಯ ಕೊರತೆ ಇದ್ದು.
ಇವರು ಪ್ಯಾನೆಲ್ ಇದ್ದಾರೆ ಅಂತ ಎಲ್ಲಿದೆ?
My lord, it's not disputed, my lords.
Please, Your Lordship, may I submit, Your Lordship?
ಹೇಳಿ.
The so-called special general body meeting, Your Lordship, which was held on 21/7/2017, Your Lordship, that has been communicated to the respondents, Your Lordship, on 5/8/2016, Your Lordship. That too after initiation of these annexure A and B, Your Lordship. And
ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿದೆಯಲ್ಲ?
ಅಲ್ಲ ಎಲ್ಲ ಮುಗಿದ್ಮೇಲೆ ಇದು ಇಶ್ಯೂ ಆದ್ಮೇಲೆ ಆಗಿದೆ. And Your
ಡಾಕ್ಯುಮೆಂಟ್
Lordship,
ಇದೆಯಲ್ಲ?
and section 63(2), Your Lordship, specifically.
That chartered accountant is also from the panel?
Please, Your Lordship.
Then what is your problem?
ಇದರಲ್ಲಿ ಇಲ್ಲ ಅಂತ ನಮ್ಮವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ, but
ಇಲ್ಲ, that's wrong. My lord, in the endorsement, they don't say that.
Then what's the problem?
they have not recommended in the earlier general body meeting, Your Lordship. And this special general body meeting is, Your Lordship, it's all concocted according to my instructions, Your
What is
Lordship,
concocted?
to support their thing, Your Lordship, support their act, Your Lordship.
There is no dispute that the next man who has audited is also in the panel. Finish.
ಅಲ್ಲ ಇದು meeting, and they have not sent the proceedings, Your Lordship, only the
Where are the proceedings, ಇದರದ್ದು?
proceedings ಕಳಿಸ್ಲಿಲ್ಲ.
But this is the annexure E, my lord, this is the proceedings. Annexure E, my
ಮುಂಚೆ
lord.
ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ದೀರಾ ಯಾವ್ದಾರು? ಇದೇನಾ? ಅಲ್ಲ ಯಾವ್ದು ಹಾಕಿದ್ದೀರಾ?
But that is different, my lord. Only, my lord, to show, it's a settled principle of law, my lord, that the choice of the auditor, my lord, is
From the
within.
panel ಇರ್ಬೇಕಷ್ಟೇ.
Panel
You
ಅಷ್ಟೇ.
can't bring in
That's
anybody
that's
from
the-
outside. That's all.
That's the only thing.
63(2).
They cannot say, my lord, that-
63(2), madam.
Please, Your Lordship.
Yes, madam.
ಅಲ್ಲಲ್ಲಿ, the
63(2)
auditor,
is interpreted. Come to page 34. 63(2) provided so and so.
please, Your Lordship.
The auditor is not qualified is not your ground, except saying that he cannot be, you are not made aware of the fact that there is change in auditor.
Yes, Your Lordship, and that resolution is not passed in the general body meeting, Your Lordship, that's what.
But annexure B, my lord, is the endorsement where they say that I have to get a re-audit done from the particular chartered accountant.
Why?
Who has been selected in
Because,
the
my
general
lord,
body meeting, Your Lordship.
Where is the, why did you change? Other ಒತ್ತಡ ಇದೆ ಅಂತ ಹೇಳಿದಾರಲ್ಲ.
ಅಲ್ಲ, and they ought to
Well,
have
now, my
taken
lord,
the
they say
permission from.
that I have to get it done from the particular auditors, re-audited. Annexure B, my lord, is the. Annexure A, my lord, where they hold that my audit is in.
Tippeswamy was chosen.
Please,
He declined.
he declined.
Next, the man.
Srinivas Dotihal, my lord, we appointed in special general body.
Special general body ಇಷ್ಟೇನಾ?
ಅಷ್ಟೇ.
Proceedings, they are not.
Complete proceeding ಎಲ್ಲಿದೆ?
ಇಲ್ಲ.
But I can get the proceedings.
ಅಲ್ಲ ಯಾಕೆ ಕರಿಬೇಕಾಯ್ತು, ಯಾಕೆ ಇದು ಮಾಡಿದ್ರಿ? ಆಡಿಟ್ ಮಾಡದೆ ಹೋದ್ರೆ then you will proceed against the society.
They ought to have taken the permission from the
Of whose permission?
authorities, Your Lordship.
Lord, now,
ಅಲ್ಲ, director.
but now no misappropriation is found, well, nothing is found. Section 63, my lord, where re-audit can be ordered at my lord 63, section 63, clause 10. If the result of the audit held under section 1 discloses any defects in the working of the society, the board shall take step to rectify the defects and remedy the irregularities.
So what?
My lord, clause 13, my lord, where re-audit can be ordered. If it appears to the state government or an application by cooperative society or otherwise that it is necessary or expedient to re-audit the accounts of the society, the state government may by an order provide for such re-audit and the provision of this act, and the rules applicable to the audit shall also apply to such re-audit. The result of the audit shall be incorporated by cooperative society in the next audit report to be issued.
Only if it is misappropriation or
Further,
embezzlement.
my lord, provided that such re-audit shall be ordered only when there is a prima facie case of fraud or misappropriation or embezzlement of funds.
So there is no finding to
No,
that
no,
effect.
no, not at all.
That is not the order also, except
No,
saying
Your
that re-audit is not done.
Three matters are there were similar. Tippeswamy, same chartered accountant, next matter also he has refused.
Still more matter, yeah.
Are the connected matters? Totally three matters.
We'll finish all three, yes.
We are only
But
on
if
the
they
point
refuse,
that
my
Your
lord, we
Lordship-
don't have any other option.
The petitioner, same order, the repeat, tag ಮಾಡ್ಬೋಣ ಎಲ್ಲ ಅದರ?
Please, it's tagged.
Already tagged.
ಹೌದು.
The petitioners in all these cases is the society, the primary agriculture credit cooperative society. They are at the doors of this court calling in question an order dated 18/5/2018 and 25/5/2018 by which the audit that is been executed to be conducted by a particular auditor has been found fault with, and the re-audit is directed by a particular chartered accountant.
Please.
Heard so and so. Facts in brief germane are as follows. The petitioner society, here not refer to this as petitioner. The petitioner in its general body meeting held on 29/6/2016 resolved to appoint one J. Tippeswamy as chartered accountant to undertake the task of auditing of the account for the year 2016-17. The chartered accountant is said to have expressed his inability to conduct the auditing owing to his busy schedule. The petitioner then appears to have called for a
Special general.
general body meeting and resolved to appoint Srinivas
Dotihal.
Srinivas S.
Dotihal.
Srinivas S. Dotihal as the chartered accountant who conducts the audit and submits the report. The first, who has now passed this order?
Respondent 2.
The second respondent finds fault with the action of the society in getting the audit conducted by a person other than whom was authorized by the annual general body meeting held for the year 2016-17. It is this that has driven the petitioners in all these cases to this court in the subject petition. The learned counsel appearing for the petitioner Shivraj Bellakki takes this court through section 63 of the Karnataka Cooperative Societies Act 1959, hereinafter referred to as the Act for short, to contend that a direction to get the accounts re-audited by the state can come about only in terms of the Act. There is no allegation of falsification of records, misappropriation or otherwise for the state to direct conduct of a re-audit in a routine manner that is now directed. The learned counsel would submit that if the chartered accountant to whom the work of undertaking auditing was entrusted was not willing to undertake the audit, the society is left with no choice but to get it re-audited. It is his emphatic submission that the person who has now audited the account also is from the panel approved by the state. The learned HCGP would, however, defend the action of the impugned orders on the score that there is no proceeding produced with regard to the special general body meeting, as the name was decided earlier by the annual general body that could not have been tweaked or tinkered by the special general body except in accordance with law. She would seek dismissal of the petition on this score as the entire narration is concocted. I have given my answer. Therefore, narrated facts are not in dispute. The issue revolves around a narrow compass, as it concerns the auditing of a society at whose hands is the question. The auditing of the petitioner society was resolved to be handed over to one J. Tippeswamy pursuant to an annual general body meeting for the account for the financial year 2016-17. J. Tippeswamy declines to accept the offer owing to his heavy work. The where is that communication? Yes, it's here. The communication to the society by the auditor chosen in the annual general body meeting reads as follows, page. A special general body meeting is called immediately thereafter, which resolves to appoint the person who has now audited. The special general body resolution reads as follows, page 18. Pursuant to the resolution, the audit accounts are audited and it is submitted to the state. It is then the impugned order comes about. The impugned order dated 18/5/2018 reads as follows. The consequential order to the impugned order reads as follows, page. The impugned order dated 18/5/2018 declines to accept the report of the auditor, and the consequential order dated 25/5/2018 directs a re-audit at the hands of a particular auditor. In the considered view of this court, both are erroneous. Both are legally untenable. What is deployed in 18/5/2018 is section 63(1), and what is directed for a re-audit is under section 63(2). Therefore, I deem it appropriate to notice the aforesaid provisions. Section 63 reads as follows. Section 63 deals with audit, inspection and surcharge on a society. Subclause 13 assumes significance. It ಹೇಳಿದ್ದೀನಿ already. ಪೂರ್ತಿ ಕೋಟ್ ಮಾಡ್ಬಿಡಿ. Subsection 13 of section 63 assumes certain significance for the reason that re-audit can be ordered only if the allegation is of misappropriation or embezzlement of funds which has not been detected properly by the auditor. It is not the case of the state that there has been misappropriation of funds in the case at hand. All that the state alleges is change of the auditor without it being placed before the annual general body. It is an admitted fact that the auditor now who has audited the society is also from the panel that finds approval from the hands of the state. In that light, no fault can be found with the society getting it audited from the from Srinivas S. Dhutihal, owing to the unavoidable circumstance of J. Tippeswamy denying it. Both of them are in the panel. The order is not in the violation of section 6. Sorry, the order directing an re-audit to be conducted by the hands of a particular auditor runs foul of subsection 13 of section 63 as observed here in above. For the aforesaid reasons, the following are allowed quashed. Next.
The second matter.
ಏನು ಬೇರೆ ಇದೆಯಪ್ಪ ಅದು?
ಅದರಲ್ಲೇ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್.
ಮೂರು ಸೇರಿ ಅದನ್ನೇ.
ಥರ್ಡ್ ಒನ್ ಮಲಾಡ್ ಸೇಮ್ ತಿಪ್ಪೇಸ್ವಾಮಿ. ಸೆಕೆಂಡ್ ಒನ್ BV Sintri ಅಂತ ಫಸ್ಟ್. BV Sintri. That's the
ಬಟ್ ಧೂತಿಯಾಳ್ ಇಸ್ ಕಾಮನ್ ಇನ್
ಧೂತಿಯಾಳ್.
ಅದೊಂದು ತಿಪ್ಪೇಸ್ವಾಮಿ ತೆಗೆದು ಅದನ್ನ ಬರ್ಕೊಡಿ. ಅದ್ರಲ್ಲಿ ಇರುತ್ತೆ ನೋಡಿ ಮೇಡಮ್. ಏನ್ ಹೆಸರು? BV Sintri ಅಂತ ಬರ್ಕೊಂಡಿ. Replace Tippeswamy Sintri ಬೇರೆ ಅಲ್ಲ. ಅದು ಪ್ಯಾನಲ್ ಏನೋ?
Third, yes, panel.
Yes.
ಧೂತಿಯಾಳ್ same.
All three allowed quashed. Next.
Film 12, Ganapati M. Bhatt, Sharmila M. Patil, MB Hireman.
Kindly pass on notice. He head up in the other court.
Held up in the other court. Yes. What's the matter?
I correspond number 2.
E-auction.
Yes.
Not called in question the e-auction. They have not called in question the e-auction. They have only called in question the communication. Let's intimidate the bank. They have sought information with regard to the auction.
Sale agogidya?
Yes. Sale certificate issued in the year 2019 in favor of me. In turn, I have sold the property to some other person. They have not been impleted.
In turn, dismissal bit ಬೇರೆ ಏನು ಇಲ್ಲ ಇದರಲ್ಲಿ. Yes. Anything else? ಅಷ್ಟೇ ಅಲ್ಲ?
Yes, please. I correspond number 2.
ನೀವು ಯಾರಿಗೆ ಮೇಡಮ್?
I am for respondent number 2. The petitioner may be directed to collect the money from the bank. The auction amount is spending and it is more than 1 crore.
ಅದು ಬೇಡವಾ?
Password.
We'll direct them to forfeit that also. If you're not interested in that. The property is sold for a song, is it?
Password.
ಅದ್ಬಿಟ್ಟು ಏನು ಹೇಳ್ತಾನೆ ಇಲ್ಲ. Yes. Pass over. Yes.
Bill number 30, VP Vadvi, take card note.
Tomorrow, my lord.
Lordships may kindly recollect, matter was parted, taken to Bangalore also.
Taken to Bangalore, I bought it back, sir.
ಅಲ್ಲೂ ಬರ್ಲಿಲ್ಲ ಅವರು, ಹಿಂಗೆ ಆಗ್ಬಿಡ್ತು.
ಅವ್ರು ಬರೋದೇ ಇಲ್ಲ. Yes. Is covered by my order.
Tomorrow morning.
United Nations, sir. Where is my order?
What we found was.
ಇದೆಯಲ್ಲ ಕೊಡಿ.
I'm not sure, my lord, if this.
ಅಲ್ಲ ಇದಲ್ಲ. There is one more written in Bangalore. This is on a different footing. Anyway, what are your grounds?
Sunday accommodation.
Lord, annexure A, B and D, my lord, are the complaints by the agents of the insurance company that petitioner is harassing them and is not making the payments. And my lord, these complaints, your lordships may kindly turn to my synopsis, my lord, which I have filed. Annexure A, my lord, is dated 10/8/2015, page number 14. This, my lord, pertains to incidents that are said to have occurred between 2007 to 2008. And complaint, my lord, is lodged in 2015. Then annexure B, my lord, again is dated 17/12/2015. This also, my lord, pertains to incidents said to have occurred in 2006 to 2010. Then annexure D, my lord, is dated 17/12/2015. Allegations, my lord, pertain to the incidents said to have occurred in 2010. So, my lord, there is annexure D, my lord, it is not dated.
Who has registered complaint? No aggrieved person?
No aggrieved person. And no allegation of financial irregularity or financial loss.
So removal from service, huh?
Yes, my lord, it's been, there is no allegation of illegal gratification or unlawful enrichment. And only procedural lapses, my lord, which occurred due to the computerization and digitization of records, and no complaints by the insured. My lord, insured have not said we have not received the sum. Insured, my lord, had instructed this petitioner to pay it to the agents. Accordingly, he has paid it to the agents. Agents having received the money on behalf of the insured.
There is no complaint.
There is no complaint by them. And charges, my lord, charges 3, 4 and 6 are not proved. A petitioner is exonerated. Charge number 1, my lord, page number 35, your lordships may kindly see. Page number 35, my lord, is the charges. Page number 36, nally issue number 1, my lord, is there. While working as administrative officer in DO Hospet so-and-so, has misutilized an amount of 124 on 3 occasions by debiting cash deposits control of Miss India Sugars Refineries without a request from the client by issuing checks in the name of Agent Jairam. My lord, the allegation is that I have issued check to the agent and not to the insured. It is seen that the refund vouchers were generated in the name of India Sugars while the checks were issued favoring the agent. This issue, my lord, is proved. For this, my lord, there is no complaint by India Sugars, and the agent who has received the money, my lord, cannot complain. And all the checks, my lord, your lordships may kindly note, are signed by 2 of them, petitioner and another official of the insurance company. My lord, your lordships may kindly turn to one official, my lord, is a minor punishment is imposed to him.
What is that?
On page number 120, 2 increments cut ಮಾಡಿದ್ದಾರೆ.
ನಿಮಗೆ ಮಾತ್ರ ರಿಮೂವ್ ಅಲ್ಲ?
ನಮಗೆ terminated from service, and another signatory, my lord, is not even called, no charge sheet against him.
Signatories to the
My lord, there are 2 or 3 checks. There are 2 signatories to the check on all occasions. Petitioner is common, and other 2, my lord, have also joined in signing the checks.
ಅವ್ರಿಗೆ ಏನ್ ಮಾಡಿ?
ಒಬ್ಬರಿಗೆ 2 increments reduced, ಒಬ್ಬರಿಗೆ ಕರೀಲಿ ಇಲ್ಲ ಏನಿಲ್ಲ, despite my request, my lord, that he must be summoned as a witness at least. He's not called, and he's protected, is my allegation. And when there are allegations, my lord, that the checks are signed by 2 officials, and in all 3 officials, my lord, a joint inquiry, my lord, should have been held. Merely, my lord, putting the blame on only the petitioner.
Where are the regulations? United Indians Conduct, Discipline and Appeal Regulations.
So CDA rules, wherein the
Conduct, Discipline and Appeal and the CDA.
Please.
Yes.
The penalties ಅಲ್ಲಿ major and minor.
That time aware. I wanted to know the procedure. It's all right. It's the same as in the banks.
Yes.
Yes. Yes, sir.
Kindly, one day accommodation.
Huh?
One day.
No.
Hospital.
Hospital. ಯಾಕೆ?
Senior. Angiography ಅನ್ನೋ.
ಯಾರಿಗೆ?
Senior.
ಯಾರು?
Hack ಮಠ.
ಕಾಯಕ್ ಮಠ. ಇದು ಸ್ವಲ್ಪ ನಾಳೆ?
ನಾಳೆ.
Tomorrow fresh matters. Heard the Learned Counsel Harsh Desai appearing for the petitioner. List tomorrow, not beyond tomorrow. ಏನಿಲ್ಲ ಇದರಲ್ಲಿ. It should go lock, stock, barrel.
The one is this delay, my lord, in lodging the complaint, and no complaint by the aggrieved. Third one, my lord, is no signature.
Delay vitiates the proceedings. No complaint by the aggrieved. There should be an aggrieved person for complaint. All right. Sometimes it mean record scan. 3, having imposed no penalty on one, minor penalty on one. How can a major penalty be imposed on this? On all 3 counts it should go unless you answer properly. Tomorrow morning I'll pass the order.
Last, my lord, submission alternative excessive punishment.
Excessive punishment and ವಾಪಸ್ ಕಳಿಸಬೇಕು ಬೇಡ. Yes.
40, SB Dodgwad, Shivraj P. Mutho.
21 ಇಂದ ಪರವಾಗಿಲ್ಲ, ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಿದ್ರೆ ಕೊಡ್ತೀವಿ. 20 ವರೆಗೂ ಕೇಳಬೇಡಿ.
No, ready.
ರೆಡಿನಾ?
Please. May I request?
ಅವ್ರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಯಾಕೆ?
Senior daughter's marriage. My senior daughter's marriage is on 15th.
Senior.
Shivraj Mudhol.
Oh, correct. Yes. ಯಾವತ್?
24th.
24th ಮ್ಯಾರೇಜ್?
15th ಇದೆ ಮೇಡಮ್.
15th ಮ್ಯಾರೇಜ್ ಇದ್ರೆ 24th ವರೆಗೆ ಹಾಕ್ಬೇಕು. List on 21st.
Great.
Yes. Next.
Number 15, Shubhendu A. Akalwadi.
Transfer.
Appearing for the petitioner, my lords. This is a case of transfer, my lords, wherein the petitioner was found as excessive teacher in the respondent number 2 institution.
Where are you transferred, sir?
My lords, at page number 7, my lords, the transfer order is. The school, my lords, R2 has given an objection statement, my lords, saying that he was the only person who was teaching the mathematics and he is not the excessive teacher. And the deputy director has not considered the objections, my lords. I pass
He's
on.
been
We are not sought for this thing.
Not sought.
No, because we are
Not sought ಅಂದ್ರೆ 4 ವರ್ಷ ಆಯ್ತು ಈಗ.
we come on record subsequently.
He's been redeployed to the scarcity of the teachers, your lordship, to the school where the scarcity of teachers are there, your lordship. He is access teacher, your lordship, as per the survey made by the
principal did not like his face. ಆಗೋದಿದ್ರಲ್ಲಿ ಏನಿಲ್ಲ.
That's not the matter.
You don't like the face, so take him as access teacher, send him out.
Access teachers cannot be paid, your lordship, for sitting and.
Correct. He is not in access. The only person teaching mathematics ಅಂತ ಇದೆಯಲ್ಲ.
He is
44, my lords, the R2 has given objection statement, my lords, wherein at 45 page.
ಹಿಂಗೆ ಈ ಪಾಲಿಟಿಕ್ಸ್ ಅಲ್ಲೇ you will destroy education. Yes. ಅದು elementary education.
Annexure F he has challenged, your lordship. Page 72, your lordship.
ಎಲ್ಲಿದೆ? Page 44 ಅಲ್ಲಿ.
44, my lords, in page number 44, wherein the respondent number 2 institution has given objection statement, my lords.
ಇನ್ನೋರ್ವ ಶಿಕ್ಷಕರು ನಮ್ಮ ಪ್ರೌಢಶಾಲೆಯಲ್ಲಿ ಸಹ ಶಿಕ್ಷಕರಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿರುವ ಹಾಗೂ ಗಣಿತ ವಿಷಯವನ್ನು ಬೋಧಿಸುತ್ತಿರುವ ಮಲ್ಲೇಶ್ ನಾಯಕ್
Please petition, my lords.
ಇವರನ್ನು ಸಹ ಹೆಚ್ಚುವರಿ ಎಂದು ಗುರುತಿಸಿದ ಶಿಕ್ಷಕರನ್ನು ನಮ್ಮ ಶಾಲೆಯಲ್ಲಿ ಇದುವರೆಗೂ ಹೆಚ್ಚಿನ ಕಾರ್ಯಭಾರ ಇರುವುದರಿಂದ ಇವರ ಸೇವೆ ಅವಶ್ಯಕತೆ ಇರುವುದು ಶಿಕ್ಷಕರ ಗಣಿತ ವಿಷಯವನ್ನು ತೆಗೆದುಕೊಂಡು ಜೊತೆಗೆ ವಿಜ್ಞಾನ ವಿಷಯವನ್ನು ಸಹ ಬೋಧಿಸಿರುತ್ತಾರೆ. ವಾಟ್ ಮೇಡಮ್?
And he has already joined your lordship.
Already
to the
joined, get him
school.
back.
In fact, my lords, in fact,
There, it will be affected to that school,
ಏನಾಗಿದೆ
your
ಈಗ?
lordship. ಇಲ್ಲಿ.
ಇಲ್ಲೇನಾಗಿದೆ?
He has accepted and.
It is all right. ಇಲ್ಲೇನಾಗಿದೆ ಈಗ? ಇಲ್ಲಿ ಡರ್ತ್ ಆಗ್ಲಿಲ್ವಾ ಈಗ? ಏನ್ ಬೇಕಾದ್ರೂ ಮಾಡೋದು.
In fact, my lords, on
What
27.
have you done after this communication? 16/8/2019 communication. Have you reviewed the order?
Redeployed your lordship. Directly redeployed your lordship. ಅವನು redeploy ಮಾಡಿದ್ವಿ.
Redeploy ಮಾಡಿದ್ದೀರಾ ವಾಪಸ್ ಈಗ? ಎಲ್ಲಿಗೆ?
ಅಲ್ಲಲ್ಲ ಅಲ್ಲಿಗೆನೆ ವಾಪಸ್ ಕಮ್ಯುನಿಕೇಶನ್ ಮೇಲೆ
ಅಲ್ಲ ಈ ಕಮ್ಯುನಿಕೇಶನ್ ಮೇಲೆ ವಾಪಸ್ ಏನ್ ರೀಡಿಪ್ಲೈ ಮಾಡಿಲ್ವಲ್ಲ?
ಇಲ್ಲ ನೋ.
ಮತ್ತೆ ಅಲ್ಲಿ ಸ್ಟೂಡೆಂಟ್ಸ್ ಏನಾಗ್ಬೇಕು? ಈಸ್ ಟೀಚಿಂಗ್ ಬೋತ್ ಮ್ಯಾಥ್ ಅಂಡ್ ಸೈನ್ಸ್ ಅಂತಿದೆ ಇಲ್ಲಿ. ಪ್ರೌಢಶಾಲೆಗ?
Please.
ಹಾ.
Even
High school.
in fact, order was passed on 15th, my lords, August 15th. The
No, your
public
lordship.
holiday order was passed, my lords.
No, your
Finding-
lordship. That is on 25/8/19, your lordship.
Government works
Allala.
24/7.
Annexure A6, your lordship. May I kindly take your lordship to annexure A6?
Government works 24/7, 365 days. ಏನ್ ಮಾತಾಡ?
No, your lordship. It's not. It's just they have mistaken your lordship. It's on 25/8, your lordship. It's not 15/8.
Even if.
ಅಲ್ಲ 25 ರೀ.
The petitioner is before this court calling in question. Yen pleading is what is
No, miss, the
calling in question
subsequently
an order passed by the third respondent, commissioner and appellate authority.
That was the reason we have filed amendment, my lords.
Where is the amendment?
IA1 is filed on 13/1/2020.
The petitioner is before this court calling in question an order dated 15/2/2021. Heard so and so. The facts in brief germane are as follows. The issue revolves around a narrow compass, as the challenge is to the deployment of the petitioner from A institution to B institution on the score that he has become an excess teacher in A institution. The deployment is accepted and the petitioner is now working in B institution. The A institution in the case at hand is yaudadu? Institution yaudadu?
Management of Sri Jagadguru, respondent number 2, my lords.
The A institution in the case at hand is the second respondent. ಈಗ ಎಲ್ಲಿಗೆ ಡಿಪ್ಲಾಯ್ ಮಾಡಿದ್ದಾರೆ?
ಚನ್ನಬಸವೇಶ್ವರ ಪ್ರೌಢಶಾಲೆ ಅರ್ಲಿಕಟ್ಟಿ, my lords. Page number 7 may kindly be taken.
And the B institution is ಚನ್ನಬಸವೇಶ್ವರ
ಪ್ರೌಢಶಾಲೆ
ಅರಳಿಕಟ್ಟಿ. The petitioner is a government teacher, is not in dispute. He joined service on 5/6/2013. On 25/8/2019, he comes to be declared as an excess teacher. The declaration comes about in terms of which annexure?
Annexure A, my lords.
Page
6, my lords.
Declaration comes about. ಎಲ್ಲಿದ್ದಾರೆ ಇದು? ಬಾ ಯಾರು ಕಾಣೋದಿಲ್ಲ. The order of the notice reads as follows. The notice is dated 15th August 2019. Pursuant to the declaration of the petitioner being an excess teacher, a consequential order comes to be passed on 24/10/2019, deploying the petitioner from School A to School B. The petitioner joins the School B and is said to be functioning there, said to be teaching in the said institution. At the time when the petitioner was declared to be an excess teacher, the institution is said to have replied to the notice dated 15/8/2019 by observing that the petitioner is not an excess teacher. He is the only teacher teaching mathematics in the high school, and due to the dearth of staff, he is also teaching science subjects. Page
45 minutes.
45 alla 45
Please, 45.
44 45. The communication to the Second respondent reads as follows. This is issued immediately on the notice being issued to the petitioner to the institution, a institution, on 15/8/2019. No action is taken. He is deployed. The petitioner goes and reports to B institution and is said to be working in the said institution. The resultant action is that the students at the A institution are now put to jeopardy due to the inaction on the part of the state.
Even now the vacancy is there, my lords, in mathematics subject.
Another?
A institution, and now also there is a vacancy in.
So and so. The learned counsel for the petitioner places on record the vacancy position for the year 24-25 in the A institution, which clearly shows that there is nobody to teach mathematics, notwithstanding the fact that the students are available in the high school aforequoted. Therefore, the state by a stroke of pen appears to have placed the students in A institution at jeopardy for reasons not tenable in law. In that light, despite the vehement opposition of the learned HCGP, I deem it appropriate to pass the following order. The petition is allowed in part. The order of deployment so and so stands quashed. The respondent state shall now reconsider the deployment of the petitioner owing to of the petitioner, bring about the student strength in A institution and B institution, and place the petitioner back in A institution if there is work in real time and there is no teacher to teach mathematics subject, all of which shall be complied with within 3 months from the date of receipt of the copy of the order. Ordered accordingly.
PN30, CS Patil.
Petitioner was working as Group D employee without promotion for 40 years, my lord.
40 years?
Yes. And the corporation has recommended that
corporation.
Annexure B, page 12 is the recommendation by the corporation to refix the pension by giving additional increments in terms of the notification.
So without increments, he retired.
Yes, yes. Without increments,
Regular
without
employee,
promotions, without
regular employee.
Yes, Group D employee.
Oh, this is that circular.
Yes.
Please, your lordship, he has already reached the highest mark, your lordship.
Illa promotion kodi.
Alla.
Super.
And the recommendation,
Which
corporation
post?
should
Which
have,
post, sir?
no, your lordship,
Which post, sir?
Group D employee. Attender.
D, Group D in the end the ಮೇಲೆ.
Please.
Attender ಆದ್ಮೇಲೆ promotion ಏನಿದೆ?
SDC.
SDC ಗೆ ಎಷ್ಟು ವರ್ಷ ಇರಬೇಕು?
15 years.
15 years. SDC ಆದ್ಮೇಲೆ FDC ಅಂತೂ ಆಗಲ್ಲ. SDC ರಿಟೈರ್ ಆಗಬೇಕು. So one promotion. Okay.
Your lordship, as per last time I have given the
Parole ಹೇಳಿ circular.
As per that circular, your lordship, the corporation ought to have taken the permission from the government, your lordship.
For
They
what?
should have.
For appointment?
No, your lordship, for this second and third increments, your lordship.
Second and third?
Increments, your lordship.
ಕೊಟ್ಟಿದ್ದಾರೆ increment?
Increment ಕೊಟ್ಟಿಲ್ಲ. That is why we have approached this.
ಯಾವ permission ಕೇಳಬೇಕು ಕೊಡದೇ ಇರೋದಕ್ಕೆ?
The government permission.
Corporation has to take
Yes, your lordship.
Permission
from the government, your lordship. And we have stated, we have communicated to the corporation, your lordship.
Saying what?
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶ್ರೀ ಶಿವಪ್ಪ
ತಾವು 25 ವರ್ಷಗಳ 2ನೇ 30 ವರ್ಷಗಳ 3ನೇ ಹೆಚ್ಚುವರಿ ವೇತನ ಬಡ್ತಿಗಳನ್ನು
ಮಂಜೂರಿಸುವ ಬಗ್ಗೆ ಸರ್ಕಾರದಿಂದ ಅನುಮೋದನೆ
ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಿರುವ
ಮುಂದಿನ
ಸೂಕ್ತ
ಕ್ರಮ ಕೈಗೊಳ್ಳಲ್ಲ. They have not sent any recommendation.
They have sent, my lord, page 12, annexure B. They have recommended. Over 2020 itself they have done. Page 12.
Page 12.
In terms of this recommendation, my pension has to be refixed.
When do you take action, madam? ಇಲ್ಲರ ಕಾಸ್ಟ್ ಎಲ್ಲ ಇಂಪೋಸ್ ಮಾಡ್ಬಿಡ್ತೀವಿ. Interest cost.
He has already reached the position.
Told you don't play with the lives of retired people. Never ever do that.
Time frame may be given, Your Lordship. Will consult.
Yes. The petitioner is before this court seeking a calling in question an order dated 14/9/2020 passed by the third respondent. ಏನಿದು?
My lord, they said that I have already attained superannuation.
No. Who is the third respondent? Assistant Director for Pension. ಅಂತದ್ದು ಯಾರಿದ್ದಾರೆ?
ನಿರ್ದೇಶಕರು, page 14, my lord, annexure D. This is the impugned order. PF office. ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಪಿಂಚಣಿ.
ಅದು ಇಲಾಖೆ ಸರ್.
Yes.
All right. Calling in question, communication dated 14/9/2020 passed by the third respondent, holding that the petitioner is not entitled to an increment for time, is not entitled to an increment for completion of 25 years and 30 years of service, as the petitioner has 30 years of service. Facts in brief germane are as heard sounds of facts in brief germane are as follows. The petitioner is now 65 years old. He was employed as a group, he was
Attender, my lord, group D employee.
Attender alva. He was employed as an attender, a group D post in which municipal corporation?
Hubli Dharwad.
Hubli Dharwad Municipal Corporation. The employment was for a period of 40 years. After completion of 40 years of service, attains the age of superannuation. He joins as a group D employee, retires as a group D employee without an increment and promotion to the next higher post. For a group D employee, the next higher post is the second division assistant, and he would retire as a second division assistant and not beyond that. The petitioner, on attaining the age of superannuation, stakes a claim that he was not, though he was eligible for increments for completion of 20 years of service and 30 years of service respectively, is not paid, and his pension is not accordingly worked. This representation results in a recommendation from the hands of the Hubli Dharwad Municipal Corporation, and the recommendation has resulted in the impugned order denying or declining to accept the claim of the petitioner on the score that he has already retired on attaining the age of superannuation. It is this that has brought the petitioner to the doors of this court in the subject petition. The learned counsel appearing for the petitioner submits that the petitioner, after completion of 40 years, has not got his due either promotion or in additional increments for completion of requisite period of service at intermittent intervals. He would submit that it is a matter of right to the petitioner to get promotion or increments for non-grant of promotion. The learned counsel appearing for the Hubli Dharwad Municipal Corporation submits that the case of the petitioner, owing to his representation, had been recommended, which has been rejected by the state. The learned HCGP now submits that the petitioner is not entitled to the increment of 25 years and 30 years had he had reached the maximum scale in the post of the attender. Therefore, the action of the state cannot be found fault with. I have given my so. The aforenarrated facts are not in dispute. As observed here and above, the issue revolves around a narrow compass as to whether the employee is entitled to the increment after completion of 25 years and 30 years of service. The additional increment that is granted to the employees who would not get promotion or owing to circumstances where an employee cannot be promoted is by way of grant of those increments which are time-bound scales, time-bound increment, which is for 25 years and 30 years of completion of service. Admittedly, the petitioner takes birth in service as an attender and retires as an attender. He was entitled to be promoted to the post of second division assistant. In that second division assistant, promotion was never granted to him owing to manifold circumstances, but the petitioner was always entitled to the increment in lieu of such promotion that he was to be granted, as he had completed 25 years of service and 30 years of service. Service increments that are granted from time to time has nothing to do with the increment that is granted for 25 years or 30 years of service. They stand on a different footing. Merely because an employee reaches the pay scale, reaches the maximum increments that can be granted in the normal course, would not mean that the petitioner, but that an employee would not be entitled for 25 years or 30 years of additional increments that are granted. The term itself is additional increments. They are not service increments that the employee is entitled to. Therefore, the employee is entitled. The representation was made by the petitioner, which comes to be recommended by the corporation.
Page 12, my lord. Annexure B.
The recommendation reads as follows. The recommendation had complete clarity as to what is the increment that the petitioner was entitled to and that had to be granted. The state, as is known for its, the state rejects the same by the impugned order without any rhyme or reason. The petitioner, the increments as observed herein above is granted to take away or ward off stagnation in service. The stagnation has happened in the case at hand, as the petitioner for 40 years remains in the same cadre. Therefore, the petition deserves to succeed with the following order. Writ petition is allowed. So and so stands quashed. The respondent state is directed to reconsider the recommendation so made by the corporation and accordingly pass necessary orders refixing the pension of the petitioner. The excise shall be pension of the petitioner, bearing in mind the observations made in the course of the order. The excise shall get concluded within 3 months from the date of receipt of the copy of this order, if not earlier. Ordered accordingly.
Highly obliged.
Yes, next.
Highly obliged.
Satish K, Raj Vimudha.
Lord, I appear for the petitioners. Lord,
sir.
Lord, the past service rendered in the erstwhile corporation is required to be counted for the purpose of Lord pension.
Which
Lord, all
corporation,
these,
sir?
Lord, we were working in Lord Power Corporation as assistant engineer. While working in the Power Corporation, Lord, we applied for the post of assistant executive engineer in KPTCL. Lord, we were selected and appointed, Lord, in the KPTCL. We resigned in, Lord, Power Corporation.
Exactly.
Joined in, Lord.
Things tell me. Did you apply to the Power Corporation first?
Yes. Yes, my lord.
Second.
Yes.
Was it a technical resignation under Rule 252 of the KCSR? Is an order passed to that effect?
Kindly come.
Or analogous rules under the KPC?
59. Yes, my lord. Yes, my lord. Exactly, my lord. That is.
Yes, sir.
250 technical resignation, my lord. No, my lord. That is not the dispute. My lord. 2 ವರ್ಷ 3 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ.
ಅಷ್ಟೇನಾ?
Lord, the regulation, my lord. Page 58. Page.
ಕಂಪ್ಲೀಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡು ಆಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡಿ. ಎಲ್ಲ ಪಾರ್ಕ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೀನಿ.
All right, yes.
Lord, only one submission, my lord. No, my lord, that is not under dispute now.
1 minute. Objections ಹಾಕಿದೆ.
ಹಾಕ್ತೀವಿ ಸರ್. 24.
ಯಾಕೆ ನಾನೇ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ನೋಡಿಲ್ವಾ?
ನೋಡಿ.
ಮತ್ತೆ ಯಾಕೆ ಹಾಕಿಲ್ಲ? Your right to file objection stands forfeited. I made an observation. You can't take it lightly, sir.
No.
We'll allow the petition straight away. Objections. What is your submission? ಹೇಳಿ.
No, madam.
Yes, sir. Order ನೋಡಿದಿರಾ ಅಲ್ವಾ ಒಳ್ಳೆದು?
Notice.
ಕೊಡಿ ಅವ್ರಿಗೆ.
Within no. On 21th, not without fail, I will.
Order ನೋಡಿ, sir.
I'll see. It is.
I'll impose costs now. I'll take it on Friday. Friday morning, if the objections are not there, I'll allow the petition. Yes, list on Friday as a last list court on so and so had passed the following order. The right to file objections ought to have been directed to be forfeited, but as the last chance, list the matter on 14th in the fresh matters. Next.
Number 18, Krishna, Jay Gachima.
Yesterday's matter, my lord, sir. This is the judgment of the division bench. Section 16 appeal, my lord, not by the children. Here in this case, what has happened is the Tahsildar, the assistant commissioner maintenance.
The appeal not maintainable.
Yes. So now the maintenance tribunal passes an order to mutate the name of the senior citizen. That was questioned before the deputy commissioner appellate tribunal. He partly remands the matter only to the extent of.
Now two things.
Yes.
Mutation entries cannot be the subject matter before the assistant
Yes, yes.
commissioner. All right. Now the deputy commissioner, on the orders of the assistant commissioner filed by the respondent there, has remitted the matter back. So two illegalities. One, mutation cannot be, and the order of the deputy commissioner is non-est in the IF law because of this. Now we will leave you to work out your remedies in accordance with law.
Yes. Yeah.
But in the division bench,
Yes.
This was my order.
Please.
This went on my order.
Yes.
I had directed that everybody should go there, and I had quashed the assistant commissioner's order also.
Yes.
Because the very senior citizen is not there. Division bench has found fault with that.
Yes.
Saying that assistant commissioner's order should not have been quashed. So now here, he has remitted the matter back to the assistant commissioner. We will have to hold that mutation entries cannot be gone into, and then allow you to work out your remedies.
Now pursuant to this, my lord, mutation entry has been effected in favor of this. That has to go.
Which one? Pursuant to the order
Order of
assistant
AC.
commissioner. That is illegal.
Yes. Per se illegal, my lord, that has to go. Only regarding maintenance, my lord, both of us can modify it.
Maintenance ಎಷ್ಟು ಕೊಡ್ತಾ ಇದ್ದಾರೆ?
No, he's not paying, my lord.
ಅಲ್ಲ ಅವ್ರು ಆರ್ಡರ್ ಮಾಡ್ಲಿಲ್ಲ AC.
ನಾನು ಮಾಡ್ತೀನಿ. ಇಲ್ಲೇ ಮಾಡಿ ಕಳಿಸ್ಬಿಡ್ತೀನಿ, ಅಲ್ಲಿಗೆ ಎಲ್ಲೂ ಹೋಗೋದೇ ಇಲ್ಲ.
The other respondent.
My lord,
10,000 under the act, I will direct.
ಅಲ್ಲ ಇಬ್ರಿಗೂ ಮಾಡಿ ಸರ್. ನನಗೆ ಮತ್ತೆ the brother is there. He, my lord, does not represent. He instigates the mother. I am taking care of mother for last 40 years.
that is
Stays
not
in
the-
Pune, my lord,
that-
and
that is not the case.
Who is the brother?
ಅಲ್ಲ ಆ ಬ್ರದರ್ ಮತ್ತೆ ಉಳಿದ ಸಿಸ್ಟರ್ಸ್ ದೇ ಆರ್ ಟೇಕಿಂಗ್ ಕೇರ್ ಆಫ್ ದ ಮದರ್.
ಅಲ್ಲ ಅದು ಹಾಕಿಸಿದಾರೆ ಆ ರಿಪೋರ್ಟ್.
ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. ಜಾಯಿಂಟ್ ಅಂಡ್ ಸೆವರಲ್ ಅಂತ ಮಾಡಕ್ಕಾಗಲ್ಲ. 10,000 ರೂಪಾಯಿ ಅಂಡರ್ ದಿ ಆಕ್ಟ್ they are entitled to you pay.
ಅಲ್ಲ ನಾವು since it is
ಏನ್
only
ಮಾಡ್ತಿದ್ದೀರಾ ನೀವು?
I am an agriculturist, my lord. There was a division between myself, brother and father in the
Agriculture ಏನು?
ಅಲ್ಲ sugar cane.
Sugar cane.
2 acres, 37 guntas of
Till
sugar cane
what
land.
extent I am suffering, my
He,
lord?
my lord, owns 2 acres of, my lord, NA plots, my lord. He has sold it off. 1 acre in my land also he got after, my lord, selling his property. Then now, my lord, he gets the mother to file this petition.
Like till what
ಅದಕ್ಕೆ
extent
ಇವನ್
mother
ನೋಡ್
is
ಐ ಆಮ್ ರೆಡಿ ಟು ಪೇ ಮೇಂಟೆನೆನ್ಸ್. ಅವ್ರಿಗೆ ನನಗೆ ಇಬ್ರಿಗೂ ಡೈರೆಕ್ಟ್ ಮಾಡಿ ನೋಡಿ ವಿ ಆರ್ ರೆಡಿ. ನನ್ನ ಹತ್ರ ಇವತ್ತಿಗೆ ಇರೋ 2 acre 37 ಗುಂಟಾಸ್ ಮಾತ್ರ.
ತೊಂದರೆ ಇಲ್ಲ. 10 ಗುಂಟೆ ಶುಗರ್ ಕೇನ್ ಕೊಟ್ಬಿಡಿ 10,000 ರೂಪಾಯಿ.
Therefore, I'll pay maintenance. I am not
Father's ultimate.
mother. I am ready to pay. In fact, that's what I stated. 40 years she was with me.
ಜಾಸ್ತಿ ಮಾಡಬೇಕು.
40 years she was with me. I have been taking care of her throughout.
No problem. Yes.
Please.
The petitioner is before this court seeking the following prayer. Heard so and so. Facts in brief germane are as follows. The parties to the list are
Respondent number 1 is the mother.
First respondent is the mother of the petitioner.
And respondent number 2.
Mother of the petitioner and the second respondent. The petitioner and the second respondent are brothers. It transpires that the mother knocks at the doors of the assistant commissioner, invoking his jurisdiction under the Senior Citizen So-and-so Act. The assistant commissioner has, by the order impugned,
should be page 14.
set aside the mutation entries standing in favor of the petitioner in excise of his jurisdiction.
He did not set aside. He said enter the name of mother also.
Sorry. The mother also.
Page 16, my lords.
So the assistant commissioner directs entry of the name of the mother first respondent as well along with the petitioner in the mutation entry of the property as described in the order. This order is called in question by the present petitioner before the appellate authority, the deputy commissioner. The deputy commissioner exercising his jurisdiction under the act entertains the appeal, sets aside the order of the assistant commissioner and remits the matter back to the hands of the.
He doesn't do that. He keeps the appeal pending.
Huh.
He directs the assistant commissioner to decide only regarding, my lord, maintenance, keeping open this question of mutation
Deputy
pending.
commissioner, on the challenge made to the order of the assistant commissioner, the deputy commissioner keeps the appeal in abeyance, directs the assistant commissioner to decide about the maintenance. The pending is no. They said the execution of the said direction is said to be pending even as on date. The issue now would be whether the assistant commissioner has a right under the act to tweak the mutation entries in favor of the parties, and the deputy commissioner on the challenge could have entertained the appeal or otherwise. Both these issues need not detain this court for long or delve deep into the matter. A coordinate bench of this court in writ petition so-and-so Surat has held as follows.
Para 13, my lords, to the operative portion.
Para 11 to issue ಏನು
13 ನಲ್ಲಿ mutation entries.
ಎರಡು ಬಂದ್ಬಿಡ್ಲಿ ಬಿಡಿ.
ಎರಡು
Para 11 to
yes
end. The issue whether mutation entries could have been gone into by the assistant commissioner invoking under the act therefore is held to be illegal. The action of the assistant commissioner in the case at hand is to tweak the mutation entries by making an entry of the first respondent's name. Therefore, the said direction falls foul of what the coordinate benches held in the aforequoted order. Thus, the order of the assistant commissioner becomes illegal on the face of it. The second issue is whether the petitioner could have preferred an appeal before the deputy commissioner claiming to be aggrieved. Claiming to be aggrieved by the order of by the aforesaid order of the assistant commissioner. The issue again need not detain this court for long or delve deep into the matter. The division bench, in terms of its order dated 20th December 2024, has held that that no other person other than the senior citizen who had knocked at the doors of the assistant commissioner under the act has a right to prefer an appeal. Therefore, the very right of the petitioner to prefer an appeal gets obliterated, and the appeal so preferred becomes non-est in the eye of law. The situation now is the mutation entries have been changed pursuant to the mutation entries tweaked pursuant to the order of the assistant commissioner, and the order of the deputy commissioner directing the assistant commissioner to the order of the deputy commissioner to keep the appeal in abeyance and direct the assistant commissioner to consider maintenance is rendered illegal by the observations of the division bench. The division bench has held as follows, para 38 till the end.
12 to 38.
12 to 38, or the second issue, para 12 to 38. In that light, the issue now would be whether the mother would be entitled to maintenance, which has now been directed to be decided by the assistant commissioner. Therefore, in the light of the aforesaid illegalities in both the orders of the assistant commissioner and the deputy commissioner, invoking assistant commissioner, in terms of the act, I deem it appropriate to direct the petitioner to pay the first petitioner, the first respondent, maintenance at rupees 10,000 per month with liberty to the first respondent to seek its enhancement only if need arises before the assistant commissioner. In that light, both the proceedings of the assistant commissioner and the deputy commissioner being illegal are to be obliterated. For the aforesaid reasons, the following order. The writ petition is allowed. The order of the assistant commissioner stands quashed. The mutation entries that are made pursuant to the order of the assistant commissioner the mutation entries that stood prior to the order of the assistant commissioner shall be restored, and the order of the deputy commissioner stands quashed.
Only one clarification regarding maintenance, I'm ready to pay. Mother sought maintenance from both of us. In fact, the other son is represented by my learned friend. Both of us may be directed to pay 5,000 each because yes.
My lords, till date, my lords, the
She prays for maintenance from both of us. My lords may kindly see page number 15.
No problem.
So it can't be saddled only against me is my humble submission.
Property ಕೊಟ್ಟರೆ ಯಾರಿಗೆ?
ಅಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಮರೋಡ್ ಅವನಿಗೂ ಕೊಟ್ಟು ಅವ್ನು ಮಾರ್ಕೊಂಡು ಹೋಗಿದ್ದಾನೆ. 4 acres ಮರೋಡ್ he sold it off, then ಮರೋಡ್ took 1 acre in my land. If I may, that's why I did not go into those facts. I straight away said I'm ready to pay maintenance. Let him pay morood 5,000 out of it.
What has happened is, my lords, I'm staying in the same property which the petitioner is staying. They are not even giving the water, my lords. And my second son is staying in.
Mother ಕೊಡ್ತಾರೆ.
No, I'm not.
That's all.
Quarreling about paying to the mother.
The mother, first respondent, is entitled to maintenance at rupees 10,000. At rupees 10,000 as the act. 10,000 from the hands of the petitioner, month on month. Yes.
Please. Page 15 may kindly be seen for a moment.
Sugar canes. 2 acres 36 crores.
Or 35 plots ಮಾಡ್ಕೊಂಡು ಮಾರಿ 2 crore rupees he has earned from the same property by purchasing it.
That is questioned in the civil court, my lords.
ಅಲ್ಲ ಅದಕ್ಕೆ all these things are there. I'm not saying
Mother ಕೊಡ್ತಾರೆ sir.
Please.
Mother ಕೊಡಕ್ಕೆ should not.
No.
Parents ನೋಡ್ಕೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ.
Please.
PS come to.
Taken time to file a objection statement, or may I seek permission to
19.
19. Yes, of compassion apartment, my lord, I had taken time to file certain objections, my lord. May I seek permission to, my lord, place on record? Lord, I had taken time to file objection statement. May I seek permission to place on record, my lord, the statement?
What's the matter?
Lord, now only I have received the objections, my lord. Kindly have it on 14th.
What's the matter
14th.
on
14th.
19th? Yes, next. Objection, registry lakpadi. Next.
Bill number 20, SM Karnataka. Sir.
Just now the yes, some of the copies, my lord.
Same, 19th. File it in the registry. Please.
Number 21, CV Angdi.
This is rejecting my application to enter my name pursuant to the execution of and registration of the sale deed. But respondent number 2 has.
ಮಾಡಿದ್ರಾ?
Please, Lords. Illa.
ಯಾವಾಗ?
Illa. Lords, the section 28 and 29 provides us, Lords, if there is a registered document, Lords, as per section 128, Lords.
So sale certificate ಆಗಿರುತ್ತೆ ಇದು.
ಆಗಿದೆ. ಅಲ್ಲ ಮಾಡಬೇಕು. But if any dispute is arises, Lords, then after issuing notice.
Bank ಅಲ್ಲಿ sale cert, he has purchased it in the bank.
ಹೌದು.
If some borrower comes and gives you objections, you can't take all that.
Borrower no. Another bank who has charge over the property. 10 lakhs boja ಇದೆ ಅವರದು. ಎನ್ಕಮರಸ್ ನೋಡೇ ಇಲ್ಲ ಇವರು.
ನೋಡ್ಕೊಂತಾರೆ, don't worry. Yes. They will proceed against him. Why are you bothered about other banks? Fit and come back.
ಅಲ್ಲ ಅದನ್ನ ಮಾಡಕ್ ಬರಲ್ಲ ನಮಗೆ. Court order, because already we have issued endorsement stating that, my lords, as there is a complaint, objection by the, my lords, the another person who has society, my lords, who has loan over that property, and we have asked him, my lords, to get it rectified, and then, my lords, encumbrance clear.
Why are you bothered about others?
ಅಲ್ಲ encumbrance clear ಇಲ್ಲ ಅಂದ್ರೆ, my lords, it will be affect, my lords, both the rights, the right of the, my lords, the petitioner also, and, my lords, the right of the society, which has, my lords, the lien over the property.
So ಈಗ ಏನ್ ಇಂಟ್ರೆಸ್ಟ್ ಕೇಳಿದಿರಾ? ಯಾರಿಂದ ಇಂಟ್ರೆಸ್ಟ್?
No, I'm seeking entry of my name.
Entry.
Respondent number 2, my lord. In fact, my lord, the
ಸರ್ವೇದಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಬೇಕು ಅಷ್ಟೇ.
The property was
records entry ಆಗಬೇಕು.
City survey.
The name of the petitioner requires to be.
Before whom entry?
Respondent number 2, my lord.
South Indian Bank.
No, my lord.
ಯಾವ serial number, madam? Dharwad.
I think it's earlier file, my lord, sir.
Madam.
My lord, here the petitioner, my lord, purchased the petition property, my lord, in a public auction uh, conducted, my lord, on 19/4/2022, my lord. And the mortgage deed, my lord, it is produced at Annexure D, my lord. That is the first mortgage deed in chronological sequence, my lord, dated 28.
There is one judgment I have rendered.
Please.
That there other dues of other departments were there that cannot be looked into while directing registration of the sale certificate that is pursuant to the sale. He has purchased it.
He has purchased.
ಅವ್ರಿಗೆ
Auction
ಅಲ್ಲಿದೆ
purchaser.
ಇಲ್ಲಿದೆ ಅಂತ ಅವ್ರಿಗೇನ್ ಗೊತ್ತು?
ಅಲ್ಲ ಅಂದ್ರೆ ಎನ್ಕಂಬರೆನ್ಸ್ ಇತ್ತು ಅದರಲ್ಲಿ.
No,
The
my other
society has given
ಅದಕ್ಕೆ will pass orders on Friday. Cost impose ಮಾಡ್ತೀನಿ on the sub registrar.
ಸಬ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ. ADLR mallards only ADLR has to
ADLR
enter.
100% cost. Yes. Sub registrar ಮಾಡಿದ್ಮೇಲೆ ನಿಮ್ದೇನು?
ಮಾಡಬೇಕಾಗಿತ್ತು. Only mallards as the objections were raised by the person who has interest over the property in question.
No issues. ಅದೇ
129 ದಲ್ಲಿ mallards were given endorsement.
Yes. ADLR cost ಬರ್ತದೆ. Knowing the law, what is his problem? Yes, next.
Lord, this writ petition.
Pollution, yes, sir. Mahesh.
That's I appear for the board, my lords. That's the issue, my lords, is in the narrow compass of whether petitioner would be entitled to get under 2A other category, my lords. My lords, I may request my colleague to pass over, my lords, one note, so that, my lords, there are certain facts which have not been placed on record. It's only a 5-fact, my lords, which I just want to place. That's admittedly, my lords, there was a notification calling for appointment of the post of additional environmental officer, my lords, under which there were two categories. One is called B category, that is bachelors of engineering, or masters category, my lords. The petitioner falls under the bachelors category, and there's only one post of 2A which is being allotted to 2A other category, my lords. Now what happens is, after that is we come out with a merit list. 3 people from this particular category get selected, my lords. One is Mr. Adarsh, who's ranked at serial number 10. And then, my lords, he gets appointment letter in the general merit, which my lords would get at annexure C1. Then, my lords, there's another candidate by name Veena Kona. That she is under 2A general category. She's ranked at serial number 38 in the merit list. Finally, my lords, is the petitioner who's ranking at 172. Now, my lords, the confusion here is that, my lords, which the petitioner seeks to agitate before this court, which, my lords, I want to clarify. The eligibility is a question before, my lords. The previous order of this court, my lords, seeks to direct the board to consider his representation. My lords may see the order, my lords, of the annexure E, my lords, which my lords would get at page number 41, and I would take my lords to
what is that you have filed now?
Look, I've just filed a list of dates and my points of argument, my lords, that I'll be in a position to, if in case, my lords, the audio loses, my points would not be missed out.
Yes.
That's my
objections. You have filed your objections.
Yes, ma'am.
objection. I just want to bring my lords
Lord,
notice.
Yes.
At
Exactly,
page
this
number
is opposite to what they have contended before a previous writ petition.
No, it is not so. I will show it on the record, my lords.
That mistake Mahesh will not do. So don't
Well,
worry, we'll see. Yes. Friday.
Let's have it on Monday or Tuesday, my lords.
Monday. Yes.
Yes,
Monday fresh. Next.
Yes.
Lord, let them give a copy, my lords.
ಕೊಟ್ಟಿಲ್ಲ ಕಾಪಿ.
ಕೊಟ್ಟಿಲ್ಲ, ನಮ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ, ಏನೋ ಕಾನ್ಫಿಡೆನ್ಷಿಯಲ್ ಅಂತ ಹೇಳಿದ್ರು.
ಅಲ್ಲ, list of dates ಮಾತ್ರ confidential ಅಲ್ಲ. There's another thing which is given to my lords, which is confidential. It's an internal record. The list of dates we'll give it to them.
Yes.
Filing the memo for retirement.
Memo for retirement. Who has come on record?
23.
Your Lordship, I undertake to file wakalat. The SB Habali Council name may be for the petition.
Our name shall be deleted.
Application for vacating stays pending.
Hello, what's
Case of the construction that was made by the respondent authority was high-handedly taken over by the petitioner during this COVID period. The entire cost of construction was borne out from the government funds. Now he contends that pursuant to the lease that was granted in his favor, he has made up construction of the first floor. Lord, in fact, we have, if your Lordship sees my statement of objection, The work order was issued millets to the KRDCL. KRDCL put up construction of the first floor. He was given millets the permission to start a business. So
What is his claim?
His claim is that a vacant space was given to him under a lease deed. He has put up construction of the ground floor and the first floor according to the case of the petitioner.
Yes, you get ready, Monday I'll take it.
So may I seek on 24th or 25th?
No.
Senior is not well. He has to argue this.
Then why did you file wakalat?
Today itself the
No,
parties are
nothing doing. Yes.
on Monday. Name shall
List
be
on
deleted.
Monday, the fresh matters list. Yes.
Instead of Monday, no, Tuesday.
Tuesday, one more day, yes.
Abhishek,
Stay ತಗೊಂಡ್ಮೇಲೆ vacating stay go ready ಆಗಿರ್ಬೇಕು.
ಇಲ್ಲ ಅವ್ರು they have been making all their efforts to ensure that stay is continued for all.
ಅದಕ್ಕೆ anyway, final effort.
Please.
Yes.
Petitioner is the person with 85%
Yesterday
locomotor
matter,
disability.
Disability. Lord, the initial appointment of the petitioner himself is under the handicapped quota, PWD quota. Lordship kindly peruse page 10.
We'll see. I'll take this tomorrow.
Please.
Tomorrow in the fresh matters list. Yes.
25, Shinande
Take some
Pachapuri,
time. Yes.
Bhushan D. Kulkarni. Shivraj.
Vacating order.
Post of yesterday's matter, my lordship are pleased to hear the post of superintendent of library, my lords of Gram Panchayat, where my lords the petitioner had secured 91%, 17%, 91.17.
Yes, sir.
Please, I have filed my statement.
Provision, second provisional seniority list.
As per eligibility clause, my lords, second PUC they should have secured.
Second provisional seniority list is what
Yes.
your question.
Second provision.
Yes, Shivraj.
Lords, please. As per my submissions, my lords, she does not, my lords, possess the proper
What proper?
certificate, my lords, from
Computer
government-
certificate.
computer certificate.
ಅದು ಗವರ್ಮೆಂಟ್ ಎಲ್ಲ ಬೇಕು ಅಂತ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
Notification alle ide. Notification in lordship may take page 19, my lords, of the memorandum of writ petition, my lords. That is the notification. Annexure B, page 19. Certification course in library nalli ಪ್ರಮಾಣ ಪತ್ರ ಪಡೆದಿರೋ ತಕ್ಕದ್ದು
ಕ್ಲಾಸ್
ಸೆಕೆಂಡ್ ವಿದ್ಯಾರ್ಥಿಯಲ್ಲಿ ನೋಡ್ಸ್ 10 ಶೈಕ್ಷಣಿಕ ವಿದ್ಯಾರ್ಥಿಯಲ್ಲಿ ಕಾಲಮ್ ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ವಿದ್ಯಾರ್ಥಿಯಲ್ಲಿ ದ್ವಿತೀಯ ಪದವಿ ಪೂರ್ಣ ಪರೀಕ್ಷೆ ಉತ್ತೀರ್ಣರಾಗಿದ್ದಾರೆ.
ಸರ್ಟಿಫಿಕೇಟ್ ಕೋರ್ಸ್ ಇನ್ ಲೈಬ್ರರಿ ಸೈನ್ಸ್
ನಲ್ಲಿ
ಪ್ರಮಾಣ ಪತ್ರ ಪಡೆದುಕೊಂಡು ಹಾಗೂ ಕನಿಷ್ಠ 3 ತಿಂಗಳ ಕಂಪ್ಯೂಟರ್ ಕೋರ್ಸ್ ನಲ್ಲಿ ಶಿಕ್ಷಣೇತರ ಆಗಿರ ಏನೋ ಸ್ನಾತಕೇತರ ಆಗಿರ್ಬೇಕಾ ಏನಿದು ಕಾಣದೇ ಇಲ್ಲ.
ಅದು ಚಾಲುಕ್ಯ ಸೈಬರ್ ಟೌನ್ ಕಂಪ್ಯೂಟರ್ ಎಜುಕೇಶನ್ ಸೆಂಟರ್ ಅಲ್ಲಿ 6 months she has conducted that course and certificate that is been. ಅವ್ರು ಹೇಳೋದು ಗವರ್ನಮೆಂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಗವರ್ನಮೆಂಟ್.
At the time of uploading documents, my lords, online application, if I may invite the lordship's attention to page number, my lords, 26.
ಕಿತ್ಕೊಂತ ಇದ್ದೀರಾ? ಸರಿ.
Page 26, my lords. At the time of uploading the document, it says, the prompt says, my lords, certificate from government authority.
Prompt should be looked into or this?
On merit, my lords.
Prompt comes up because of keying in.
Please.
Prompt ಆಗಿ ಹೇಳಿದ್ದೀರಾ? Close ಮಾಡ್ಬೋಣ.
Please.
Yes, the petitioner is before this court calling in question a final select list ಆಗೋಗಿದೆಯಾ?
ಹೌದು.
I have been selected.
ಆದ್ಮೇಲೆ my lords, during pendency of this petition, an appointment order at annexure G was passed. That is also challenged.
Select list dated 6/7/2024 by which respondent are you, Shivraj?
Respondent 2.
Respondent number 2.
By which respondent number 5 is chosen to the post of library supervisor in ಯಾವ ಗ್ರಾಮ ಪಂಚಾಯತ್?
Fourth respondent, my lords,
The fourth
Hanapur.
respondent, Hanapur SP Gram Panchayat. Heard so and so. Facts in brief, germane, are as follows. The second respondent issues a notification for selection of 23 vacant posts of superintendents of library and information sciences in Bagalkot district. The petitioner and the sixth respondent, finding themselves eligible, apply to the said post on 19/10/2023. Pursuant to the process of selection, the fourth respondent notifies a provisional select list on 19/12/2023. The name of the petitioner was not in the said list, but neither the name of this fifth respondent. Both of them, you filed
Fifth
objection.
respondent, my lord,
The petitioner, though the name was not available, did not, though the name was not found, did not file objections. But the fifth respondent filed objections to the provisional select list. The result of the objections was the second provisional select list notified by the fourth respondent, by the fourth respondent. It is then the petitioner wakes up and files objections that her name ought to have been found in the select list, and therefore select list. Non-consideration of the said objection had driven the petitioner to this court in the subject petition. During the pendency of the petition, a final select list is notified by which the fifth respondent comes to be appointed, and therefore an amendment to the petition has come about, raising a challenge to the selection of the fifth respondent. The learned counsel Srinath Pachapure, appearing for the petitioner, would take this court through the provisional select lists to demonstrate. Name the ground.
Not so that the petitioner has secured 91.17%.
That the petitioner is higher in merit, as she has secured 91.17%. 17%, while the selected candidate, the fifth respondent, has secured 89.
89.
Secured 89% in the qualifying examination. And he would contend that the qualifying examination and one more
and not so the certificate course which she has obtained, that is also as per eligibility.
On this score, the learned counsel would seek to contend that the name of the petitioner could not have been removed, ought to have been in the provisional select list, and the selection ought to have been made in favor of the petitioner. The learned counsel for the fifth respondent, the selectee, the appointee, the Shivraj Balloli, would submit that the petitioner, though is found to be more meritorious, the certificate of the computer certificate that was required to be produced is not from a government recognized computer center, but a private computer center. Therefore, the fifth respondent is preferred, and no fault can be found with such preference. The learned counsel, the other respondents would also toe the lines of the counsel Shivraj Balloli, representing the fifth respondent. I have given my so-and-so. The factum of issuance of a notification calling for applications for superintendents of library and information centers in the precincts of the Gram Panchayat is a matter of record. The application by the petitioner and the fifth respondent is also a matter of record. A first provisional select list is notified on 19/12/2023. Both the names of the petitioner and the fifth respondent was not found. The fifth respondent objects to the name of the petitioner not being present in this provisional select list. The petitioner does not. A second provisional select list is notified owing to the objections of the fifth respondent on 11/3/2024, to which the petitioner wakes up and files objections. The result of the objection files the objection. Notwithstanding the objections, the selection is in favor of the fifth respondent, and the fifth respondent is appointed. The core issue now would be whether the selection of the fifth respondent is in tune with law. The notification so issued for appointment and the selection criteria in the said notification is as follows. Clause 10 ನಲ್ಲಿ ಶೈಕ್ಷಣಿಕ ವಿದ್ಯಾರ್ಹತೆ. Clause 10. In terms of the aforequoted eligibility stroke educational qualification, one should have a pass in PUC. Both the fifth respondent and the petitioner have. one should have a certificate course in library sciences. Both the petitioner and the fifth respondent has. One should have 3 months minimum computer course. One should have 3 months, one should have passed 3 months computer course. Both the petitioner and the fifth respondent have. The issue is who should be chosen for selection. In the light of all the criteria of selection being met, both by the petitioner and the fifth respondent, the issue boils down to merit. Admittedly, the petitioner is 91.17% in the qualifying examination, and the petitioner is 89%. When all traits are equal, even or otherwise, it is merit that takes a higher seat, and merit cannot be compromised in any kind of selection. The only reason projected by the respondents, including the selectee, is that the petitioner does not have a pass in computer course in a government recognized institution, as the fifth respondent has a pass in computer course in a government recognized institution, while the petitioner's course is in a private institution. Again, we go back to the educational qualification. The qualification is indicative of the fact that 3 months computer course should be completed. Where it should be completed is what is found in the said notification. Therefore, the petitioner being higher in merit and having a computer course, albeit in a private entity, which does not have the recognition of the state, that by itself cannot deny an appointment to a person who is more meritorious than the fifth respondent. In the aforesaid circumstance, the fifth respondent will have to give way to the petitioner for appointment as a library supervisor. A library superintendent and superintendent at the information center in the Gram Panchayat. In that light, the following order. The petition is allowed, so and so stands quashed. The respondent will now consider the candidature of the petitioner for appointment. Inyaru meritorious ilva?
Yeah. She is the highest.
Merit list prakara they first.
Sorry. They shall consider offering appointment to the petitioner, bearing in mind the observations made in the course of the order. Till so and so. In place of the fifth respondent. The exercise shall be undertaken within 4 weeks from the date of receipt of the copy of this order. Till such time, the service of the fifth respondent shall not be disturbed.
But owing to the pendency of the proceedings, I have not been paid the salaries, my lords, for all the month.
Allon para before the operative portion. The learned counsel Shivraj Baloli submits that owing to the pendency of the petition, the fifth respondent who had been appointed pursuant to the impugned order on 6/7/2024 has not been paid salary. If that be so, the Panchayat,
Respondent number 2 to 5.
The respondents 2 to 5 shall ensure payment of complete salary to the fifth respondent for having worked from 6/7/2024 till the implementation of the order.
Please. Highly obliged.
Yes, next.
2 to 4. Sorry, 2 to 4. Respondent number 2 to 4.
2 to 4. 2 to 4. Yes. 2 to 4. Correct. 5 tane kodbekagida. 2 to 4.
Number 26, Srikanti Patil, KL Patil.
Writ of mandamus, my lord, to consider, my lord, the representation at annexure A and G.
To receive instructions, your lordship, in this matter.
Lord, here, my
At
lord,
the request of the learned HCGP, list on Monday in the fresh matters list. Yes.
One submission. I appear for the bank. From the bank, we have requested the petitioner, bank who is the disbursing authority. We have requested the petitioner to furnish a copy of the pension payment order since it was
that
misplaced.
is already given. That is already given. Annexure A prakara already we have given that.
I will verify.
Monday fresh matters. Yes.
May I request, my lord, on Friday?
Monday. Yes.
27, Ravi Hegde, Prashant Usmani.
Page number 29 is the impugned order.
It's the impugned order, my lords, the calculation has to be redone. There is a mistake. It has to be redone. The gratuity period, my lords, has not been calculated properly. That has to be redone.
We'll close it.
Please.
The petitioner is before this court seeking the following prayer. Heard so and so. Facts in brief germane are as follows. The petitioner comes to be appointed as a driver in the year 1998. On allegation of certain misconduct comes to be dismissed from service. The dismissal is questioned before the labor court. The labor court allows the dispute, directs reinstatement with continuity of service but without back wages. Aggrieved by the said order, the management is before this court in writ petition 146106 of 2020. Then madadru?
Settlement.
The matter was settled before the Lok Adalat by the employee gave up the right for what did he give up?
Back wages and consequential benefits.
Back wages and consequential benefits, and the penalty
of reduction of 3 increments.
Penalty was modified to withholding of 3 increments as agreed. After the
there was continuity of service, my lords. That is
reinstatement with continuity was confirmed.
And but the reinstatement and continuity of service was agreed upon between the parties. The petitioner retires.
Retire. Service ಇದೆ.
Again ಮತ್ತೆ ಬೇಕಾಗಿಲ್ಲ.
No, he is retired.
Gratuity ಕೇಳ್ತಾ ಇದ್ದೀರಾ, ರಿಟೈರ್ಮೆಂಟ್ ಆಗದೆ ಏನು ಮತ್ತೆ?
ಇಲ್ಲ.
The petitioner retires on attaining the age of superannuation. The retirement leads to.
Lord, when he attains the age of 58, this order came to be passed. He has not yet retired.
ಹೌದಾ?
ಹೌದು.
Anyway, so and so. The petitioner retire ಬೇಡ. The petitioner is now, the pay of the petitioner is not refixed owing to the compromise that was.
58 years, my lords, is retirement age. He is born on 1/6/1965. And my lords,
prayer ಗೆ ಅದು ರಿಟೈರ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಕೇಳಕ್ ಸಾಧ್ಯ. Yes, so and so. The petitioner, retirement ಬಗ್ಗೆ ಬರಿಬೇಡಿ. The petitioner is before the court seeking refixation of salary considering the entire service by deducting 3 increments that had to be deducted in terms of the compromise. The issue therefore lies in a narrow compass. The compromise entered into between the petitioner management and the petitioner and respondent management is as follows. Page 26-27. In terms of the compromise, the petitioner was entitled to continuity of service but without back wages. Therefore, continuity of service will be that the salary of the petitioner has to be refixed. The non-refixation would lead to anomaly both in his pay and his pension, both in his pay and his terminal benefits at the time of payment. Therefore, the respondents ought to have reworked with the salary of the petitioner by taking the service rendered throughout and denying 3 increments as was agreed upon in the aforequoted settlement. The learned counsel Prashant Hosmani submits that reasonable time is granted. If reasonable time is granted, the reworking would happen and the anomaly, if any, would be rectified. In the light of the said submission and the afore narrated facts, I deem it appropriate to dispose the petition, directing the respondents to refix the salary of the petitioner owing to the settlement as quoted herein above within 8 weeks from the date of receipt of the copy of this order, if not earlier.
Formally, annexure C may be questioned. Deny ಮಾಡ್ತಾರಲ್ಲ 10
As a matter of form.
Thanks, sir.
As a matter of form, annexure C so and so stands quashed.
Grateful.
Ordered accordingly.
Number 28, Anandar Kolli, Bhushan Kulkarni.
Last occasions, my lords was
Last
directed.
occasions.
Yes, lords. Where my lord, the concerned officer, my lords, is present before the court, who had issued an endorsement dated 31/7.
He has not issued, somebody else had issued, yes.
Already, my lord,
officer ಹೇಳಿ ಯಾರನ್ನೋ ಕರೆಸ್ಬಿಟ್ಟಿದ್ರಿ.
this court, my lords, has already quashed the endorsement of the earlier order dated, my lords, 29/7/2024. Lordships, my lords.
Again, connected matter ಏನು?
Yes, that same, my lords.
Memo for disposal.
Where, my lord, this
What
court
disposal, sir?
in respect of two other employees, my lord, so this court has already quashed.
Yes, madam.
Your Lordship, in another matter, Your Lordship. In another matter, Your Lordship, the court
We'll
has
close
held
it.
that.
Following this, we'll close.
Illa,
Ilva.
one ನಿಮಿಷ, Your Lordship. The same person is involved in the earlier illegalities, Your Lordship, and that has been upheld by the this judgment, Your Lordship, and discipline. Yes, Your Lordship. Disciplinary inquiry has been initiated, Your Lordship.
Is the order back?
No, I am not aware of that.
You become aware, sir.
Yes, this, my lord, this order.
We'll
that-
exchange orders.
And these are the reports, Your Lordship, wherein departmental inquiry
Tuesday,
is.
fresh matters. Next.
Please.
Ramchandra Mani.
One decision of the Lordship Justice M. Shyam Prasad, my lords, on section 18.
Pudi.
Which says about not section 18 and my lords 34 subsection 39.
Yes, Suraj. Sorry.
Lords, I'm sending him, lords.
Oh, electronic transfer. Yes. Tuesday, yes.
Please.
Tomorrow, my lords, if I may request.
Tomorrow?
Please.
Okay, urgent.
Yes, my lords, I mean, there's
one,
been an
one
interim order, my lords, and
one difficulty is this, my lords. Petitioner, she is appointed as now, my lords, by the government to as a chairman to the Sahitya Sammelanam, my lords. Ivattinda, start.
1 minute, 1 minute.
my contention is, my lords,
Again, what's the problem? Tell me.
my lords, the petitioner who is, my lords, appointed as the registrar evaluation
Registrar?
of, my lord, evaluation, my lords, of university. My contention is that, my lords, in light of section 18, she is not eligible. As per section 18, my lords, only, my lords, the officers of case cadre or, my lords, a senior faculty member of an university is up.
She's neither.
She's a, my lords, a teacher of a college, and she now not having, my lords, she not being eligible at all to, my lords, being appointed. Her appointment was rightly withdrawn by the government, my lords, after realizing that she is not eligible.
After 23, my lords, she was appointed. Thereafter, my lords, they passed an order appointing her as a registrar evaluation of Akka Mahadevi University, Bijapur. But that was challenged by another candidate at Bangalore, bench, my lords, where, my lords, the principal bench, my lords, was pleased to grant interim order.
And her appointment
And, my
was
lords, her-
stayed, my lords, only on the ground that, my lords, she is not eligible.
And there, my lords, after hearing, my
Let me
lords.
look into Justice Shyam Prasad's order.
Yes, please. I'll also
Tomorrow.
send him.
Tomorrow, my lords, please.
May I request it, my lords, because for this reason, why is my lords? Now by the government, my lords,
They have been, my
appointed.
lords, they have been
Nothing to do.
taking.
This will tomorrow.
Please. Tomorrow, my lords,
Tomorrow.
please.
Obliged, my lords.
30 Vithalis Tele.
Fresh matters list.
Petitioners further,
Tomorrow, fresh matters.
the petitioners further herein, Lords, filed a application under the Rule 13 of the Bombay Public Trust Act for a change of report acceptance. Lords, in view of change of law, that was transferred to the civil court. Civil court rejected it on the ground that, my lords, by way of will, puja rights and, my lords, property cannot be transferred. And on the ground that there is inordinate delay in moving an application. And that ground, two grounds it dismissed. So far as that, my lords, second ground of a delay, the Supreme Court holds that, my lords, delay could be condoned subject to payment of a cost.
That we'll see. You serve on the respondents.
Please.
Petitioner to serve on the counsels who represented the respondent in the trial proceedings. List on next Wednesday. Yes.
Please.
Number
Next.
31, Prashant Vasmani, Viresh Budhia.
My lords, a matter similar to my lords, fly in the ointment judgment. Lords, our
okay.
students have now been calling the judgment as fly in the ointment judgment. My lords, expression in that judgment, ground rent matter.
In the ointment.
How's the
Can only be mine, yes.
how that can only flow from the law pens of a pen of my lords, my lord. For a similar matter, my lords, now the corporation has made two demands. One, my lords, is for development charges, which is not covered either by my
ಅಲ್ಲ,
lords
ಇದೇನು
or.
urgency ಇದೆಯಾ?
My lords, yes,
Red
there is
mark
an, no,
ಹಾಕ್ಬಿಡ್ತೀನಿ.
there is an acute urgency because, my lords, I have obtained a home loan. Now, my lords, if I don't use that home loan within a
Ask your
stipulated
client to
period,
sit back.
lords, if I don't, my lords, use that amount,
Yeah.
then, my lords, it will, from home loan interest rate, it will, my lords, get converted to commercial interest rate. In fact, there is an interim order in my favor, wherein, my lords, I had submitted, no, but they have not yet issued the permission. They have, in fact, my lords, filed an application for recalling that order. My lords, interim order is, my lords, that I had submitted that whatever the amount decided either by the, my lords, by this court, but I'm ready to pay. But at least let me first start the construction because of this. My lords, but they issue the, my lords, permission. And tomorrow, my lords, if the court says that this is the amount that I have to pay or some any other amount, my lords, I have undertaken that I will pay.
By now, my lords, it
I'm
is
put
no
on
more
terms by this honorable court.
It is no more a question of res integra. As far as, my lords, once your lordship's order was passed, my lord, the legislature, my lords, in wisdom has passed an amendment. It has now been stayed, my lords. Certain portion of that has been stayed, my lords, by the order of the coordinate bench, my lord, and the matter has been reserved for orders. So let the petitioner now pay whatever has been directed to be paid, my lords, in those matters.
Lord, the amount that they are, my lord, now demanding is 5,445 rupees for, my lords, granting me the permission.
It will be subject to outcome, sir.
My lords, that is why, my lords, I had submitted.
Not construction. You
Please.
can't have the cake and eat it too. So you.
No, I have undertaken, my lords, I'll undertake that I will pay the amount, my lords, decided by this court. Or tomorrow, my lords, if the court holds that they don't have the power to collect any amount.
ಯಾವ heads al demand
My lords, may kindly see, my lords, in my writ petition.
Where is my order dated 4/8/2021?
Lords, furnished in on the earlier, my lords, round of hearing.
Impossible impecuniosity. The impugned imports are impossible to be countenanced. Yes. Adel.
My lords, I only got the operative portion without the cost title.
ಅದೇ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಅಲ್ಲೇ ಅದರಲ್ಲೇ
ಇದೆ ಪ್ಲೀಸ್
ಇದೇ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಬೇಕಾಗಿಲ್ಲ.
ಪ್ಲೀಸ್.
Imposition of the impugned imports is impossible to be countenanced. Yes.
Page 31 of my writ petition, my lords, the heads under which they are now claiming.
ಏನೇನದು?
My lords, scrutiny fee 10,000. Then, my lords, no asphalt road 2,30,000. No UGD 89,000. Labor cess 50,000. Dustbin 75,000. Because dustbin.
I'll submit.
I have, my lords, produced the permission copies of my neighbors. There, my lords, none of these heads, my lords, they are charged on none of these heads.
I'll submit once.
ತುಂಬಾ ಗಲೀಜಿದೆ ಅಲ್ಲಿ.
My lords, there are two portions of my demand, my lords. One relates to, my lords, the 5 heads, my lord, under which your lordship's order covers the field. The other one, my lords, the development charges is not a part of the order or the amendment. Lords, the petitioner chooses to buy a site which is absolutely undeveloped. Lord, it is the only a few houses here and there. The roads are not there. Lord, the owner, the developer, my lords, has thrown the baby along with the bathwater and he has escaped. But it is now the corporation to make it humanly habitable.
See, I'll tell you, you can't impose fee. Two things, unless there is a quid pro quo. Fine.
Please, Lord.
And you can't impose fee. Your manil kasa jaasti ide, our manil kasa kammi ide.
Like uniform.
Or he is going to make it more dirty or dirty. It should be uniform.
Uniform. It's uniform. It's uniform.
Dustbin ಬೇರೆಯವರಿಗೆ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ?
ಎಲ್ಲರಿಗೂ ಸ್ವಾಮಿ. Whosoever wants building permission in this undeveloped jungle-like layout, ಎಲ್ಲರಿಗೂ ಹಾಕಿದೀವಿ, and I filed an affidavit before your lordship.
Source of power.
My lord.
Source of power.
There are two things, my lord. One, my lords, is the statutory exercise of power, for which, my lord, your lordship's order holds the field in spite of the amendment. And second one, my lord, your lordships did not take into consideration, my lords, that layout where there is absolutely no development and the corporation.
So that's on a different footing. ಅಲ್ಲೇ ಗ್ರೌಂಡ್ ರೆಂಟ್ ಅದೆಲ್ಲ ಇತ್ತು.
That, my lord, I concede whatever, my lords, is the subject matter of your lordship's order, my lord. That now, my lords, the coordinate bench.
Yeah, which is covered by this order.
My lord,
my lords, scrutiny fee, my lords, labor cess, they can't, my lords, labor cess, my lords have held that upfront they cannot demand. My lords, I have, my lords, also produced the permission copy given to my neighbor. None of all these heads that I have read out, my lords, are all zero. They have not, my lords, asked for any amount. That is why, my lords, once if this matter is settled, I'll pay the amount whatever, my lords, is due and demanded. But let me at least, my lords, start the construction.
I have calculated. I will not trouble my learned senior friend. Lord, he says that everything is zero. Lord, the coordinate bench has passed a detailed order which has been, my lords, passed in very many other orders, the interim orders. But certain heads, there's an absolute stay.
ಇದಾದ್ಮೇಲೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಬಂದ್ಮೇಲೆ ಸ್ಟೇ ಆಗಿರೋದು ಎಲ್ಲಿದೆ?
ಇದೆ ಸ್ವಾಮಿ. Because this is one such orders, my lord, one of such orders.
Some
my lord.
500 petitions, my lords, are filed.
Almost
It's
500.
all right.
petitions.
What is it?
But certain heads, my lord, there's an absolute stay. Certain heads, no stay. I mean,
We'll just follow this order.
Please, my lords.
Whatever heads that are stayed, that will be stayed here.
subject to, my lord, the rate.
Subject,
Please,
subject to
my lord.
outcome always.
Please,
sir.
please, my lord.
Same thing.
That
You
can
start
be done,
construction, we'll pass this order.
Please, my lord.
ಅಷ್ಟೇ.
In my case, my lords, the
Suraj Sahib reserve ಮಾಡ್ರದ?
ಹೌದು ಸ್ವಾಮಿ. My Lord Justice Govindra passed this interim order. Relying on the order passed, my lords, by the another coordinate bench. The another coordinate bench, my lords, has heard the matter, my lords, has reserved the matter for orders, my lord.
No, my lords.
So this is only as far as the 5 heads. No? The development charges has got nothing to do, my lords, with the demand. I have given them the road, I have given them the dustbins, I have given them all other things, and equally distributed to all such persons who are going to file applications. I'm on affidavit, my lords, on that. So my lords may.
That affidavit, my lords, is contrary to what the application, this permission they themselves have, my lords.
What's the harm in passing the same order?
My lords, I don't know if, my lords, my only, my lords, major amount why that has been.
You look into it.
My lord,
I'll take it at 2:30. Look into it.
for asphalt road, my lords, they have charged, my lords, 2 lakhs.
ಏನು interim order ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ. That same order will pass.
Please.
Pass. Next.
Number 32, J. Gachimat, A.S. Patil.
Payment of subsistence allowance matter.
Here for respond number 5 and 6. The similar endorsement mode is questioned in the other petition also. It is also connected with.
No, substance allowance ಕೊಡಲ್ಲ ಅಂತ.
ಕೊಡ್ತೀವಿ. Grounds is that mode. In fact, apart from the management, the respondent the government has caused the delay in processing our request for initiating the inquiry proceedings. That has resulted in. Government has caused a delay in processing our request for initiating the inquiry Immediately after suspension, we wrote a letter to the government several occasions. We have requested them to give the approval to the suspension.
When did you write, sir?
Please.
Date of suspension.
Please, date of suspension is. And in fact, all these documents are produced in the connected petition which is filed by the management. Notice is not yet issued to the those respondents.
Notice is not
how? It was not listed along with the other 2 petitions.
Yeah, 107219.
But 107219 is the petition filed by the management, producing all these documents to indicate that there is laches on the part of the government in not approving the order of suspension, and also causing a request made by the management to initiate the inquiry proceedings. That has resulted in forcing the management to pay the.
ಈಗ substance allowance ಎಲ್ಲಿಂದ ಬಂದಿಲ್ಲ ನಿಮಗೆ?
10/6/2024
to December.
To December. That will be, my lords,
because
that's what 3112.
An amount of 3,59,262 rupees, my lords, I am entitled for. Subsistence allowance.
Management has to pay.
Management has to pay
According
because
to
it has suspended me without the approval of the government, and the government has also expressed its displeasure.
My request is
Granted institution.
Granted
institution.
You recover from the grants that are to be sent.
Please.
By the institution. You are granting the grant nilsbidi. I will pass an order now to stop grants.
We will pay my submission
tomorrow?
is one more petition.
Tomorrow, first one by one.
Yes.
Substance allowance 3,59,000 ನಿಮ್ದ್ರಲ್ಲ.
But reserving our right to proceed against the government.
You produce against the government.
Yes, because it is because of the laches and the delay on the part of the government.
Whatever you want. ನಾಳೆ ಕೊಡ್ತೀರಾ?
Enquiry is also stopped by virtue of the
that I will pass an order later. ಈಗ substance allowance ನಾಳೆ ಕೊಡ್ತೀರಾ?
Weeks time because chairman is not in station. They have to conduct
on to the United States.
They have to conduct the meeting of the other board of directors. Weeks time.
Weeks time to the United States.
Bangalore next week
get it list on Tuesday in the fresh matters list.
Please.
Their cost ಎಲ್ಲ impose ಮಾಡ್ತೀವಿ. Substance allowance
ಕೊಡ್ತೀವಿ, but the other grounds are
ಮೆಹರ್ಬಾನಿ ಅಲ್ಲ ಸರ್. It's his right and
reason for suspending her with
your obligation.
But reasons for suspending her with immediate effect is
maybe manifold.
Serious allegations
maybe manifold. If you have the luxury of placing some employee under suspension, you better well pay substance allowance.
Yes. Please. Wednesday, may I request
Tuesday, fresh matters.
Please, grateful.
ಆಮೇಲೆ ನಿಮ್ದು ನೋಡೋಣ enquiry.
33 J. Gachimat.
Please, my lords. My lords, I appear for the petitioners in 33, my lords.
Is an identical order?
No, my lord, this is a matter relating to denial of input tax credit under GST law for the period from July 17 till March 20 by issue of a notice, my lords, which is issued on 9th April 2024, alleging there is fraud, suppression, etc. on my part. My lords, I'm audible?
Other delay of 4 years.
More than 4 years.
Alay.
Under 74, alleging fraud, suppression.
It is reversed. Reply ಕೊಡ್ಲಿಲ್ಲ, my lords. Thereafter, the order has been passed on the
Yes,
show cause
order
notice.
passed. The notice was challenged. I have IA challenging the orders. my lords.
Two applications are preferred challenging the order.
Yes, my lords.
Accept notice, reserve so and so.
And in the order also, there is no finding as to why there is fraud, suppression, etc. on my part to invoke the extended period.
My lords, and moreover, my lords, the show cause notice has been issued in the month of May, my lords.
No reply is given.
No, my lords. And they had preferred a petition in the month of September, my lords. And for the first time, the matter has been came up in the last week, my lords.
No, my
I
lords.
have said so.
Please, my lords.
What is called in question is a show cause notice to 31/5. Petitioner
lords,
did not
even-
reply, but challenged on 4th September. And during the subsistence, you passed an order.
Please, my lords. If they are agreed by the order, my lords, let them go and
Appeal
prefer an
idea,
appeal before Commissioner Appeals under Section 107 of GST.
Why no appeal?
Well, the appeal, why we are pointing out, Malad, because the invocation of extended period under 74(1), Malad, is bad in law. 2, Malad, this is for the period from July 17
You should
till
have,
March
you should
20.
have replied to the show cause notice.
No, Malad, they just pointed out. But in fact, the requirement.
Why you did not reply to the show cause
We filed
notice?
the challenge because the similar matters are filed before this honorable court and
Sir,
interim orders have been
4th
passed.
September 2024, you have challenged. Other
Well,
Puncha
because there are
reply
similar
period was
orders,
already over.
the similar orders by
File
the
your objection.
honorable court granting stay. I'll just point out, Malad, what is the reason?
The council, Girish, seeks 2 weeks' time to file statement of objections. List after 2 weeks. Next.
Let's protect me in the meanwhile, Malad.
No, sir. Yes. Next.
Any date may be fixed.
Some date may be fixed, Malad.
List on 26th, 27th. Yes. Objections, if any, by then.
34, Lordship, as per the intervention of the elders of the community and the religious, their matter is settled, Lordship. As per the settlement, we agreed to form the managing committee. That committee should function without prejudice to my right as a trustee and as a mutali of that to perform all the religious activities as per the customs and usage, Lordship.
I have no instructions, sir. 2 days time may kindly be.
In fact, Lordship.
No instructions with regard to what?
For settlement is concerned.
You did not take them into confidence? You did not take them into confidence?
We are given our offer with joint compromise.
2 days time.
I mean,
List on Friday in the fresh matters.
They have filed review also against that.
List on Friday in the fresh matters. Yes. But don't sing the same swan song on Friday.
Our proposal ಏನಿದೆ, let them, whatever the.
ಕೊಡಿ.
ಕೊಟ್ಟಿದ್ದೀನಿ. ಅದು let them be, copy be.
ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ, ಬೋರ್ಡಿಗೆ ಅದ್ರ ಕಳಿಸಿದ್ರೆ ಸ್ವಲ್ಪ ಅನುಕೂಲ ಆಗುತ್ತೆ. So that your matter can be settled once for all.
ನಿಮಗೆ ಕೊಡಿ ಕಾಪಿ.
ಕೊಡ್ತೀನಿ.
Lordship, they claim the Khajatship. Khajatship is not comes under the preview of the offense.
Who are you?
Respondent number 5, Lordship.
ಆಗಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ, ತೊಂದರೆ ಇಲ್ಲ. ಕಾಪಿ ತಗೊಳ್ಳಿ ಫಸ್ಟ್ ಫ್ರೈಡೆ.
Please.
31st?
Monday.
Interim order.
ಆಯ್ತು, Monday fresh matters.
Interim order.
Interim order subsisting will continue to the next date. 30?
So senior citizens
My lord.
appeal, my lords, not maintained.
Municipal court directed the petitioner to serve hand summons on the respond number 3, my lord. The respond number 3 is expired, your lordship. On
The senior
16th,
citizen is no more.
No more.
No more.
Yes.
Order of appeal.
challenge the order passed by the respond
But
number.
assistant commission division bench judgment now.
The same. 254.
So division bench says you can't set aside the order the ನೋಟ್ ತಿಂತಾಳೆ. ನಿಮ್ಗೆ ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ಹಾಗೆ.
ಲಿಸ್ಟ್ ಆನ್ ಫ್ರೈಡೆ ಮೇಡಮ್ ಈಗೊಂದು ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ನಲ್ಲ ಗಿರೀಶ್ ಅಡ್ವರ್ಡ್ ಅದ್ರಲ್ಲಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಡ್ಮೆಂಟ್ ಇದೆ, ಅದು ಇದಕ್ಕಿಡಿ, ಅದು ಕಾಪಿ ಮಾಡಿದ್ನ.
Interim order may be.
Interim order subsisting, that will go madam on Friday. Yes, list on Friday in the fresh matters. Yes, next.
Cell number 36, M.A. Rajendra.
For the respondent number 2, auction purchaser in this matter. Sale certificate is already issued.
ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿದ್ದು?
It was issued on
13/8/24.
13/8/24.
Yeah, and registered on 17/9/2024.
Go to the DRT, sir.
Your lordship, on submission, my lord. My submission.
ಇಲ್ಲ ಆಗಲ್ಲ. Yes.
Your lordship,
Cover.
one
kindly, my lordship.
No, this is
Kindly.
the latest one. my lord.
ಪಾಪ್ನ ಆದ್ಮೇಲೆ ಒಂದೆರಡಿದೆ ಕೊಡಿ ಎಲ್ಲ.
Yes, sir. What the judgment they are relaying, where in the para number 218 may be read, madam.
This is
218, my
after Bafna, my lord.
218, wherein
ಪಾಪ್ನ ಅಲ್ಲ ಸರ್, there is another one. Sale
Your lordship-
certificate issue ಮಾಡಿದ್ಮೇಲೆ, register ಮಾಡಿದ್ಮೇಲೆ, I will not interfere, sir.
No,
Para
no,
33, my lord.
your lordship,
Para
three,
33.
my lord, three judges,
No increment. Para 33, my lord.
my submitting your lordship, my colleague is there, he is submitting.
Re-agitating the matter, I have paid entire consideration.
No, wherein,
Remedy is
Yes.
only one moment, only please,
No
one
problem.
moment.
Yes. No, sir, I will not interfere after sale certificate is issued and registered. ನಿಮಗೂ ಗೊತ್ತು, ಮತ್ತೇನ್ ಮಾಡ್ತಾ ಇದೀರ ಆರ್ಗ್ಯುಮೆಂಟ್?
No, no, it was Honorable Supreme Court judgment is clearly says in para number 218, if I convince the court, if the valuation
You
is made,
can't convince at all. Yes.
even they are not remitted the 3 crores, 1 lakh need, but the property has been sold much less than.
Everything before the DRT.
Okay. Bafna's case, my lord. Right of redemption is lost, my lord. Moreover, my lord, on the.
No, your lordship, I can convince my lord, based on the same Supreme Court, Honorable Supreme Court judgment, para number 218.
We will issue rule and keep it. You carry on. ಅಷ್ಟೊತ್ತಿಗೆ ಇನ್ನೊಂದು ಜಡ್ಮೆಂಟ್ ಬಂದಿರುತ್ತೆ.
I may be permitted to take the position.
Please take possession.
Lordship stay is there in DRT.
14
No,
under section.
stays operating.
DRT.
No, under section 14.
ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ ಹಂಗಲ್ಲ.
Under section 14, DRT has granted interim order of stay there.
Then you agitate there only, sir. Yes.
This
may be disposed of.
I will dispose this case then. Yes.
And time spent here, Lordship, the time spent before your lordship may be taken.
No
into
time
consideration.
spent.
DRT it is
The
reserved for
petitioner-
orders, my lord.
1 minute, sir. The petitioner is before this court calling in. ಎಲ್ಲಿ petition ಎಲ್ಲಿದೆ ಮೇಡಮ್? ಬರೀ objections ಇದೆ ಇಲ್ಲಿ. The petitioner is before this court calling in question
Along with memo also we have paid, my lord.
Sale
a
certificate.
sale notice, auction notice dated 12/3/2024 and a sale certificate so issued pursuant to the auction. The learned counsel appearing for the respondents would in unison submit that the petitioner is before the DRT in which he has challenged a possession notice issued under section 14 of the SURFACE Act, and the DRT has reserved the matter for its orders after hearing the parties. Hearing the parties. What is projected in the case at hand is as certain procedural aberration, which I do not find prima facie, since the entire issue is now before the DRT. The petitioner is at liberty to agitate to call in question if he is so aggrieved, the sale certificate also being issued before the appropriately drawn proceedings in the DRT. As the writ petition in the light of the judgments rendered by the apex court in the case of Sanjay Sharma versus Kotak Mahindra Bank rendered on 10/12/2024.
Para 33, my lord.
Para?
33.
In which the apex court has observed as follows. Held as follows. Para 33 till the end, 35, 33 to 35. In that light, I do not find any warrant to entertain the petition. The petition is thus disposed, reserving liberty to the petitioner to avail of such remedy as is available in law before the appropriate forum at the appropriate stage.
Your lordship,
Yes,
that
next.
time spent for your lordship may be taken.
ನೀವು ಬೇಕಂತ ಇಲ್ಲ delay ಇದೆ. Yes, next.
ಆಮೇಲೆ ಅದ್ರ lordship possession notice ಚಾಲೆಂಜ್ ಮಾಡಿದ ಅಂಡರ್ ಸೆಕ್ಷನ್ 14 ನಲ್ಲಿ ACM ಕೋರ್ಟ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು.
ACMM court.
Section 14 has been challenged where protection has been given not to dispose.
Correct. So what? DRT ಅಲ್ಲ, ACMM court. How can ACMM court stay proceedings?
Section 14 order has
DC order.
How can that court stay surface proceedings, sir?
No, section 14 DC order. That I have
DC order is stayed by whom?
DRT.
That will see. Correction. Yes, next.
37, kitchen cooler.
My lord, claim of compassionate appointment is rejected, my lord. Impugned order is annexed G, my lord.
Who has to consider?
The respondent number.
Who has to consider?
Respondent number 1 and 2, my lord.
No, it's already considered and rejected, my lord. On the, already considered and rejected.
What
On the
is
ground
the-
that, my lord,
Challenged, your lordship.
What is wrong with it?
annexure G, my lord,
Ah.
in the impugned order, my lord.
Hmm.
On the ground, rejected on the ground that, my lord, no scheme was available at the time of death of father of the petitioner, my lord.
Ah.
My lord,
No scheme was available. Scheme itta?
ಅಲ್ಲ ಅಂದ್ರೆ ರೂಲ್ಸ್ were not available ಅಂತೇಳಿ.
ಅಲ್ಲ scheme ಇತ್ತ?
Yes, my lord.
Huh?
ಅಲ್ಲ ಅಂದ್ರೆ
ಏನಿತ್ತು?
my application was accepted.
ಸರ್ ಯಾವ ಸ್ಕೀಮ್ ಇತ್ತು ಹೇಳಿ ಸರ್?
ಅದನ್ನ ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ ಅವರು. ಅದರಲ್ಲಿ
ಯಾವ ಸ್ಕೀಮ್?
ಬರೀ
Is your lordship here?
ಪೇಜ್ ನಂಬರ್ 33, my lord.
ಹೂ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದು? ಸಿಇಒ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್.
Yes, my lord.
ಯಾವ್ದು ಕಂಪಲ್ಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ರೂಲ್ಸ್ ನಿಮ್ದೇನೆ? ಇನ್ಯಾವ್ದಿದೆ?
ಅಲ್ಲ ಇಲ್ಲಿ your lordship at page number 33 your lordship third para ಸದರಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಉಲ್ಲೇಖ 1ರ ಅಧಿಸೂಚನೆ ನಿಮ್ಮ 22ರಿಂದ 24ರಲ್ಲಿ ವಿವರಿಸಿದಂತೆ ಉಲ್ಲೇಖ 3ರ ಸರ್ಕಾರದ ಪತ್ರದಲ್ಲಿ ದಿನಾಂಕ 14/11/22ರಿಂದ ಜಾರಿಗೆ ಬಂದ ನಿಯಮಗಳನ್ವಯ ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ ನೇಮಕಾತಿಗೆ ಅವಕಾಶ ಕಲ್ಪಿಸಿದ್ದು 14/11/22ರ ಹಿಂದಿನ ಅವಧಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಗ್ರಂಥಾಲಯ ಮೇಲ್ವಿಚಾರಕನ್ನು ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ ನೇಮಕಾತಿ ಮಾಡಲು ಅವಕಾಶವಿಲ್ಲ.
ಯಾಕಿಲ್ಲ? ಲೈಬ್ರರಿ ಸೂಪರ್ವೈಸರ್ ಬರಲ್ಲ ಅಂತನ?
Yes, your lordship.
Where is your scheme?
That I'll
File your objections, yes. The respondents are directed to file their statement of objections, to which 10 days time is granted.
Last time also granted, my lord, time. Last time also time.
Well, so what? Yes.
38 Satish Raju, Manjunath Gowda.
This is
In this senior counsel, Amit Kumar has argued.
Huh?
Amit Kumar has already advanced the
the
argument.
tender, tender case, my lords.
Matter.
I filed objections. It is not the case that, my lords, so we have rejected the tender on the ground which is argued. The 5 reasons, my lords, we have stated. He has not supplied, my lords, given the details which are required.
Objections are filed?
Okay, I filed, my lords.
ಎಲ್ಲಿದೆ? You want rejoinder ಆಗ್ತೀರಾ?
Today they have served copy.
Learned counsel for the petitioner submits the statement of objections are served upon him today and would seek to file a rejoinder to the statement of objections. Rejoinder, if any, by the next date of hearing. List on 21st in the fresh
To be taken in
matters.
fresh
For
matters.
respond,
21st in the fresh matters.
I am for respondent number 4, 5 and 6.
ಹಾಕಿ ವಕಾಲತ್ ಹಾಕಿ.
Filed, man, already.
ಸರಿ. ఇప్పుడు ತೋರಿಸಿಲ್ವಾ ನೇಮ್?
Proceed.
ನೇಮ್
It is
ತೋರಿಸಿಲ್ವಾ?
shown, it is shown.
ಸರಿ, yes.
Please, ma'am.
39 Channegowda KG, DV Patta.
My lord, 2 points submits in page number 74, my lord.
Objections ಹಾಕಿದ್ದೀರಾ? Respondents. Why?
Instructions ನಂಗೆ ಸರಿಯಾಗಿ ಸಿಗ್ತಾ ಇಲ್ಲ ಸರ್.
ಆ?
Instructions not
ಸರಿಯಾಗಿ ಸಿಗ್ತಾ ಇಲ್ವಾ? ಏನು ಸರಿಯಾಗಿ ಸಿಗ್ಬೇಕು?
actually your lordship the tender notification is of the 31/7/24.
No, madam, there is only one thing.
Please.
1% or 3%.
ಹೌದು. ಅಲ್ಲ as per
ಈಗ
31/7 notification
0 to 3% ಕೊಡಂಗಿಲ್ಲ ಅಂತಿದೆ. In the document. ಇವರು 3% ಕೊಟ್ಟಿದ್ದಾರೆ. Selected is 1%. How did you select? ಇಷ್ಟೇ ಕೇಳಿದ್ ನಾನು. Instructions
Yes,
ಬರ್ತಾ
your
ಇಲ್ಲ ಅಂದ್ರೆ we'll allow
lordship.
this.
Yes, your lordship. But as per 31/7 notification, your lordship, it was quoted as 1 to 3, 5%.
It is wrong. Deliberately to
As
help
per the
someone, you have
proceedings,
tweaked the
please.
notification ಅಷ್ಟೇ. ಮತ್ತೆ subsequent ಅಲ್ಲಿ
And
ಮತ್ತೆ 3%.
And the petitioners have not challenged that
No problem.
this notification, your lordship.
No
And he
problem.
has participated in that process, your
That
lordship.
also no problem at all.
He cannot.
ಏನು ಪಾರ್ಟಿಸಿಪೇಟ್ ಆದ್ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Yes, your lordship. My submission, your
ಸರ್ವಿಸ್
lordship.
ಲಾ ಇಲ್ಲಿ ತರಬೇಡಿ ಆಮೇಲೆ.
My lord, page number 74, my lord. ರಾಜ್ಯದ ಎಲ್ಲ ಜಿಲ್ಲೆಗಳಲ್ಲಿ ಕಾರ್ಮಿಕ ಸೇವೆಗಳನ್ನ
ಅಲ್ಲ ಸರ್. Yes.
He participated and L1 candidate is been given the tender.
L1 ಇಲ್ಲಿ ಇದಾರಲ್ಲ.
L1, your lordship.
L1 3%, ಅದು 1%.
1%, your lordship,
Ah.
which is beneficial to the government, your lordship.
Correct.
Please.
My lord,
ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಇರ್ತೀರಾ ನೀವು? ನಿಮ್ ಕ್ಲೈಂಟ್ಸ್ ಇದಾರಾ ಇಲ್ಲಿ? ಇದಾರಾ ಇಲ್ಲಿ? ಮತ್ತೆ ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಇರಿ. ಎಸ್ ಸರ್.
1% ಅವ್ರು ನೋಟಿಫಿಕೇಶನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ 2017 ಮಾಡಿ ಸರ್. Recently ಮಾಡಿ ಸರ್.
ಅಲ್ಲ ಅದು 1% ಇಂದ 5% ಅಂತ ಕರೆಕ್ಟ್ ಇದೆ.
ಆಗಿದೆಯಾ?
ಅವರು 0% ಇಂದ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಓ ಸರಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡಿಸ್ಕೊಂಡೆ.
ಅದು ಮುಗಿದೋಗುತ್ತೆ, ಟರ್ಮೇ ಮುಗಿದೋಗುತ್ತೆ.
ಅಲ್ಲ ಅದು ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಮುಗೀತು ಸರ್ ನಮ್ದು
ಅಲ್ವಾ? ಅದೇ ಆಮೇಲೆ ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೀನಿ ಬೈ ದ ಎಂಡ್ ಆಫ್ ದಿ ಡೇ, ಪಾಸ್ ಓವರ್.
Your Lordship,
I am
petitioners
going to
have,
allow it, madam. Yes. ನಿಮ್ಗೆ ಯಾವಾಗ ಬೇಕು ಅವಾಗ 1%,
and in
ಯಾವಾಗ
the
ಬೇಕು ಅವಾಗ
next,
3%.
in the next petition, Your Lordship, connected matter, we have complied all the conditions, Your Lordship. There in
ಮೈಲಾಡ ಅದನ್ನ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ನೋಡಿ
3%,
ಕೊಟ್ರ ಮೈಲಾಡ
both-
ಹೈಯೆಸ್ಟ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಮಾಡ್ರ 886 crore ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಮಾಡ್ರ ಅಂತ ಕೊಟ್ರ ಮೈಲಾಡ ಅದನ್ನ. ಅದು ಕೂಡ ಆರ್ಡರ್ ನಲ್ಲಿ ಎಲ್ಲಿ ಇಲ್ಲ ಮೇಡಮ್.
both the bidders have quoted 3%, Your Lordship, and with the discretion of the respondents, Your Lordship, whose transactions are more, Your Lordship.
ಈಗ ಇವರು ಯಾವ್ದು ಇದರಲ್ಲಿ 39.1 ಎರಡರಲ್ಲೂ
39 ನಲ್ಲಿ 1% ಸರ್ವಿಸ್ ಚಾರ್ಜ್ ಅಂತ ಕೊಟ್ಟಿದೆ.
ಸೆಲೆಕ್ಟೆಡ್.
Please, Your Lordship.
ಆಯ್ತು.
39.1 ನಲ್ಲಿ 3% is complied, Your
ಅವ್ರದ್ದೇನ್
Lordship.
ಪ್ರಾಬ್ಲಮ್?
ಅವ್ರದ್ದು ಟ್ರಾನ್ಸಾಕ್ಷನ್
ಯಾಕೆ ಎರಡೆರಡು ಬೇಕು?
ಮೈಲಾಡ ನಮ್ದು ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಮೈಲಾಡ ಅವರ ಮೆಂಬರ್ಸ್ ಮೈಲಾಡ ನಾವು ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಕೇಳ್ತಾವೆ.
ಸೆಕೆಂಡ್ ಅಲ್ಲಿ ಏನಿದೆ?
ಅವ್ರು ಟ್ರಾನ್ಸಾಕ್ಷನ್ ನೋಡಿ ಕೊಟ್ರ ಮೈಲಾಡ 886 ಕೋಟಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಮಾಡ್ರ ಕಾರಣ ಕೊಟ್ರ ಮೈಲ. ಅದ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಎಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ನೋಡಿ ಕೊಡಬೇಕು ಅಂತ
It
ಹೇಳಿ.
is up to the discretion.
On that ground we will allow one.
ಬೋತ್ ಟೆಂಡರ್ 90 days ಕ್ರಾಸ್ ಆಗಿದೆ ಮೈಲಾಡ.
That will see. Yes. 90 days ಕ್ರಾಸ್ ಆದ್ಮೇಲೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
90 days ಮೈಲಾಡ.
No, Your Lordship, it's complied within 3 months, Your Lordship.
92 ಆಗ್ತಾರ.
ಅದೇ ಇದು ಫೈಲ್ ಕಳಿಸಿ ನಾಳೆ ಟುಮಾರೋ. Yes, next.
Film 40, Ranjita Ji Alagwadi. Your Lordship, election is over.
It's covered
Respect
by
of the same, Your Lordship has already passed orders.
PMSPJ.
Please, that is.
Order. Shamsar Sahib.
That, please. Right. 41.
The PMSPJ order disposed.
Petitioner was appointed in the 1996 Lordship, Gram Panchayati clerk Lordship. And to the respond number 2, Chief Secretary Municipal Corporation Bangalore has afforded Gram Panchayati to Town Panchayati Lordship in the year 2016. And next year G. Page number 24, Lordship.
Yes, sir.
Milord, respond number 6 has to answer, Milord.
Who is respond number 6?
Town Panchayat, Milord.
ನೀವು ಯಾರಿಗೆ?
Milord, Jilla Panchayat and Gram Panchayat.
Who appears for 6th respondent?
Third and unrepresented.
ಯಾವತ್ತು ಸರ್ವಾಗಿ ನೋಡಿ. ಅಂಡ್ ಸಮನ್ಸ್ ತಗೊಂಡಿಲ್ವಾ? 31st January. One more chance. List on 21st in the fresh matters list. ಅವತ್ತು ಬರಲಿಲ್ಲ ಅಂದ್ರೆ we'll pass orders.
Sirajuddin Ahmad.
For the petitioner, my lords.
What is this?
My lords, it's 9 years, 11 months the petitioner's brother has undergone, my lords. It's for parole, my lords.
Parole escape case ಆಗಿದೆ ಮುಂಚೆ. Parole escape case.
Parole escape case.
Yes. My lords, late surrender, my lords, and case has been registered against him and he has
Police
already.
report is also, my lords.
ಎಷ್ಟು ದಿನ? ಲೇಟ್ ಸರೆಂಡರ್ ಎಷ್ಟು ದಿನ?
ಇಲ್ಲ ಅದರಲ್ಲಿ lords in the police report they have submitted that the family members are lords afraid of giving an application or statement because last time lords because of his escape they met lords the difficulties.
ಎಷ್ಟು ದಿನ ಲೇಟ್ ಆಗಿ ಹೋಗಿತ್ತು?
ಅದನ್ನ ಆತರಾಗೆ ಇಲ್ಲ. Parole escape case ಆಗಿದೆ ಅಂತ.
My lords, according to my information, second day he surrendered, my lords.
No. Get how many days? How was he apprehended? It's only late surrender or escape from parole.
Case is also registered for that.
Please, the case. Get the
please,
details.
Please.
List on Tuesday, Wednesday, next. Yes.
Obliged.
43, Halima Begum.
This case. Today they have served the copy.
Today I have served the copy. Your Lordship, it was
Day
missing.
after tomorrow.
Date.
Friday?
Friday, please.
Friday in the
Please.
fresh matters list. Yes.
44, Shayadot.
Petitioner is calling in question the order of the appellate authority remanding the matter back to the DCVC, Caste Verification Committee.
Milord, I am for the 9th respondent, Milord.
9th respondent.
Sixth, 9th respondent. Milord, I may be permitted to file my wakalat and file my objections also.
Who is 9th
I
respondent?
am the original complainant, Milord. I am the original complainant.
Complainant.
Yes, Milord. In fact, a complaint has been filed questioning the caste certificate issued by the district caste verification committee, my lord.
On
The
21st
procedure
at the
followed.
request- All right, list on 21st,
25th.
list on 24th.
Please.
List on 24th at the request of the request of the ninth, first Barkumbudi. Learned counsel so and so
PV Gunjal, my
submits,
lord. PV Gunjal.
submits that he has entered appearance for the ninth respondent registry to print the name of so and so as appearing for the ninth respondent. Yes. Objections, if any, by the next date of hearing, list on 24th. Fresh
Obliged.
interim order substituting will continue till the next date of hearing in the fresh matters.
Obliged, my lord.
5 second code वाला विजय कुमार
Yes, direct comment.
ಇಲ್ಲ ಮಲರ್ಸ್ ದಿ
ನೀವಲ್ವಾ?
ಇಲ್ಲ ಇವರು ಇದೆ.
Kindly pass for lordship.
Passed over by 2 days. List on Monday, fresh matters list. Next.
Please, lordship.
46 Sadiq in code वाला
Interim order stands extended to the next date of hearing.
46
ಇಲ್ಲ ಇಲ್ಲ. ಇದರಲ್ಲಿ ಮಲರ್ಸ್
46.
the civil dispute is there ಮಲರ್ಸ್
Strangers are put up the construction lordship.
on his property and he is seeking protection from the.
Who has put up where?
ಅಲ್ಲ ಅವ್ರೇನ್ ಹೇಳ್ತಾ ಇದಾರೆ, ಅವ್ರ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಬೇರೆಯವರೆಲ್ಲ ಶಾಪ್ಸ್ ಎಲ್ಲ ಹಾಕ್ತಾ
Pan ki
ಇದ್ದಾರೆ.
dukaan.
Please,
How can we mlords just file a suit against
Yes,
them mlords?
Sadiq. पान ಅಲ್ಲಿ ಟೇಸ್ಟ್ ಇಲ್ಲ ಈಗ. ಪಾನ್ ಕಿ ದುಕಾನ್ ಮೇ ಕುಚ್ ನಹೀ.
ಪಾನ್ ಕಿ ದುಕಾನ್
ಇದೆ, ಪಾನ್ ದುಕಾನು ಇದೆ, ಅಲ್ಲಿ ಚಾಯ್ ದುಕಾನು ಇದೆ. Kindly see, my lord.
Yes, sir.
What is the, my lord, guidelines? And they have been removed by the PDO, my lord, after the order of your lordships. My lord, some
I will continue at 2:30.
please.
ಅರ್ಜನ್ ಇಂಟ್ರಿ ಮಾಡೋ పేరు మీరు విజయ్ కుమార్
Lordship. Serial number 45, lordship. My name is shown in the typographical error, lordship. Kindly correct, lordship.
Your Lordship, on submission, serial number 147, it's a pending election matter. Your Lordship heard this matter and stated the returning officer and president of the society to bring the original records on record. They are today before this.
Society.
It may be taken at 2:30 because Your Lordship, administrator has appointed the president, vice president election as state. Please.
Monday. 46.
Monday.
State.
Interim order.
That will continue.
8411.
ಯಾರ್ಯಾರು ಟೈಮ್ ಬ್ಯಾಕ್ ಕೇಳ್ಬಿಡಿ.
Lord, serial number 80, my lord, I need a short accommodation, my lord. They have filed objections, my lord, I need to file a rejoinder.
Madam, 84.
ವಿಜಯ್ ಕುಮಾರ್ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್
80, my lord.
ಈಗ ಮ್ಯಾಮ್ ಮೆನ್ಷನ್ ಮಾಡಿದೆ ನಾನು.
ಯಾವಾಗ ಬೇಕು ಸರ್?
2 weeks?
24
Yes.
Oh, sorry.
Madam, 84. 84 and 106.
Madam?
Sir 24
Yes, madam. Thank you, madam.
Madam, 84, 21.
Madam, serial number 70, anybody asking time?
ಸರ್ ಹೇಳಿ ಸರ್.
Madam, 25.
Serial number 70 ಯಾರು ಡೇಟ್ ತಗೊಂಡ್ರೆ ಮೇಡಮ್?
ಸೀರಿಯಲ್ ನಂಬರ್
70.
70 ಯಾರು ಡೇಟ್ ತಗೊಂಡಿಲ್ಲ ಸರ್.
Madam, ನಾನು 70.
ಸರ್ 70 ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಇಲ್ಲಿ.
ರೈಟ್ ಮಾಡಿ. ಮೇಡಮ್ ಅದನ್ನ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ನಾಳೆ ಶುಕ್ರವಾರ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್.
ಫ್ರೈಡೆ ಬೇಕಂತ ಸರ್.
ಫ್ರೈಡೆ ಕೊಡಿ ಮೇಡಮ್, ಫ್ರೈಡೆ ಕೊಡಿ. ಆಮೇಲೆ ಪಟಿಷನರ್.
ಅವ್ರು ಹೇಳಿ. ಹಲೋ ಮೇಡಮ್.
14th.
ಮೇಡಮ್.
Madam, 106 date ಬೇಡ. 50 ನೋಡಿ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಲ್ಲಿಗೆ ಈಗ ಇದು ಸ್ಟಾಪ್ ಆಗಿದೆಯಮ್ಮ ಮೇಡಮ್?
ಸರ್ ಹೇಳಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ ಎಲ್ಲಿಗೆ ಸ್ಟಾಪ್ ಆಗಿದೆಯಮ್ಮ ಇವಾಗ? 40 ನಮ್ಮ?
46.
ಓಕೆಮ್ಮ, ಥ್ಯಾಂಕ್ ಯು.
Madam.
Sir, no, sir.
ಅವ್ರು ಕೂತ್ಕೊಳ್ಳೋಕೆ ಹೇಳಿ. That's the problem. Now I know the problem. You want your father for everything. Why?
Sir.
ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂತೀರಾ?
ಸರ್ ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ಇಲ್ಲ ಸರ್.
ಅಮೌಂಟ್ ಇಲ್ಲ, ನಾನು ಆರ್ಡರ್ ಬರೀತೀನಿ.
ಅವಾಗ ಸೆಟಲ್ ಮಾಡ್ತೇವೆ ಒಂದೇ ಸರ್. ಅವರು ನಾವು ಸೆಟಲ್ ಮಾಡ್ತೇವೆ ಅಂದಾಗ ಅವ್ರು ಒಪ್ಪಿಲ್ಲ ಸರ್. ಆಮೇಲೆ ನಮ್ಮ ತಂದೆ ತಾಯಿದ
ಏನ್ ಹೇಳಿ?
ಸರ್ ನಾವು ಅವಾಗ ಸೆಟಲ್ ಮಾಡ್ತೇವೆ ಅಂದಾಗ ಅವ್ರು ಒಪ್ಲಿಲ್ಲ ಸರ್ ಅಷ್ಟಕ್ಕೆ.
ಆಯ್ತು, ಈಗ ಹೋಗ್ತಾರೆ.
ಆಮೇಲೆ ನಮ್ಮ ತಂದೆ ತಾಯಿ ಇಬ್ಬರು ಹಾರ್ಟ್ ಪೇಷಂಟ್ ಸರ್. ಅವಾಗ ನಾನು ಅವ್ರದ್ದು ಅಮೌಂಟ್ ಅಲ್ಲೇ ಹಾಕಿದ್ದೆ ಸರ್. ನಾನು ಇವಾಗ ನನ್ನ ಹತ್ರ ಅಮೌಂಟ್ ಅಲ್ಲ, ನನ್ನ ಹತ್ರ ಅಮೌಂಟ್ ಇಲ್ಲ ಸರ್ ಈಗ ಕೊಡ್ಲಿಕ್ಕೆ.
ಈಗ ನಿಮ್ ತಂದೆ ಕರ್ಕೊಂಡ್ ಬಂದ್ರಲ್ಲ, ಅವ್ರ ಪ್ರೈಸ್ ಕೊಡಿ
ಸರ್.
ವಾಟ್ ಎವರ್ ಇಟ್, ದೆನ್ ಐಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್ ಆನ್ ಮೆರಿಟ್ಸ್. ನೋ ಪ್ರಾಬ್ಲಮ್.
ಇಲ್ಲ ಸರ್, ನನ್ನ ಹತ್ರ ಇವಾಗ ಪ್ರೆಸೆಂಟ್ ಅಂದ್ರೆ ಅಮೌಂಟ್ ಇಲ್ಲ ಸರ್ ನನ್ನ ಹತ್ರ. ನಾನು ಈಗ ಹೊರಗಡೆ ಇರ್ತೀನಿ ಸರ್. ನಾನು
that is actually reasonable. You are not agreeing for settlement, then I'll pass orders on merits. No problem.
He is not a party to this.
Huh?
He is not a party to this petition.
No problem. I will dismiss the in-laws petition. Then you'll be all right. Because one more round of talks you have, and I'll take it at 4:30.
Please.
Please. I will. Yes. Mallikarjun Swami here.
Past over matters.
Service matter tha na?
Yes.
Second show cause.
Yes.
Now, whom are you looking?
Please.
What are you?
No, I was working as a cashier.
Adu got sir. Why were you looking back and keli?
See, AG had taken my file. I had given. He said that he don't have the
file is not in its own. Give it. Elli Yaji?
ಅದೇ ಅವ್ರು ನನ್ನ ಫೈಲ್ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ. ಅವರು
ಫೈಲು ಇಲ್ಲ, ಅವರು ಇಲ್ಲ.
ಹೇಳ್ಕೊಂಡು.
The petitioner is before this court calling in question an order dated 16/11/2011 passed by the disciplinary authority imposing penalty of dismissal.
Yes, dismissal.
Dismissal from service, and the order of the appellate authority dated 14/9/2012 by which the order of the disciplinary authority comes to be confirmed. Idyavadu innondeno review.
Appeal is 27/3/2012.
27/3/2012
and 27/3/2012 is the appeal order. 14/9/2012 is reviewing authority had passed.
What are you talking? 16/11/2011 disciplinary authority.
Yes, madam.
Adadmele appeal hakadre.
Appeal is 27/3/2012 order.
Where is 27/3/2012 you have challenged?
Page 70.
Prayer bani. Come to the prayer at page 21. The order dated next year R. Correct again.
ಅದು reading cell bar mistake.
Review ಆದ್ಮೇಲೆ appeal ಹಾಕಿದ್ದೀರಾ? ಏನು ಉಲ್ಟಾ procedure? Review under banking regulations is suo moto. You can't file a review at all. Appeal is your right.
Ex-employee.
ಬ್ಯಾಂಕ್ ನವರು ಸರಿಯಾಗಿದ್ದಾರೆ.
Ex-employee has conducted.
What ex? ಅದಕ್ಕೆ ರೂಲ್ಸ್ ಗೊತ್ತಿಲ್ಲ ಅಂತನಾ? The petitioner is before this court calling in question the order of the disciplinary authority dated 16/11/2011 and the order of the appellate authority dated 27/12/2014 by which penalty of dismissal from service is imposed against the petitioner by the disciplinary authority and the order of the appellate authority affirming the same. Facts in brief germane are as heard so and so. Facts in brief germane are as follows. The petitioner is appointed as a clerk cum cashier in the respondent Union Bank of India on 7/12/1989 and is said to have worked in several branches of the bank as clerk cum cashier up to 2/5/2005. The petitioner was proceeded against departmentally by issuance of a charge sheet on allegations of misappropriation inter-alia and conniving with the customer of the bank to siphon off certain funds. The charge sheet on the said allegation comes to be issued on 7/3/2011, and after conduct of a departmental inquiry, the inquiry officer submits his report on 23/7/2011. The inquiry report resulted in the impugned order being passed on 16/11/2011. The petitioner then prefers an appeal against the order of dismissal from service passed by the disciplinary authority. The appellate authority, by his order dated 27/12/2014, rejects the appeal, affirming the order of the disciplinary authority imposing penalty of dismissal from service. The orders of dismissal and its affirmation is what has driven the petitioner to the doors of this court in the subject petition. The learned counsel Mallikarjun Swamy Hiremat submits that submits apart from the merit of the matter, that after the findings of the inquiry officer, the petitioner was not issued with a second show cause notice as is necessary in law. That has been page 60. Kotila andre? Allah, 1 minute, Mallikarjun Swamy, you said it's not given?
Yes, I'm sorry. My apology. I had.
Tunde ground ididu.
I'm sorry.
Ground
I'm sorry.
Misappropriation.
No, my apology.
That's all right.
I had not noticed.
Mallikarjun Swamy Hiremat submits that there is no charge of misappropriation that can be laid against the petitioner, as the customer himself has tendered a statement before the inquiry could get concluded, that he has himself instructed the petitioner to deposit 3 lakhs at a later point in time, or any other mode of transaction between the two. He would therefore submit that the penalty that is imposed upon the petitioner, i.e. the dismissal of service, would not hold water, as the customer has himself accepted the action that is now alleged against the petitioner. Per contra, the learned counsel Narayan Yaji, appearing for the SV Yaji, appearing for the petitioner, respondent bank would refute the submissions of the petitioner in contending that notice, second show cause notice, was in fact issued to the petitioner. The petitioner has not chosen to submit his reply to the said show cause notice. Therefore, the said ground of violation of principles of natural justice is thus contrary to the record. He would further submit that the petitioner, having been alleged of misappropriation of funds, no lenience should be shown to the petitioner, therefore would seek dismissal of the petition. I have given my anxious consideration, so on and so on.
Acquittal.
He would further contend that where is the order of acquittal?
It is filed along with the memo minutes on 2/11/2020. It is not a case of misappropriation. The customer having withdrawn the amount, it is subsequently admitted.
Temporary misappropriation. You are accused of 409 IPC.
In fact, it was against 2 of them. The manager who had countersigned that was also arraigned as accused number 1.
What has happened to him?
No, he got the proceedings quashed on the ground that it was not brought to his notice. Subsequently, trial was held against me and I was acquitted.
Correct. Benefit of doubt. First type ಮಾಡಿ. We'll see. Acquittal not. Friday ಹಾಕಿ. ಅಷ್ಟು ಟೈಪ್ ಮಾಡಿಡಿ. Facts ಬೇಕೇ ಬೇಕು. Yes.
It's my apology. I had not noticed that.
That was the ground on which I
Yes,
could
yes.
have allowed other
Yes.
Yes. Next. Continue. madam. Password ಯಾವುದು? ಅದು ಬಿಟ್ರೆ ಕರೆದ್ಬಿಡಿ password. ಕರೆದ್ಬಿಡಿ.
Serial number 6, Girish Dharwad. Girish or Budhia?
Please. That is my submission. Aste. If that can be reconsidered, let them reconsider. Aste.
What reconsideration?
They in-
Order ನೋಡಿದ್ರಲ್ಲ.
ನೋಡಿ.
Same order will pass. Seal number 6.
In respect of the other claimant also, my lord, the order copy is also produced by them.
Seal number 6.
6 is the training order, my lord's maker. Land loser training order.
That's what. Yeah.
Along with the memo, my learned senior friend has produced another order passed by coordinate bench of this honorable court in.
Okay, page 6.
Yes, yes. Even if that
Same
is.
order will pass.
Please, please.
The petitioner is before this court seeking the following 2013 following prayer. Heard so and so. Facts in brief germane are as follows. The first petitioner is the son of the second petitioner. The lands of the petitioners were said to be acquired for establishing the thermal power plant by the respondent corporation. In terms of the scheme notified by the corporation of rehabilitation of the land losers, the mandate was that one appointment should be given to the family of the members of the land losers. The first petitioner, being the son of the second petitioner, had filed an application seeking appointment as a trainee -C, which had been rejected by the respondent on the ground that he is the sister's son of the land loser who has lost the land for establishing Ballari thermal power plant. Therefore, the petitioner is before this court. The learned counsel Girish Dharwad, appearing for the petitioner, submits that there was a partition in the family prior to the acquisition of lands for the purpose of the establishment of the thermal power plant. That has not been looked into by the respondents, and therefore the son of the second petitioner, the first petitioner, becomes entitled to consideration for appointment under the scheme of rehabilitation of land losers. The learned counsel would thus submit that the petition be allowed and a direction be issued to that effect. Counsel Shri Ashok R. Kalyan Shetty, representing the respondent, would refute the submission in contending that the grandson, yar grandson adu?
Of the original land loser, Narayanappa.
The grandson of the land loser has already been offered employment, and there cannot be two employments in the same family. He would seek to place reliance upon the judgment rendered by the coordinate bench in identical circumstances. The learned counsel Prashant Hosmani at this juncture submits that if an identical order that is passed by the coordinate bench is passed in the case of the petitioner as well, ಏನ್ ಮಾಡಿದಾರಲ್ಲಿ would
Respondents to consider petitioner's application.
Present. Therefore, without going into the merit of the claim of the petitioner, I deem it appropriate to dispose the petition following what the coordinate bench has held while issuing a direction by a writ in the nature of mandamus to the respondent. The coordinate bench has held as follows, para 2 in the end. In the light of the submission of Girish Dharwad that it would suffice if an order of the kind is passed, the petition is disposed directing the representation of the petitioner to be considered in accordance with what is directed by the coordinate bench in the aforesaid petition, ordered accordingly.
That petitioner is another grandson of Narayanappa.
ಅಲ್ಲೇ ನೋಡ್ತಾ ಇದ್ದೇನೆ, ಸೇಮ್ ನೇಮ್ ಕಾಣ್ತಾ ಇದೆ.
Same, yes.
Ganpati Ambat, B. Hiremat.
Silmer?
Surface Act, madam. But in this case, what happened is, earlier to issue notice, they already entered into OTS in a Lok Adalat, and petitioner paid 25% of the entire amount, but subsequently failed to comply.
Yes, sir.
Finally, the auction.
Against the petitioner, so many judgments are there. I will not interfere, sir. Go before the DRT.
But in parallel proceedings, they took under Surface Act, even though they entered for.
These are all seriously disputed questions of fact. You can go avail of remedy available in law. Sale notice agide.
After auction only they filed it.
The petitioner is before this court calling in question, seeking the following prayer. The petitioner is said to have, the petitioner is the borrower, borrows funds from the hands of the respondent State Bank of India, defaults in payment. The bank initiates proceedings invoking the provisions SURFACI Act 2002. In furtherance of the said proceeding, a sale takes place in which who is the success, he is not a party here.
Spot number 4, we filed IA, but that one is pending, my lord. Insofar as implementing that person, I filed IA
So
number.
the property is sold to the successful auction, the auction takes place and the property is sold to the successful auction purchaser. And the sale certificate is also said to have been issued by the respondent bank, and all proceedings concerning the sale of the property gets concluded long ago. Long thereafter, the petitioner is before this court seeking the aforesaid prayer on manifold circumstances. In the light of the judgment of the apex court in the case of yes, so Sanjay Kumar latest 3 days back, yes, don't ಕೊಡ್ತೀನಲ್ಲ. In the light of the judgment of the apex court, ಬೆಳಗ್ಗೆ ಒಂದು ಮಾಡಿದ್ದೀನಿ, apex court in so and so, I deem it appropriate to dispose the petition without entertaining the prayers or the plea of the petitioner, reserving liberty to the petitioner to avail of such remedy as is available in law. Petition stands disposed. There is no impediment with the disposal of the petition. There is no impediment to the bank. ಆಗೋಗಿದೆಯಲ್ಲ ಎಲ್ಲ, ಇನ್ನೇನಿದೆ? So ಏನ್ ಬೇಡ.
And the petitioner may be directed to
The learned counsel appearing for the respondent bank submits that an amount of 1 crore,
more than 1 crore.
Amount more than 1 crore that is to be returned to the petitioner is lying in the coffers of the bank. Therefore, if the petitioner is so willing, can approach the bank at any point in time to take the amount of 1 crore.
To be directed, sir, is
And I can't, ಅವ್ರಿಗೆ ಬೇಡ ಅಂದ್ರೆ?
No, with the current interest, my lord.
ಅವ್ರಿಗೆ ಬೇಡ ಅಂದ್ರೆ ಎಷ್ಟು ವರ್ಷದಿಂದ ಇದೆ ಅದು?
Sir, 2019.
2019.
Amount. 2-3 ಸತೆ
We filed rate.
ಒಂದ್ ನಿಮಿಷ. ಏನ್ ಮಾಡಿದೀರ ಅದನ್ನ?
2-3 ಸತೆ they have gone.
ಒಂದ್ ನಿಮಿಷ. ಏನ್ ಮಾಡಿದೀರ ಅದನ್ನ?
It is deposited in the bank, so it is
SB.
just lying.
SB account, suspense account ಏನು?
Suspense account. SB account it is not available. ಅವರೆಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ.
ನೀವ್ ಯಾಕೆ ತಗೊಂಡಿಲ್ಲ?
They should notice to the advocate, not party.
ನಿಮಗೆ ಕೊಟ್ಟೇ ಇಲ್ಲ ಇಲ್ಲಿವರೆಗೂ ನೋಟಿಸ್?
They have gone to their house.
Along with interest.
Please.
ಅಲ್ಲ,
Bank has utilized the amount, no?
it is not, it is kept in suspense accounts.
No, there is no suspense about it, we'll see.
Check ಮಾಡಿ ಇಟ್ಟಿದ್ದಾರೆ, ಎಷ್ಟು ಸತಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಬೋದು ತಗೊಂತಾ ಇಲ್ಲ. 3 times it was been requested.
Where are the notices issued? ಕೊಡಿ.
What is this?
Where are the notices issued to him to come and collect the amount?
Right now I don't have.
Right now I want it. Otherwise, right now interest.
I'm so sorry. But the thing is, it was requested. Continuously it was requested.
Orally phone ಮಾಡಿ ಹೇಳಿದ್ರೆ ಏನಾಗಲ್ಲ ಕೆಲಸ.
ಮನೆಗೆ ಹೋಗಿದ್ದಾರೆ ಸರ್. ಮನೆಗೆ ಹೋಗಿ requesting them to collect the money.
ಲೆಟರ್ ಇದೆ ಮೇಡಮ್. Why don't you put everything in paper? ಮನೆಗೆ ಹೋಗಿ ಕಾಫಿ ಕುಡ್ಕೊಂಡ್ ಬಂದ್ರೆ ಆಗಲ್ಲ.
That is true, but since it is lying and
ಬರ್ಕೊಳ್ಳಿ.
and
ಮುಂಚೆ ಬರ್ಕೊಳ್ಳಿ. The learned counsel appearing for the respondent bank submits that the petitioner be directed to approach the bank and take the amount that is lying, take the amount that is payable to the petitioner that lying with the bank for the last 6 years. The learned counsel would further submit that the petitioner has been notified on plethora of occasions to come and collect the amount and he has not collected the same. Therefore, the bank is not liable to pay any interest on the said amount as it has been lying in a suspense account. There is no document, the learned counsel for the petitioner would dispute the position, contending that no notice was ever issued to the petitioner to come and collect the amount. It may be that the counsel representing the petitioner was told that would not be in consonance with law. The respondent bank has not placed on record any document to show that petitioner has been issued a notice to come and collect the bank. In that light, the petitioner becomes entitled to interest at bank rates from the date that the amount fell into the account of the bank till the amount falls into the account of the petitioner. Ordered accordingly. ಇಟ್ಕೊಂಡಿದ್ದೀರಲ್ಲ ಮೇಡಮ್?
Nominal
ಈಗ
interest.
ಅವರು ಡಿಫಾಲ್ಟ್ ಮಾಡಿದ್ರೆ ನೀವು ಎಷ್ಟು ಇಂಟ್ರೆಸ್ಟ್ ಹಾಕ್ತಾ ಇದ್ರಿ?
Sir, default agide, that is different, is
ಆಗಿದೆ
closed now.
ಅಲ್ವಾ?
But in spite of repeated.
ಇನ್ ಸ್ಪೈಟ್ ಗೆ ಇಲ್ವೇ ಇಲ್ಲ. There is no
Right now, I
spite.
don't have the document, that is true, sir. But from 2009.
No, I am only doing what you will do. ಅಷ್ಟೇ. ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಸುಮ್ಮನೆ ದುಡ್ಡಿದ್ರೆ ಇರುತ್ತಾ ಇಲ್ಲ?
Minimum interest may be.
ಅದೇ ಬ್ಯಾಂಕ್ ರೇಟ್ಸ್. ಇಂಟ್ರೆಸ್ಟ್ ಅಟ್ ಬ್ಯಾಂಕ್ ರೇಟ್ಸ್ ಅಷ್ಟೇ. Ordered accordingly.
Cell number 31, Prashant S. Osmani, Viresh Pudia.
ಇದೇನ್ ಮಾಡಿದ್ರಿ? Dust tax.
Those my lord, their my lords in Bengaluru, those matter, lords, it is the builders or the my lord, real estate companies, lords, that have approached for my lords approval of the layout. Here what has happened, it is a developed layout now.
ಎಲ್ರಿಗೂ ಇದೆ ಅದರಲ್ಲಿ, that don't go by the cost title.
Because my lords, the entire layout my lords has been handed over to the municipality with my lords certain conditions. My lords, may I just pass on my lords that
ಈಗ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಬೇಡವಾ?
ಅಲ್ಲ, ಎಂಟ್ರಿ ಮಾಡೋ my lords, because
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಬೇಡ.
ಅಲ್ಲಿ ಏನಿದೆ ಅಂತಂದ್ರೆ there is no my lords provision for asphalt road, UGD and dust bill. That are the major amounts my lords in the demand that they have sought. 2 lakhs and odd my lords is asphalt road, 70,000 for dust bin.
What is your source of power to do it, sir?
My lords, but this is not the statutory exercise of power, my lords. This is my lord. But the roads in Lali. I'm laying down the roads. But
on roads,
my lords kindly consider this. My lords kindly consider this, my lord. If because of 2 petitioners or 1 petitioner, if at all the jungle remains to be a jungle,
it's not a jungle.
I'll show the photographs. I'll show the photographs, my lord. But the petitioner wants to buy a property.
Why jungle mein ghar?
Nothing is there.
This is what my lord, my friend is portraying. But I'll just my lords pass on. What was the condition when my lord this property was handed over to the municipality? This is my lords the
ಮುನ್ಸಿಪಾಲಿಟಿ ಇಷ್ಟೊಂದು ಕೆಲಸ ಮಾಡ್ತಾರಾ?
ಅಲ್ಲ,
may I my lords
photographs ನೋಡಿ ಸ್ವಾಮಿ.
Request my lords to kindly see.
A submission is being made that the land is identical to the land that was in question before the honorable court. But there is no road. But there are indeed 2 layouts.
What is the thing here?
But
you have purchased a property here.
Please, andre original purchaser has purchased the property. My lords, a person who was developing the layout, developed it to a little extent, and then my lords, he escaped.
No.
Now, my lords,
the document may kindly.
ಒಂದು ನಿಮಿಷ ತಡಿ ಸರ್, ಪೂರ್ತಿ ಮುಗಿಸ್ಲಿ ಅವರು.
So now, my lords, it is not humanly habitable. There is no road. There is no, my lords, nothing is there. So now what we are doing, my lords, we have to lay down we have to do the roads, my lord, because the space is there. We are laying down the roads. We are laying down the sewerages. My lord, for what all that I'm spending the money? I'm not sitting on a gold mine, my lords. I can spend the money. His developer should have done it and should have given the property to him.
ನೀವು ಕೆಲಸ ಮಾಡಿ. You deposit, which will remain subject to the outcome of the petition. Please. You can start construction.
Lords, the amount, my lord, that they are now.
5 lakhs.
I have not yet even, my lords, put a brick on the, my lords. Now suddenly, my lords, if I'm
a brick on the wall. Yes.
Therefore, my lord, I'll deposit, my lords, whatever, my lords. I'm only disputing, my lords, the 70,000 for the dustbin.
You stay ilva ille.
In fact, my lords, this honorable court had directed them to issue me the permission, construction permission, and I had submitted that whatever amount the.
No, you deposit here in the court.
I am lords request. So 50% of that amount.
No, you deposit the entire amount here. ಅವರು ಕೊಡೋದು ಆಮೇಲೆ ನೋಡೋಣ. Subject to outcome, you give permission aವಾಗ.
Please, no, let him deposit, and within 2 or 3 days, my lord, I'll take instructions. I will give whatever permissions are required, my lords.
Since my lords, 5 lakhs, my lords, initially, my lords.
Deposit ಮಾಡಿ sir. Court ಅಲ್ಲಿ deposit ಮಾಡಿ.
May I request, my lord, 50% of that amount, my lords, I'll deposit.
You deposit the amount in the court. We will not permit them to take it.
Arranging the funds for deposit as well as not now to start construction also. That is my difficulty.
The part of construction. Deposit is part of construction.
The heads, my lords, on which they are seeking, there is.
We'll see. We'll behead those heads later. You deposit before the court.
It's a difficulty was, my lord.
ಈಗ ಮತ್ತೇನು?
Please.
ಅವ್ರಿಗೇನು ಕೊಡಕ್ಕೇನು ಹೇಳ್ತಾ ಇಲ್ವಲ್ಲ?
ಅಲ್ಲ, ಅಂದ್ರೆ ಚಲನ್ ತುಂಬಬೇಕು ಸ್ವಾಮಿ. ಚಲನ್ ತುಂಬಿದ್ರೆ ನಾವು ಅದು ಪ್ರೊಸೆಸ್ ಮಾಡಬಹುದು. ದಟ್ಸ್ ಓನ್ಲಿ.
ಈಗ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ, ಏನು ಪ್ರೊಸೆಸ್ ಮಾಡ್ಬೇಕು ಮಾಡಿ.
Please.
Initially, my lord, 5 lakhs would be a little difficult.
ಎಷ್ಟಿದೆ?
5 lakhs, my lord.
Correct.
50% of that.
I'll grant you 4 weeks time. You deposit. Subject to that, I will direct them to pass. Either they will withdraw the permission midstream.
Lords, my only submission here, my lords, is the 2 lakhs and odd, my lords, is
What
for
are
the-
you?
My lords, I am, my lords, a legal officer in a corporation.
ಯಾವ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ? ಯಾವ 2 weeks ಸಾಕ?
6 weeks, my lords.
ಅದು ಬೆಳಗ್ಗೆನೆ ಕೇಳಿದ್ರೆ ನಾನು ಕಳ್ಸೇ ಬಿಡ್ತಾ ಇದ್ದೆ ಇಷ್ಟೊತ್ತಿಗೆ. Which corporation? Seriously? All right. Deposit before the court. 4 weeks?
Please.
4 weeks.
My lord, can you take me issue manual because I can't do it computerized, my lord. ಚಲನ್ ಆಗಿರೋದಿಲ್ಲ.
Manually-ನೇ.
ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ರೆ ನಾವು.
ಏನಂತ?
Manual.
ಆನ್ಲೈನ್ ಅಲ್ಲಿ.
Because it has to be done online, my lord.
ಏನ್ ಬೇಕು ನಿಮ್ಗೆ ಈಗ?
No, the direction to issue online permission.
No, I will do it.
Manual
Yes.
permissions.
The petitioner is before this court seeking the following prayer. The issue is with regard to the imposition of imposts, IMPOSTs, imposts on various heads by the corporation, by the municipality, by the corporation upon the petitioner to permit him construction of the house. House
Residential house.
Construction of a residential house. The determined value is at 5,32,000. Therefore, there shall be an interim order of stay and a consequent direction to the respondent corporation to permit to issue,
manual,
to issue
construction
manual building commencement. What do you
building
call it?
Building permission.
The issue building construction permission either manually or electronically as the case would be, subject to the condition that the petitioner would deposit
5,454 rupees.
5,454 rupees before this court in the next 2 days, 2 weeks.
4 weeks.
In the next 4 weeks, yes. List the 4 weeks between date kodi.
Let them, my lords, issue the permission. I'll deposit.
ಹೇಳ್ದ್ನಲ್ಲ ಈಗ.
No, because now the interest rate of home loan, my lords, is going to be get converted into commercial. That's
ಕೊಟ್ಟಿದ್ದೀರಾ? Yes. ಅದಕ್ಕೆ ಹೊಡೆದಾಡಬಾರ್ದಲ್ಲ. Discretion is the best part of valor. Yes. Two
230 board list number 2, serial number 1, Sirajuddin Ahmad.
ಈಗ ಕಾಂಬ್ಳೆದು ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಪೆರೋಲ್ ಕೊಡೋದು ಬೇಡ ಇವ್ರಿಗೆ? 302.
302 ಕೊಡಿ.
ಮತ್ತೆ ಯಾಕೆ what is the problem now?
ಅದು applications were made by advocate ಎಲ್ಲ ಇದ್ದಲ್ಲ.
ಅದಾ ಇದು. The petitioner is before this court seeking release of his brother on grant of parole. Heard so and so. The brother of the petitioner gets embroiled in a crime which is tried by the court of session and is convicted for offense punishable under section 302 of the IPC and has been in prison for the last 8 years and 9 months. The petitioner has moved the matter seeking grant of parole on the score that the petitioner's daughter is getting married and the presence of the convict, the brother of the petitioner, is necessary to perform the obligations of the family and certain rituals. The learned AGA on instructions had submitted that the application was not submitted by the convict or the family of the convict but by the council. Now the application is said to have been submitted by the present petitioner.
By virtue of the honorable court order, my lords, we have written to the, my lords, asked the concerned SP to submit a report. ಈ ಕೇಸಲ್ಲಿ await report ಇದೆ, but because of marriage, my lords.
So and so. The application is on record. The invitation of marriage as observed herein above is also appended to the petition. In that light, I deem it appropriate to grant the petitioner parole for a period of 30 days from to commence from day after tomorrow. Commence from the morning of day after tomorrow.
13th marriage ಇರಬೇಕು. 13th marriage ಇರಬಹುದು.
For 13th to commence from tomorrow. ಇವತ್ತು urgent ಮಾಡ್ಬಿಟ್ಟಿದೆ. So commence from tomorrow, 30 days from tomorrow. Yes.
Serial number 2, Prashant is first money.
ಅದು ಸೇಮ್ ಕಂಡೀಷನ್ಸ್ ಪೆರೋಲ್ ಇದೆ. Yes.
Petitioner, my lord, president of a cooperative society. Lord, for the year 2023-24, AGM was to be conducted. For that, my lords, to fix the date for the AGM, my lords, a meeting was called. Only out of 12 members, my lords.
Term ಎಲ್ಲಿಂದ ಎಲ್ಲಿವರೆಗೆ?
Its term, my lords, it's still existing. It's still existing. Yes. That is not an issue. Now, my lords, when the meeting was called to fix the date for conducting the AGM, lords, only 4 persons, including this petitioner, only 4 persons attend the meeting. Others, vice president and a few of his followers, my lords, do not. Instead of attending the meeting here, my lords, they go to the ARCS, assistant registrar, and file a complaint that
HCG 1, 2, 3, 4 HCGP 5 and 6 emergent notice returnable by the 21st till such time interim order is spread for. Next.
Serial number 3, Shashank S. Hegde.
3, yeah.
My lords.
Ah.
My lord, we pray. It's an income tax matter. Similar matters have been stayed by this honorable court. I just draw your attention to Lecture A, my lords.
Tag same order. Yes, next.
Serial number 4, SM Mamdapur.
ಏನು ಎಜಿ?
To appear for petitioners, my lords. That's one. My rights as my landowner's rights were confirmed by the honorable order of the apex court, my lords, annexure K, Supreme Court.
Legal protest. Who is protesting illegally, sir?
The agriculturists, my lords, belonging, because they have lost their lands, my lords, litigation.
All right.
Annexure K may kindly be seen, my lords. By virtue of this order of the honorable apex court, my rights were confirmed, my lords.
All right.
Now what has happened is, having lost the litigation, they are terming me as traitors, my lords. Your Honor may kindly see the pamphlet.
Terming you as traitor.
The people protesting there, my lords, in front of a government office.
Poor agriculturists will turn you.
No, please, my lords. My lords may kindly see annexure D, my lords, page 19.
Copy ಕೊಟ್ಟಿಲ್ವಾ?
Served the copy, my lords. I've served.
Served ಅಲ್ಲ 2:30 ಮೂವ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲಿ ಕೊಡ್ಬೇಕು. And ಈ ಮ್ಯಾಟರ್ ಇಂದ ಕೊಡ್ಲೇಬೇಕು. I want him to know what is the situation actually.
It's causing law and order situation, my lords. The reason is that.
Law and order, don't worry. Who are you? Law and order situation will be taken care of.
No, in my name they are creating.
ಲಾಠಿ ಚಾರ್ಜ್ ಅವೆಲ್ಲ ಮಾಡಬೇಡಿ. Yes.
I've also given a representation, my lords. Let them take.
Copy ಕೊಡಿ first.
Please.
Copy ಕೊಟ್ಬಿಟ್ಟು check what is the situation. List day after tomorrow in the fresh matters.
Please.
Learned AG is directed to accept notice for the response.
Please.
Yes, next.
Serial number 5, K. Anand Kumar.
Consumer.
My lord, the respondent, my lord,
ಏನ್ ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದಾರಾ?
ಮಾಡಿದ NBW ಇಶ್ಯೂ ಆಗಿದೆ. Entire amount paid by the.
Appeal ಹಾಕಿದ್ದೀರಿ. Entire amount is paid?
Annexure E, my lord.
All right.
They have issued
emergent notice to the respondent. Respondents.
Please.
Respondent. Emergent notice to the respondent. Petitioner is at liberty to serve on the counsel who represents the respondent in the trial proceedings. A warrant of any kind hanging on the head of the petitioner shall remain stayed till the next date of hearing.
Date may
Both
be
same.
given,
List on
already
21st.
amount may
21st.
19, my lord.
6 to 10 same.
Please, my lord.
List on 19th.
Please,
19th.
Any.
Serve ಮಾಡಿ ಕರ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ.
Please.
19th. Yes.
Please.
Serial number 11, Harshavardhan M. Patil.
Premature transfer ಮೂವ್ ಮಾಡಿದ್ ಕೊಡಿ. ಎಲ್ಲೋಗಿದ್ದಾರೆ ಅಲ್ಲ ಇಲ್ಲ ಯಾಕೆ? KPTCL. Current counsel BS Kamte is directed to accept notice for respondents 2, 3, 4, 1 HCGP. Which is your last order of transfer?
Lord, annexure B, annexure A, Lord.
Page.
Page number 12, Lord.
6th February 2025.
Please.
Now impugn order.
Impugned order is page number 12.
Other previous
Earlier
order.
to that, my lord, is page number 14.
That is 11th August 23.
Please.
O&M where?
O&M, my lord, at Mudol.
ಈಗ ಎಲ್ಲಿಗೆ?
ಈಗ
ಆಡಳಿತಾತ್ಮಕ ಹಿತದೃಷ್ಟಿಯಿಂದ
Kerur branch.
ಆ ಮುಧೋಳಲ್ಲೇನಾ? ಸೇಮ್ O&M?
Yes, my lord, O&M.
ಎಲ್ಲ O&M ಒಂದೇನೆ.
ಅಲ್ಲ, from one place to another ಇದೆ.
ಅಲ್ಲ ಇಲ್ಲಿ ಚೆನ್ನಾಗಿದೆಯಾ?
No, my lord, since my lord, the wife of the petitioner is working as the government teacher in Mudhol, and the children are studying at, 3 children are studying at Mudhol. There will be inconvenience, my lords.
ಅಂದ್ರೆ ನೀವು ಎಜುಕೇಶನ್ ಮುಗಿಯೋವರೆಗೂ ಮುಧೋಳಲ್ಲೇ ಇರ್ಬೇಕಲ್ಲ?
Not like that.
ಎಷ್ಟು ವರ್ಷದಿಂದ ಇದೆಯಲ್ಲ ಅಲ್ಲಿ?
My lord, from last 18 months.
ಅದಕ್ಕೆ ಮುಂಚೆ?
ಅದಕ್ಕೆ ಮುಂಚೆ
Which cadre?
Lord, he is working as the lineman.
Group C.
Yes.
The petitioner, a lineman in HESCOM, is at the doors of this court calling in question an order of transfer dated 6th February 2025, by which the petitioner is posted from Mudhol to
Kerur.
To Kerur. The learned counsel Harshvardhan M. Patil submits that on 11th August 2023, the petitioner was posted to Mudhol, and within 18 months thereafter is now posted to Kerur in terms of the impugned order. The learned counsel would submit that the petitioner is a lineman, which is a Group C post, and in terms of the operative guidelines dated 7/6/2013 as amended from time to time, the tenure at a place of posting of a Group C employee is 4 years. Since he has not yet completed 4 years, there shall be an interim order of stay as prayed for till the next date of hearing. ಯಾರನ್ನು ಹಾಕಿಲ್ವಾ ನಿಮ್ಮ ಜಾಗಕ್ಕೆ?
ಇನ್ನು ಯಾರನ್ನು ಹಾಕಿಲ್ಲ.
Till the next date of hearing.
Grateful.
Number 12, Srikanti Patil.
ಎಷ್ಟಿದೆ
Lord,
amount?
Lord, as of my lord petitioner, it is 10 lakhs rupees, because your lordship may kindly see annexure C for a moment, page number 32.
As of the petitioner ಅಲ್ಲ, where 14 order ಎಲ್ಲಿದೆ?
As per their position notice, they say that my lord, it is 45 lakhs 26,506.
45 ಅಲ್ಲಿ 10 ಅಲ್ಲಿ.
Allah, my lord, lordship may
And I
kindly
won't
see.
sit and calculate here.
Lord, he has already made a payment, and before the DRT, the earlier position notice is already set aside. But this annexure C, my lord, in a cyclo-style way, Lord, they, for a moment, your lordship may kindly see. They
ಸೈಕ್ಲೋ ಸ್ಟೈಲ್ ಯಾವ ಸ್ಟೈಲ್ ದುಡ್ಡಂತೂ ಕೊಡ್ಬೇಕಾ?
Allah, the earlier notice is already set aside by the DRT, but they mention it that as on 10/3/2023, 45 lakhs rupees is the amount.
So according to you 10 lakhs.
Please, it is a 10 lakhs rupees.
Deposit. Yes.
I'll deposit.
The petitioner is before this court calling in question a possession notice dated 3/12/2024. Learned counsel submits that the amount that is in due is 10 lakhs, but according to the bank, in terms of the documents appended, is 45 lakhs. Therefore, there shall be an interim order of stay as prayed for, subject to the condition that the petitioner would deposit 10 lakhs before the bank in the following manner. First, 5 lakhs shall be deposited within 3 weeks from today, and the next 5 lakhs within 3 weeks thereafter. In the event the petitioner would default in payment of the first chunk as observed herein above, the interim order would stand automatically vacated, and the petitioner would run the risk of the petition itself getting dismissed. Ordered ಇಲ್ಲ. Interim order. Next.
May I request for hand delivery, my lord, because they are coming, my lord, tomorrow for position.
Invite them. Yes.
49, Nagangoda M. Patil, MG Kulkarni.
My lord, the petitioner herein was working in a respondent bank, my lord, and he was dismissed from service, my lord.
Dismissed?
Yes, my lord.
Why, sir?
On the ground of misconduct, my lord. And leave encashment has been withheld, my lord, since from the year 2014, my lord. And the petitioner made a representation to the respondent bank, my lord, but he denied to pay the.
Employee leave encashment ಬರಲ್ಲ sir.
No, my lord, there is a covered by decision, my lord, regarding that, my lord.
Dismissed employee or compulsory retired?
No, my lord, dismissed, my lord. Even my kindly be seen.
Regulations ನೋಡಿ sir.
Sir, relevant, Your Lordship, relevant regulation is
Citation.
67, Your Lordship.
ಏನು?
Regulation 67 is more relevant here.
ಹಾ.
It doesn't stipulate insofar as payment of encashment in the cases where dismissal takes place.
My lord,
Sir, dismissed employee would lapse all his leave.
Page number 16 may kindly be seen, my
Sir,
lord. Para number,
Jitendra Kumar Srivastava's gratuity.
even it is also observed, my lord, regarding a leave encashment. May kindly be seen, para number 16, my lord. This, my lord.
Leave encashment, I doubt.
Yes, my lord. Here, the person not be deprived by the, deprived of property saved by authority of a law. No person shall be deprived of this, of his property saved by authority of law. Once we proceed on that premise, that answer,
But,
here
sir,
it is observed, my lord.
Inquiry was pending there. There was no imposition of penalty.
No, my lord, still, my lord, even, my lord, we made a petition for that, my lord. Still, it is pending for consideration before this honorable court, my lord.
Regulations, can any court pass an order contrary to the regulations? Regulation 67 nodi.
But it is
67,
nowhere,
which is
no,
akin to other banks regulation, which clearly says on dismissal, an employee would, the leave that is in his credit would lapse, and leave encashment, it is a collection of leave at the end.
but even, my lord, it's nowhere
Nowhere
stated
what?
that, my lord, bank has a right to deny the leave encashment, my lord.
67 nodi, sir.
Please, my lord.
Regulation 67 ilva?
Yes, my lord, it is there, my lord.
Lapse of leave ಅಂತ ಇರ್ಬೇಕು ನೋಡಿ.
Yes, my lord.
ಹಾ.
All the leave lapse on the death of here. The provide also in respect of employee where the service are terminated owing to retrenchment.
Yes.
He shall pay or allowances for the period of privilege leave at his credit.
Termination
Terminate.
on account of what? ಎಲ್ಲಿ ಕೊಡಿ. ಅದು ಕೊಡಿ, book ಕೊಡಿ. What is he reading? All, if I am known. ಅಲ್ಲೇ ಇದೆಯಲ್ಲ.
My lord, may kindly be seen, my lord.
Leave shall lapse on the death of an officer or employee, or if he ceases to be in the service of the bank, provided so and so, so and so, so and so. Proviso also in respect of employees where his services are terminated owing to retrenchment, he may be paid pay and allowances for the privilege leave at his credit.
Another
Dismissal
another
from
decision.
service.
Dismissal.
Yes, my lord. May
Financial
kindly be
fraud,
seen, my
Your
lord. Even relevant case, my lord. May kindly be seen, my lord. Para number 8, my lord. Similar case, my lord. May kindly be seen. Please, my lord. This case, here, my lord. Para number 8, my lord. In the case at hand, there is absolutely no provision in the regulation of bank where under claim of petition for leave encashment can be withheld on the ground that they have been penalized. If that be so, respondent number 3 was not right refusing the claim of petitioners for the amount of leave encashment as well as was admissible to them, my lord. Which is absolutely says that, my lord, the respondent bank has no right to deny the leave encashment, my lord.
Compulsory retired. Compulsory retirement ಬರುತ್ತೆ.
Yes.
Let me
My
see,
lord,
do some more research and come.
One short date may kindly be
Friday.
given. Please, my lord.
ಆಗುತ್ತಾ? ಇಲ್ಲ
Please.
Monday ತಗೊಳ್ಳ.
Please, my lord. Sure.
Monday
Friday.
fresh matters.
Please.
You'll get something, do some more research.
Please.
Yes.
Bill number 50, Girish V. Bhatt, AP Murari.
Permit,
Conviction stayed.
That has been stayed, my lord. Conviction has been stayed. And I have sought for interim direction to reinstate him into the post.
Conviction stayed.
Yes. Sentence, initially sentence was suspended.
Suspension of sentence is your right. Conviction stay is an exception. That's all.
This is stayed.
Exception, rarest of the rare cases.
Yes.
Only in case, generally in case of legislators who would lose their seat on getting convicted.
Please.
Matra, otherwise.
order copy express.
That page 12 may kindly be seen for a minute, my lord. It's a considered order. Impugn judgment of conviction dated 21/10/2024 and order of sentence so appellant accused is concerned. Is stayed
ಇಷ್ಟೊಂದು ಆರ್ಡರ್ ಇದೆ.
till the page number 12 is the operative portion. Ink page 12, my lord. Internal page 9 of the order.
Conviction and sentence both.
My only submission is 3-4 days time.
ಏನ್
The
ಮಾಡ್ತೀರಾ?
reason is I sent the
Objections,
statement of objections. ಅದು ಬಂದಂತ form ಮಾಡಿ. I don't know.
ಮಾಡು ಪರವಾಗಿಲ್ಲ.
Please, the difficulty with orally ಅದು quarters ಖಾಲಿ ಮಾಡಿಸಿದ್ದಾರೆ ಅವನು ಮತ್ತೆ ಬೀದಿ ಬಂದ್ಬಿಡ್ತಾನೆ. At least he has continued in the quarters at least to that extent.
ಅದ್ ಮಾಡ್ಬೇಡಿ. ಕ್ವಾರ್ಟರ್ಸ್ ಯಾಕೆ ಖಾಲಿ ಮಾಡಿಸ್ತಾರೆ?
Quarters ಅದ್ರ ಬಗ್ಗೆ ಏನು reference
ಅದ್ರ ಬಗ್ಗೆ ಇಲ್ಲ ಅಂದ್ರೆ
ಅಲ್ಲ pursuant to this development
ಡಿಸ್ಮಿಸಲ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಅಲ್ಲ ಇಲ್ಲ ನಿಜ ಬಟ್ ಅಲ್ಲ
ಕಳಿಸಿದ್ದಾರೆ. Yesterday only I have sent it.
why
Parawise remarks ಕಳಿಸಿದ್ದಾರೆ.
Don't evict him till Monday.
ಆಯ್ತು ಹಂಗೆ ಓಡಲಿ.
Learned counsel Shri A.P. Murari seeks a week's time to file statement of objections. The objections, if any, be filed by the 19th of February 2025, list on 19th in the fresh matters list. Learned senior counsel S.S. Yadrami submits that the petitioner is now sought to be evicted from the official quarters. Therefore, till the matter is heard.
Unless he is not evicted. No.
Therefore, till the matter is heard, the petitioner shall not be evicted from the official quarters if not already evicted.
Please.
Please.
ಅದು ಪೂರ್ತಿ ಬರೆಯೋರು ಕೇಳ್ಬೇಕು.
ಇಲ್ಲ ಮೇಲೆ ಸಾರಿ ಮೇಲೆ
51 urgent, 52 14th person Sarvesh Narsimha Desai.
ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
I am from Bangalore.
You are from
Vishnu
Bangalore?
Swami is there. I am appearing on behalf of the petitioner 1 and 2.
On behalf ಅಲ್ಲ, ನೀವೇ petitioner.
ನಾನೇ petitioner. I do agree. On the other hand, in this particular case, the judicial pronouncements delivered from this honorable court have been violated from time to time. I can, beyond your imagination, I can give any information, any this thing. Orders of the double bench has been violated.
Respondent.
My lord, I have taken instruction, my lord. Next week's time. Week's time.
ಈ ಕರೆದಿರೋದು ಯಾವುದು? ಇವ್ರು 14 ಪರ್ಸನ್ ಅಲ್ವಾ? ನರಸಿಂಹ ದೇಸಾಯಿ ಇವರೇ ಅಲ್ವಾ?
59 ಅಲ್ಲ 14%. ಸಾರಿ,
ನಿಮ್ಮ ಹೆಸರೇನು?
ವಿಶ್ವನಾಥ ಸ್ವಾಮಿ.
ಅಲ್ಲಿಗೆ ಬಂದಿಲ್ಲ.
From Bangalore I have come down.
You may have come. Case has not yet come there. 1 minute.
Okay, Maharaj.
We are at 52.
Please let me know that. Okay.
I will announce it. Yes.
Very good. Sorry.
Oh. ನೀವು ಇದರಲ್ಲೇನಾ?
Yes.
My lordship,
ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ, ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿ.
Sir, there is one more, some more documents I got it through filing the RTI, which are very crucial.
Crucial?
Yes, sir. It shows that the supplemental claim is based on the go live date considering as 24th November 2011. But the respondent number 1 office, that is HESCOM Limited, the corporate office, through their PIO, provided the information that the Hubli Dharwad Belgaum town went go live on 2016 March. So
those crucial documents.
It is submitted as additional documents.
ಅವರು ಕೊಟ್ಟಿದ್ದೀರಾ ಕಾಪಿ?
Yes.
File ಎಲ್ಲ. You file objections on all documents, crucial or otherwise. The learned counsel appearing for the respondent.
We have filed objection.
Already filed?
No. We will file one.
We will. Yeah. The learned counsel appearing for the respondent seeks a week's time to file statement of objections. List the matter on 21st. Objections, if any, by the next date of hearing. Interim order subsisting will continue till the next date of hearing.
Number 53 HN Kuda Reddy.
appearing to the petition, Lordship. Premature release, Lordship. Last date of hearing on 11/12, 15 days had given,
Already
Lordship,
recommended.
for extension. 14th is going to be expiring.
One ನಿಮಿಷ sir.
Already recommended, my lord. This case is recommended for
Premature release.
Lordship has granted him parole, my lord.
Parole
15 days.
ಕೊಟ್ಟಾಗಿದೆಯಾ?
ಕೊಟ್ಟಾಗಿದೆ. 15 ದಿನ ಕೊಟ್ಟಿತ್ತು, Lordship.
We will extend it.
Fine, Lordship. For another 45 days, Lordship. 15 days had given.
In terms of the order dated 22/1/2025, had extended the parole granted on 25/1/2025 for a period of 15 days, which would come to an end on 14/2/2025. The learned AGA on instructions would submit that the case of the petitioner has been recommended for premature release and premature release. In that light, I deem it appropriate to grant the petitioner parole for another 60 days, reserving liberty to the petitioner to seek extension at the hands of this court. Yes, sir.
54, Kiran Kumar Chettiman.
Petitioner, my lord, on 2/6/2022, my lord.
Let's consider consider representation, my lords. ಬೇಕಾದ್ರೆ
ಏನಿದು?
ಅದು ಶಾರ್ಟ್ ಸರ್ಕ್ಯೂಟ್ ಆಗಿ ಅವ್ರದ್ದು ಶಾಪ್ ಇದಾಗಿದೆ. ಎಸ್ಕಾಂ ದವ್ರ ಮೇಲೆ ಇದು ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಅವರು. ದಿ ಸಾರ್ಟ್ ಮಲೋಡ್ಸ್ ಫ್ರಮ್ ದಿ ಗವರ್ಮೆಂಟ್. ಶಾರ್ಟ್ ಸರ್ಕ್ಯೂಟ್ ಆಗಿ ಅಲ್ಲಿ ಆಗಿದ್ರಿಂದ ವಿಲ್ ಕನ್ಸಿಡರ್.
Compensation ಕೊಟ್ಟಿಲ್ವಾ ನಿಮಗೆ?
No, my lords.
Why?
The Tahsildar, my lord, respond number 2 has not taken any action, further action, my lords.
ಅಲ್ಲ,
The respond number 2, my lords.
ಯಾರು ಬೆಸ್ಕಾಂ ವೈರ್ ಇದಾಗಿದ್ದ?
ಅಲ್ಲ, ಎಸ್ಕಾಂ ದವ್ರು ಅವ್ರು ಮಾಡ್ಬೇಕಾಗತ್ತೆ.
ಅಲ್ಲ, how did the injury happen? Injury death?
ಇಲ್ಲ, ಓನ್ಲಿ ಮಲೋಡ್ಸ್ ಶಾರ್ಟ್ ಸರ್ಕ್ಯೂಟ್ ಆಗಿ ಆ ಶಾಪ್ ದಲ್ಲಿ ಆರ್ಟಿಕಲ್ಸ್ ಎಲ್ಲ ಇದೆ ಅಷ್ಟೇ ಆಗಿದೆ.
Damage.
How much?
More than 10 lakh, my lords.
Claim it against
ಅದೇ ವಿಲ್ ಕನ್ಸಿಡರ್ ಅಂಡ್ ಪಾಸ್.
ಶಾರ್ಟ್ ಸರ್ಕ್ಯೂಟ್ ಅಂದ್ರೆ ಇವ್ರದೇ ತಪ್ಪಿರುತ್ತೆ.
ಅದೇ ವಿಲ್ ಕನ್ಸಿಡರ್ ಮಲೋಡ್ಸ್ ಅಂಡ್ ಪಾಸ್.
Representation. The petitioner is before this court seeking the following prayer. Heard so and so. An accident happens on 2/6/2022 in Appaji Palace Bakery. Nimda.
Petitioners.
In Appaji Palace, petitioner sir, nimda advocate. The Appaji Palace Bakery owned by the petitioner. The petitioner said to have informed the third respondent. The electrical inspectorate appears to have submitted a report against the officials of Bescom.
Please, my lords.
Against the officials of Bescom.
Hescom.
Officials of Hescom.
Respond number 3 and 4.
And therefore, the petitioner submits a representation to the state to take appropriate action upon the report. Non-taking of the action has driven the petitioner to this court in the subject petition. The learned AG on instructions would submit that the representation of the petitioner would be considered and appropriate orders would be passed in accordance with law if reasonable time is granted. In the light of the said submission, without going into the merit of the claim of the petitioner, I deem it appropriate to dispose the petition, directing consideration of the representation/complaint of the petitioner in accordance with law within an outer limit of 3 months from the date of receipt of the copy of this order, if not earlier ordered accordingly. Yes, next.
Cell number 55, Rashmi P. Mandi, SK Kulkarni.
My lord, again, the respondent is seeking time to come back with the terms of settlement. He is considering about the quantum of settlement amount, my lord.
How long do you take, madam?
He is seeking about 2 weeks time, my lord.
Oh, 2 weeks, avagale 6 weeks ಆಯ್ತು.
At least a week's time may be granted, my lords.
List the matter on 19th in the fresh matters list at the request of the counsel for the petitioner, who submits that the talks of settlement between the parties are still afoot. AFOT. Yes.
My lords, interim order.
Interim order subsisting would continue to the next date. Next.
Much obliged.
Shivraj P. Mudho.
May I request, my lord? May I request, my lord, any date, my lord?
Any data? Bad ಇವತ್ತು.
Condition, my lords. Tender
matter, my lord. The condition, my lord.
Modification ಮಾಡಿದ್ದೇನೆ.
Yes.
List the matter after 2 weeks.
Yes.
Covered against him alva.
Oh, against him.
ಕೊಟ್ಬಿಡಿ ಮುಗಿಸ್ಬೋಣ. ಅದೇ ಶಕ್ತಿ ದಾಲ್ ಸೂರತ್ ಸರ್ ಇವತ್ತೇ ಮುಗಿಸ್ಬೋಣ ಯಾಕೆ ಫ್ರೈಡೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್
ಸರ್ ಮಗಳ ಮದುವೆ 15ಕ್ಕೆ
ಮಂಡೇ
17th or 18th?
18th ಯಾವತ್ತಿದ್ರು ಅದೇ ರಿಸಲ್ಟ್. ಎಸ್
57, Sabil Ahmed, MB Hireman.
Order granted by this court is compliant.
I'm sorry. Interim order may can be.
Order granted by this honorable court is compliant and last date.
Complied.
Let's interim order was granted on the notion that the outstanding due is of 26 lakh, out of which 17 lakh is already deposited.
Paid.
Yes, and 1 lakh was directed to be paid. However, the out of 26 lakh, original borrowed loan was 26 lakh mullets. After that mullets, he has defaulted the loan for the five times mullets. Then mullets, he in total he has paid 17 lakh till date. Not he has deposited 17 lakh rupees. Till today, the outstanding due is around 27 lakh mullets.
Next deposits.
Lordship's direction, mullets, I comply. Moreover, mullets, I am ready to settle the entire amount at once.
Moreover, ಆಮೇಲೆ
Please.
first to deposit.
Lordship direction, I will be.
Borrower will say, I have 3 months time ಕೊಟ್ಟರೆ settle ಮಾಡು.
No, mullets, I'll obey about your lordship's conditions.
Yes.
Let's order 14 is under section 14. Order is also passed. That is not called in question in this.
Don't worry, take this. Another ಏನ್ ಕೆಲಸ ಮಾಡ್ತೀರಾ?
Lord, cycle shop business man, cycle shop.
ಇದು ಏನ್ ನಡೀತಾ ಇದೆ ಇಲ್ಲಿ?
ನಾನು ಮನೆಗೆ ಮೇಲೆ ಲೋನ್ ತಗೊಂಡಿದ್ದು.
ಓ ಸೈಕಲ್ ಶಾಪ್ ಬಿಸ್ನೆಸ್.
ಸೈಕಲ್ ಶಾಪ್ ಬಿಸ್ನೆಸ್. 4 ಲೋನ್ ಟೋಟಲ್ ತಗೊಂಡಿದ್ದು, ಒಂದು ಮನೆಗೆ, 2 ಬಿಸ್ನೆಸ್ ಗೆ, ಮತ್ತೊಂದು ವೆಹಿಕಲ್ ಪರಿವಾಹನ್ ವೆಹಿಕಲ್ ಲೋನ್. Total 4 loans are clubbed together.
Clubbed together it is 26 lakhs.
Yes, please, your lordship.
27 lakh. 27 lakh and odd.
ಆಯ್ತು. Now we will pay another ಈಗ EMI skip ಆಗಿರೋದು ಯಾವಾಗಿಂದ?
COVID, total COVID 2020 February.
20.
COVID.
So 4 years ಅಂದ್ರೆ ಜಾಸ್ತಿ ಆಗಿದೆ. I can't show you so much of lenience. ಒಂದು 2.5 lakhs pay ಮಾಡಿ. 6 weeks please. Cycle shop.
Let's.
Yes. Catch big fish. Yes.
Please, your lordship.
Let's my submission supposing the same may be recorded.
Huh?
My submission opposing the same to deposit them.
Of course I will. Yes.
Please.
The learned counsel SR Gayatri, right?
Yes, Manoj. I am filing Vakal.
Gayatri SR appearing for the respondent bank would vehemently oppose entertainment of the petition itself. According to her, this court should not entertain the petition in the light of the judgment of the apex court in the case of Bafna so and so. The learned counsel would further vehemently oppose extension of the interim order, contending that the interim order is taken on an erroneous premise that 17 lakhs is paid. The learned counsel of the petitioner submits that he owns a cycle shop and is not in a position to clear the dues immediately, but however will make all-out effort to clear the dues of the bank, as there are 4 loans put together. The amount has the default has arisen. In that light, I deem it notwithstanding the said vehement opposition, I deem it appropriate to extend the interim order subject to the condition that the petitioner would pay the bank another 2.5 lakhs in the next 6 weeks. In the event the petitioner would not deposit the said amount, the interim order would get vacated and the petition itself would be dismissed. 6 weeks ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ.
Please, your lordship.
ಸಾಕಾ ಮೇಡಮ್?
Please, your lordship.
Seal number 58.
Why is Gangadhar waiting? Yes, sir.
Girish is full money.
Oh, 345. ಯಾವ್ದು 330 ಗೆ? Amit Kumar Deshpande.
My lords,
1 minute. I'll just finish the fresh matters and take it. Yes.
58.
Lords, I am for the petitioners, my lords. I have challenged the annexure B order.
Girish, ಏನಿದು?
Lords, the petitioner has no locus standi, my lords, for the reason that he has already sold the mortgage property in favor of other person, and he has also annexed the sale deed, my lords.
Original borrower.
Please, my lords, I was the original borrower for sum of rupees 60 lakhs, my lords. It was a second charge created on the.
Now you have taken possession of which property?
The same property.
You have already sold.
Lords, I did not sell, my lords. It was created only for the purpose of.
Then go before the DRT, sir.
Annexure G, my lords.
It was,
Salaried.
my lords, they have initiated
himself
DRT
has sold the
proceedings also, my lords. Even that is pending in from the
Surface
year
proceedings
2000.
initiate ಮಾಡಿದ್ದೀರಾ?
From the year
ಅದನ್ನ
2015.
ಎಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ?
Let's, the OA is pending before the DRT, my lords, which has been filed by the
OA.
bank.
OA.
Please, my lords, OA.
Solid. ಅಲ್ಲೇ ಮಾಡಿ.
My lords,
Dispute
with my
questions of
original
fact, I will not interfere.
My lords, with my original documents, they have given the loan for 2 persons, my lords. During the subsequent.
You agitate that there, sir. Before the DRT.
The primary ground is that, my lords, he himself has,
ಎಷ್ಟು ಜನಕ್ಕೆ ಲೋನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
my lords, there were two loan accounts, my lords.
Same property.
Yes, my lords.
How did you grant?
My lords, the fictitious sell deeds has been created, and by hiding the fact, my lords, that, my lords, not by the same branch, by the different branches, my lords.
That's all right. How did they do grant it?
My lords, the, on the,
Due diligence did you do? Branch in the branch ಗೆ coordination ಇಲ್ವಾ?
my lords, it is always there, my lords, but the fact is that, my lords, at the time of selling the sale deed, my lords, I may be permitted lordships to take annexure G, my lords, sale deed. My lords, he has sold the property in the name of the earlier firm, my lords, not the subsequent firm. My lords, annexure A,
ಈಗ ಏನ್ ಸ್ಟೇ ಕೊಟ್ಟಿರೋದು ನಾವು?
they are seeking the section 14 order, my lords,
Section 14 order.
which is not against them, my lords,
If that is
against the
implemented,
subsequent
Very
purchase.
worried subsequent purchaser ಇದ್ರೆ.
Lords, if that is implemented,
You are
because
not
my
in
lords,
possession of the property.
lords, I'm in the possession, they took possession from me itself, my lords. They have obtained the
They have
possession.
taken possession already.
They have taken the possession.
Challenge it before the DRT ಹೋಗಿಲ್ವಾ ಇವರು?
ಅಲ್ಲ ಅವರೇ OA ಇನಿಷಿಯೇಟ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಯಾರು?
ಅವರೇ SBI ಅವರೇ OA ಇನಿಷಿಯೇಟ್ in the year 2015.
You also file, sir, essay ಹಾಕಿ. ಅವರು ಯಾಕಂದ್ರೆ ನೀವು essay
Lords, because my lords, with my original documents, they have given the loan to the two members, my lords.
maybe fictitious, who knows?
Lords, now it is 2 crore 85 lakhs, my lords. They have given the loan for a sum of rupees 2
But
crore
ಇವ್ರದ್ದು
85
mortgage
lakhs.
ಆದ್ಮೇಲೆ ಇವ್ರದ್ದು ಪ್ರಾಪರ್ಟಿ ಇನ್ನೊಬ್ರಿಗೆ ಹೆಂಗ್
My lords, I will establish, my lords. My lords, earlier, the KDB has sold the property in the name of one firm, my lords, name RR and,
No.
no, my lords, in the name of
Figure.
GG Industries, my lords.
You file
It is-
file a synopsis. ಏನಾಗಿದೆ ಅಲ್ಲಿ? List on Tuesday in the fresh matters list.
My lords, entry order, my lords.
That will continue, provided you file a detailed synopsis.
Please.
Yes, list on Tuesday in the fresh matters.
Lords, Friday, my lords.
Bank officials appears to have bungled in this.
Please, my lords.
Bank appears to have bungled in this.
My lords, that fictitious name, sell deeds has been created, my lords. And without consideration.
ಒಂದೇ mortgage deed ಅಲ್ಲಿ ಇಬ್ರಿಗೆ ಹೆಂಗ್ ಕೊಟ್ರಿ ಸರ್?
My lords, it's not that, my lords.
ಅಲ್ಲ ಅವರು
I will establish, my lords, that how the things has been manipulated, and in order to reflect the name of the bank, my lords, they have created the sell deed in the name of the earlier firm which is not in existence.
ಏನ್ ಡ್ಯೂ ಡಿಲಿಜೆನ್ಸ್ ಮಾಡಿದ್ರಿ ನೀವು?
My lords, please, my lords.
ಏನ್ ಮಾಡಿದ್ರಿ? what action have you taken against bank officials?
My lords, that, my lords, way is pending, my lords, against this person recovery proceedings is pending, my lords.
ಅರೆ ಬ್ಯಾಂಕ್ officials ಮೇಲೆ ಏನ್ ಮಾಡಿದ್ದೀರಾ?
My lords, bank officials to that, my lords, there is no instructions, my lords. I'll get,
Take instruction.
I'll get, my lords.
ಇಲ್ಲಾಂದ್ರೆ ರೂಲ್ ಇಶ್ಯೂ ಮಾಡಿ ಸ್ಟೇ ಕೊಡ್ತೀನಿ.
Please, my lords.
Yes.
Great.
List on Tuesday in the fresh matters list. Entry matter subsisting will continue to the next date.
Great.
9, party in person. GM Vishwanath Swami.
Federation of Vakila Karnataka. ಏನ್ ಸರ್ ಇದು?
The case pertains to the Bedijangam case, my lord.
Bedijangama?
Bedijangam case where the, under orders of this honorable court, have been granted a caste certificate as far back as in the year 1992. The very issuance of the caste certificate has been got confirmed to a division bench of the honorable high court in the year 1993.
Now what has happened? Who are you?
Pardon? I'm the party in person there, this thing there.
Against you some order is passed?
Yes, orders have been passed against me, against the orders of the court and against me.
Second petitioner,
Q is the order.
second petitioner ಯಾರು?
Same petitioner, either, madam. He has come back, petition. Yes.
Who is, any order is passed against him?
Yes, order has been passed against petition number 2, Basaya Dangurmat.
How are you representing him?
I'm the GP holder. I'm also being given permission. I'm the representing.
Who has given permission?
Pardon?
Who has given permission?
Permission, the party and personal committee.
You are the
Yes.
General Secretary, is it?
General Secretary of the Federation also. We have given submission to the government. Government have also not properly considered our applications. And unfortunately, in spite of judicial pronouncement, orders passed by this honorable court, the concerned person, the petitioner has been subjected to grave injustice. That has to be. What has not been done.
Order, where is the order 10-125?
The latest order is at another queue, madam. At page 180, madam. In this particular order.
Right, will issue notice. C. Jagdish. Learned Counsel C. Jagdish is directed to accept notice for all the respondents. Petitioner to serve 2 sets of papers upon the aforesaid counsel. List the matter on 27th in fresh matters list. Next.
Serial number 60, ZM Hattarki.
Yes. Office objection.
I have given Malords the report of the Jail Authority that they are seeking Malords. They have already undergone the imprisonment. ಅದು ಮಹಾರಾಷ್ಟ್ರದಲ್ಲಿ ಆಗಿತ್ತು. The case was Malords at Maharashtra.
In the same crime they have undergone punishment?
No. Another crime in Maharashtra state.
The facts of this case is this accused that the crime has been registered on 19/2/2000. And during further investigation, the investigation office found that this accused has been arrested in Mumbai on 7/7/2002. And he has brought by the under the production warrant on 11, that is 18/7/2002. And the trial court has remanded to judicial custody. He is in the judicial custody of this case. During the pendency of this case, the accused has been convicted on 28/10/2005.
In which crime?
In another case, in Thane, for a life imprisonment. And subsequent trial is conducted in the year 2021, that 2020, April 2021, the court has convicted this accused for life imprisonment where he has been arrested. Now the question before the trial court is whether 428 is applicable or 427 is applicable to this one. That is the question of law.
Concurrent penalty.
Concurrent. Now, your lordship, the chapter 32 of the CRPC.
Now the maximum punishment is life.
Yes. Now,
right.
With the permission
which is the lesser punishment that is imposed?
Yes. There is no lesser.
Both these are life imprisonment.
Life imprisonment.
Even if they run concurrently or does not run concurrently, maximum is life.
Yes.
It's over.
Yes.
What do you need?
Sir, in this case, your lordship, the trial court has section 428 applying 428. They have set up the imprisonment that is from 18/2/2002 to 20th/10/2005, wherein he was there in this judicial custody of this case. Not only he has arrested in this case, he is in judicial custody till his trial is concluded. And now the question.
Point in what is?
Yes.
Now your lordship. ಏನಕ್ಕೆ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಂದ್ರೆ
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ?
is 14 years.
14 years.
If 14 years ಆದ್ಮೇಲೂ you say ಮುಗ್ದಿಲ್ಲ and you go on.
Please.
Now fission, all other things will come.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ? Lords, he was convicted life in Maharashtra, Lords.
He is convicted for life in Maharashtra, life in Karnataka.
ಅಲ್ಲ ಪ್ರೀ ರಿಲೀಸ್ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲಿ ಮಾಡಿದ್ಮೇಲೆ ನಮ್ಮಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಕಸ್ಟಡಿ. So
he was convicted life in
Maharashtra.
After that conviction in Karnataka. Even before the conviction in
Karnataka,
he is handed over here on body warrant.
ಬಾಡಿ ವಾರಂಟ್ ಕೊಟ್ಟಿದ್ರು ಅದನ್ನ ರೆಮಿಷನ್ ಮಾಡಿದೀವಿ. 3 years ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲಿ ಅವ್ರದ್ದು ಲೈಫ್ ಇದ್ದಿದ್ದನ್ನ ಪ್ರೀ ರಿಲೀಸ್ ಮಾಡಿದ್ಮೇಲೆ ಅಲ್ಲಿಂದ ಇಲ್ಲಿವರೆಗೆ 4 years, ಟೋಟಲ್ 7 years ಅಷ್ಟೇ ಇದ್ದಾರೆ ನಮ್ಮಲ್ಲಿ ಅವರು. ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಿಸ್ ಕೇಸ್ 7 years ಅಷ್ಟೇ ಇದ್ದಾರೆ.
ಎರಡರಲ್ಲೂ ಲೈಫ್ ತಾನೇ ಆಗಿರೋದು.
ಅಲ್ಲ ಆ ಕೇಸ್ ಬೇರೆ, ಈ ಕೇಸೇ ಬೇರೆ.
So what, there also life, here also
life.
Now he has completed 7 years here.
7 years.
According to you, how much have you completed?
I have completed in this case 22 years 6 months.
ಅದು ಅಲ್ಲಿಂದ
Karnataka, what is, I am the judicial custody of this case only. Now, before that one,
Have you taken into custody in this case?
on 18/7/2002. Now, before that one, your lordship,
Anyway, you are continuous in custody here or not does not matter. But you are taken into custody in crime number?
crime number that I have taken into custody on the MCOC case, special case of 3 of 2002, and I have been convicted on 28/10/2005. 20 October 2005 ನಲ್ಲಿ ನಾನು ಕನ್ವಿಕ್ಷನ್ ಮಾಡಿದ್ದೆ.
ಅಲ್ಲಿಂದ ಇಲ್ಲೇ ಇದ್ದೀರಾ?
I was there in judicial custody of this case, and subsequently taken to the trial. I have been convicted on 2005. 2005.
Report is there, my lords. To that
No,
effect, report is there.
One submission. Before this one, I take your lordship to section 429 of the CRPC. The procedure 2, that is the subsection 2. That is the headline of.
What offense?
And I am taking, sir, section 420, sentence on offender already.
That I know.
Yes.
Convicted for what offense?
Yes. Life imprisonment.
Offense.
For 302 of CRPC here. And there also has convicted for the MCOSO case and the 364A for life imprisonment.
The Mocha there.
Mocha there.
Coca
Now,
here, huh?
Coca illa sir. Illa only 302.
Come on.
Now, your lordship, the subsection 2, when a person already undergoing a sentence of imprisonment for life is sentenced on subsequent conviction to imprisonment for a term or imprisonment for life, the subsequent sentence shall run concurrently with this such previous sentence. This is law. The law laid down by the Supreme Court in the one of the judgment I referred, 396 page number. The state of Maharashtra Nazakat Ali case, para number 12, the Supreme Court says, the placement of the section just below section 427 of the code tempted us to have a peep into the preceding sections which deal with the instances wherein one person is sentenced in a case when he has already been undergoing the sentence in another case. The first subsection of section 427 said that the sentence in the second conviction shall commence at the expiration of the imprisonment to which the accused has been previously sentenced. Unless the court direct that subsequent sentence shall run concurrently with such previous sentence, the second subsection to subsection the section 427 of code says that when a person already undergoing a sentence of imprisonment for life is sentenced on subsequent conviction to imprisonment for a term or imprisonment for life, the subsequent sentence shall run concurrently with such previous sentence. Para number 13. Thus, the sentence of life imprisonment imposed on same person in two different conviction would converge into one and thereafter would flow through one stream alone. Even if the sentence in one of those two cases is not imprisoned for life but only lesser term, the convergence will take place and the post-convergence flow would be through the same channel. In all other cases, it is left to the court to decide whether sentence in two different convictions should merge into one period or not. If no order is passed by the court, the two sentences shall run one after the other. No doubt, section 420 is for intent to provide amelioration to the prison when such amelioration is statutory operations cases falling under the second subsection. It is a matter of choice for the court when the case fall within the first subsection. Nonetheless, the entire section is aimed at providing amelioration to the prison. Thus, phenomena of the succeeding section can be glimpsed through the one former section. This will say, your lordship, that it is a mandate. The court cannot, there is no option for the court.
When were you convicted, sir?
I have convicted in the earlier case.
What case were you convicted first?
The first case I convicted on 20th/10/2005.
Which is SC 5001 of 2018.
It is the case which has been that I am in the judicial custody.
You are now in judicial custody?
No, I was in judicial custody of this case only 5001/2018.
2018.
18, but 18 is the number has been given because the case has been transferred from the Dharwad.
This is the original number?
SC number 56 of 2002. The annexure B.
Let's see.
That is the judgment of the trial court.
Paragraph 42 in the
Para number
said
2.
judgment. 42.
In 42 which judgment?
ಅವ್ರು ಕೊಟ್ಟಿದ್ದು 405.
Justice ಸಂದೇಶ್ ಅವರ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ
ಅದರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಅರ್ಲಿಯರ್ ಕೇಸ್ ದಲ್ಲಿ ಇದರಲ್ಲಿ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
The page number 97.
Whatever period he is.
It is easy to submit. It has wide ramification. Where is which judgment did you give now? ಯಾವುದು ಓದರಲ್ಲಿ?
The annexure B, sir. Annexure B, page number
No.
94.
Did you read now?
Supreme Court.
Judgment is on page number 396.
ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲಿ?
ಕೊಟ್ಟಿದ್ದೇನೆ ಸರ್ ಅದನ್ನು.
389 page ಇದೆ.
389 ಪೇಜ್ ನಲ್ಲಿ ಇದೆ. ಇದರಲ್ಲಿ ಇದೆ ಸರ್.
389.
Along the petition.
Same judgment, Supreme Apex Court judgment ದಲ್ಲಿನೇ. There are 42, 40.
That is the descendant view given by the.
No, there are subsequent judgments. You're still stuck in 2001.
389 page number 2001 S6 SCC 311.
Other things. We'll take it on Tuesday.
May please.
Already report is there, Mulsa, given.
We'll go through it. This is serious consequences.
May please.
ಒಂದೇ ಕೇಸ್ ಅಲ್ಲ.
ಇಲ್ಲ, your lordship, the law has to be settled on this aspect.
That's why.
Please.
Based on Tuesday, yes.
61, Girish V. Bhatt.
Post immediately after service of notice upon R8 interim order ಇದ್ರೆ continue ಮಾಡಿ.
Please, my lord.
Interim order ಇಲ್ವಾ?
Please, ಯಾವತ್ತಿಗೆ my lord?
Refer.
March.
ಅಂದ್ರೆ
I also need time.
suspicious circumstances death of petitioner CBI investigations ಕೇಳಿದ್ರು.
Oh, CBI investigation.
ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕು.
R8 ಯಾರು?
Yes, party in person. Personally ಇದು ಮಾಡಿದ್ದಾರೆ.
He only manipulated the things.
Oh man, then ಬರ್ಲಿ. List on 21st.
Please.
What? ಕೊಟ್ಟಿದ್ದಾರೆ ರಿಪೋರ್ಟ್ ಇಲ್ಲಿ. ನಿಮ್ಗೆ ಯಾಕೆ ಬೇಕು? Wait will give you, yes.
Please, my lord, 21st in fresh matters list. Please.
ಬರ್ಲಿ ನೋಡಿ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಇವತ್ತು 4 ಗಂಟೆಗೆ ರೀಚ್ ಆಗ್ತದೆ.
ತಮ್ಮ ಕೈನಲ್ಲಿ CBI ಆಗೋಗ್ಲಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ list.
ಡೈಲಿ ಒಂದೇ ತರ ಇರಬಾರ್ದು.
Please.
Yes. All right.
52, Sunanda P. Patil.
Challenging the compromise decree entered into between the petitioners and the respondents, your lordship. The
Compromise.
Please, my lord.
Why?
Because the petitioner number 1 has relinquished all her rights in the suit properties, that is the 4 agricultural lands as well as the house properties in favor of the respondents, your lordship.
Petitioner to serve on the council to represent the respondent in the trial proceedings and file an acknowledgement to that effect. Will only issue notice, madam. ಏನು ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ?
Because he is not executing relinquishment deed in favor of the petition number 1, even though he has entered the compromise decree in the and he is only dragging on the matter, your lordship.
List
Even though
on
she has
25th. Yes, in the fresh matters list. Next.
decree may kindly be stayed, my lord.
What stay, madam?
Compromise decree, your lordship, because he is.
What is happening now pursuant to the decree?
Because they are entering their names and they want to sell the suit properties, your lordship. That is the problem.
The properties obtaining in the compromise decree be maintained till the next date of hearing.
Please, sir.
Yes.
63, BC Gnanaya Swami.
Even the emergent notice may kindly be ordered.
No, serve on someone. Yes.
Please.
Matter pertaining to your lordship, suspension of fair price shop license, my lord.
Fair price shop.
Please. And
appeal ಇದೆಯಲ್ಲ?
ಅಲ್ಲ appeal, but
ಆಗೋಗಿದೆ.
ಇದರಲ್ಲಿ ಆಲ್ಟರ್ನೇಟಿವ್
months ಆಗೋಗಿದೆಯಲ್ಲ?
6 months. The like suspension order is came to be passed in 17 and 2022 ದಲ್ಲಿ enquiry notice issue ಮಾಡಿದ್ದಾರೆ. As it is totally contrary.
Anything else?
ಇಲ್ಲ, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, ಅಲ್ಟರ್ನೇಟಿವ್ ಅರೇಂಜ್ಮೆಂಟ್ ಬೇರೆದವರಿಗೆ ಮಾಡಿದ್ವಿ. ಲಾಸ್ಟ್ ಡೇಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಹ್ಯಾಸ್ ಸ್ಟೇಡ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆನ್ ದ ಗ್ರೌಂಡ್ ದಟ್ ಇದರಲ್ಲಿಲ್ಲ, ಬೇರೆ ಕೇಸ್ದಲ್ಲಿ as the person who has been alternative given mullards
ಏನ್ ಧಮಕಿ ಹಾಕ್ಲಿಕ್ಕೆ
ಇಲ್ಲ ಸರ್,
ಅದು ಆಲ್ಟರ್ನೇಟಿವ್ ಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡಿದವ್ರಿಗೆ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅಂತಿದೆ. ದೇ ಫೈಲ್ ರಿಟ್ ಪಿಟಿಷನ್ ಮಲರ್ಸ್ ಆಫ್ಟರ್ ದಿ ಒರಿಜಿನಲ್ ಆರ್ಡರ್ ಇಸ್ ಕಾಸ್ಟ್, ಅದನ್ನ ಸ್ಟೇ ಮಾಡಿದ್ರು ಅವರು. ಇದರಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ. ಇದರ ಆಲ್ಟರ್ನೇಟಿವ್
suspension we will set aside, enquiry ಇದ್ರು set aside. Consequences will follow. The petitioner is before this court calling in question an order dated 10/8/2017 and the impugned and the enquiry notice dated 14/12/2022. The heard so and so. Facts in brief germane are as follows. Rules kodi. The petitioner is granted authorization to run a fair price shop in the year 1995. After about 11 years, a show cause notice comes to be issued to the petitioner by the fourth respondent and a consequent inspection of the property to conduct an enquiry. The petitioner is then the running of the fair price shop or the authorization granted to run one such is suspended by an order dated 10/8/2017. The suspension is followed by an inquiry notice on 14/12/2022. It is then the petitioner has rushed to this court, not immediately, but after 3 years. As observed herein above, the authorization of the petitioner comes to be suspended on 10/8/2017. The suspension and issuance and inquiry is regulated by the Karnataka Essential Commodities Public Distribution System Control Order 2016, hereinafter referred to as the Control Order for short. In terms of the Control Order, suspension
Section 12, my lord. ಕೆಳಗಡೆ provided that ಅಲ್ಲಿ.
Suspension of the authorization is dealt with under section 12 of the said order. It reads as follows.
ಕೆಳಗಡೆ last ಅಲ್ಲಿ ಇದೆ.
ಅದು ಗೊತ್ತು, ಸಸ್ಪೆನ್ಷನ್ ಯಾವುದರಲ್ಲಿದೆ?
Provision.
No order shall be made clause unless authorized.
Provided no order shall be made under this clause unless the authorized dealer or agency has been given a reasonable opportunity of being heard.
ಅದಾಯ್ತು, but 90 days from
Conditions authorization.
the aforequoted provision subsection 2 of section 12 proviso appended to subsection 2 of section 12 mandates that the inquiry shall be completed within 90 days from the date of suspension of the shop, and in that case cancellation of new authorization shall be issued within 60 days of such cancellation. Therefore, on placing the authorization of a fair price shop under suspension, inquiry against the said suspended fair price shop, suspended authorization which runs the fair price shop, should be completed within 90 days. The dates are unequivocal. On 10/8/2017, the authorization stands suspended. Within 3 months, the inquiry ought to have been completed. Notice of inquiry is issued not after 3 months, not after 3 years, but after 5 years. The inquiry is sought to be continued after issuance of the said notice, which is completely contrary to the aforequoted mandate of the statute. Therefore, the petitioner, on this short point, that the state has not sought to complete the inquiry within 90 days after placing the authorization of the petitioner under suspension, the petition deserves to succeed. The learned AGA would submit that in the interregnum, the shop has been, the authorization of the fair price shop has been allotted in
attached to the
attached only.
Sorry. The learned AGA would submit that alternative arrangements have been made in the light of the suspension of the fair price shop. In the light of the arrangements being only alternative and the petition succeeding, the consequential benefits also should flow in favor of the petitioner. For the aforesaid reasons, the following order. Allowed, quashed, mandamus issues to the respondent to continue the authorization of the fair price shop of the petitioner, subject to his continue so and so in accordance with law.
64 sale party municipal data bangi.
This is a voter list, my lord. Your lordship may find place the writ petition order by this honorable, the coordinate bench of this honorable court at page number 78.
Yeah. It can be disposed now or
may
be heard.
And out of 111, Lord, the authority has said, I am eligible to participate in the election process. Lord, 3 of them have called in question that order.
That is called in question.
Yes.
This court has directed them to follow 13D. 13D also, the learned deputy commissioner now says that though it is not applicable, he should be included.
When this court said follow 13D,
yes,
how can he say that it's not applicable?
That is what is, your lordship may find place, the impugned order, page number 9.
He makes you eligible, is it?
Yes. I'll demonstrate how it is, my lord.
ಹಾಗಾದ್ರೆ ನಾಳೆ ಬರಲಿ.
Please.
ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಬೆಳಗ್ಗೆ ಬರಲಿ.
Because election is notified.
ನಾಳೆ ಆಗತ್ತಾ? ನಾಳೆ ಆಗಲ್ಲ, ನಾಡಿದ್ದು.
In the meanwhile, madam, let them not publish voter, they have not yet published voter list. But
Election ಯಾವತ್ತು ಸರ್?
election, they have notified. Election
Calendar
is
of
on
events is issued. This order is passed in the year, my lord,
election.
December 2nd,
Before
3rd.
15 days, they have to publish the voter list.
What were you doing till now?
Immediately after deputy commissioner's order, my lord, till now, the election list,
Immediately, ಯಾವತ್ತು ಕ್ಯಾಲೆಂಡರ್ ಆಫ್ ಇವೆಂಟ್ಸ್ ಆಗಿರೋದು ಯಾವತ್ತು?
My lord, this is
calendar of events is published
22nd January.
22nd January.
25.
Yes.
5 days ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. But anyway, maintainability?
Because 15 days prior to date of election, they have to publish the voters list. That voters list is not published till today. They may publish. But stay illa, but they have not published the voter list till now.
Let's day after tomorrow. Yes.
And till then, let them not.
If no, in the fresh matters list day after tomorrow. Next.
Number 65, dear Lord Khan.
Lord, I sought for police protection.
Why?
An application came to be filed on 7/7/2024, my lord. There was a threat to my possession and life. A representation was given to the Circle Police Inspector Saudati, my lord. That was accepted, and one more representation was given, bringing to the notice of the very authority that my life is at threat.
And I ಕೇಳಿದೆ real time ಅಲ್ಲಿ ಇದೆಯಾ ಅಂತ.
Thereafter, my lord, an
The petitioner is before this court.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ನೋಟ್ಸ್ ಫ್ರಮ್ ಲಾಸ್ಟ್ 5 years his name is not entered in the revenue records, but the persons who are in possession of the property, they're from last 60 years. So civil dispute is early. So for protection is concerned to him, my lords,
You forget about that. If his threat to life is in real time.
I'm seeking only for threat to life, my lord. As far as other aspect is concerned,
the petitioner is before this court seeking the following prayer. The petitioner and others enter into a registered partition on 10/8/2017. Pursuant to the said partition, it transpires that the mutation and the record of rights are changed. The petitioner, owing to threat in real time, submits a representation to the police, jurisdictional police seeking protection and necessary action against the persons who are obstructing to the peaceful possession of the petitioner. The representation is repeated, and later the petitioner registers a crime on 17/11/2024 for several offences in crime number 350 of 2024. The issue in the list is with regard to grant of police protection to the petitioner or otherwise. The learned AGA would on instruction submit that the several civil suits pending between the parties.
There is no civil suit pending. ಏನಾಗಿದೆ, the person who are in possession are from 60 years.
The learned AGA would submit that the persons who are in possession of the property are in possession of the property for over 60 years, and the petitioner and the people who are in possession are at squabble. Be that as it is. If the representation of the petitioner projects threat to life in real time, the police shall take action of grant of police protection after being satisfied with such threat for real time in terms of the circular of the government dated 14/11/2018 to the ordered accordingly.
Please, one more thing, he is residing at Mulot's Hubli. Whenever he goes to the Mulot's, that jurisdiction we will provide.
Adike threat in real time. After being satisfied that there is threat.
Please.
66 Sachin Godareddy.
Ordered accordingly.
My lord, challenging annexure ye, my lord. Challenging annexure ye, my lord. Through annexure ye, my lord, the respondent number 2 has disconnected the electricity power supply, my lord.
Yesterday only, my lord, intimated to the corporation. That was listed, and this is the my lord position.
ಯಾವಾಗ ರೆಸ್ಟೋರ್ ಮಾಡ್ತೀರಾ? ಎಷ್ಟಿದೆ ಬ್ಯಾಲೆನ್ಸ್ ಇದೆ?
No balance is there.
ಮತ್ತೆ why?
Today, my lord,
The fact is that, my lord.
ತಮ್ಮ ಹೆಸರು?
Shivraj P. Mudol.
Shivraj P. Mudol accepts notice for HESCOM. Objections, if any, by the next date. Till such time, there shall be an interim order of stay as prayed for.
Interim prayer is for reconnecting the electricity.
There shall be an interim order as prayed for.
Yes, please.
Stay better. Yes. Next.
67, Girish's full money.
My lords, the petitioner account has been freezed, my lords, on the basis
Why,
of
sir? Crime register ಆಗಿದೆಯಾ?
crime is registered, my lords, not against the petitioner herein, but some unknown persons.
Money trail comes to you.
My lords, money.
Accused account ಇಂದ ನಿಮ್ಮ ಅಕೌಂಟ್ ದುಡ್ಡು ಬಂದಿದೆಯಾ?
Please, my lords.
What
That
transaction is that?
That amount, my lords, he is running a CCS, Common Service Center, my lords, at Uttar Pradesh. The petitioner herein. There, my lords, for the purpose of the works which he has done, he received a payment, my lords, of rupees 4,850 rupees, my lords.
4,000?
850 rupees. His
ಶುರು ಮಾಡಿದ್ರೆ 4,500 crores ಅಂತೀರಾ?
Only, my lords, I am saying that at least by marking lien, my lords.
Freeze ಮಾಡಿ. The petitioner is before this court.
My lords, respondent number 2, bank is.
Banka.
Please, my lords.
Yaak ಬೇಕು? Yes. Who has directed freezement?
Respondent number 1.
Yes. The petitioner is before this court seeking a direction by issuance of a writ in the nature of mandamus to defreeze the account of the petitioner, which has now been frozen on account of a direction by the first respondent state to the second respondent Canara Bank. The petitioner, there appears to be a financial transaction by which an amount of rupees 4,850 comes into the coffers of the petitioner through a QR code of the Common Services Center run by the petitioner. The person who has transacted in the Common Service Center, Common Service
Center, my lords.
Common Service Center, CSC.
Page number 10, my lords, annexure A.
ಅದಾದ್ಮೇಲೆ ಮತ್ತೆ ಯಾಕೆ ಸೆಂಟರ್ ಅಂತ ಬರ್ದಿದ್ದೀರಾ?
Sorry,
Common Service Center.
sorry, my lords.
Yes.
CCS, CSC.
Common Service Center. ಏನ್ ಹೇಳಿದೆ?
Sorry, my lords.
Common Service Center run by the petitioner. It is an admitted, the notice was issued to the petitioner on 17/11/2024 under 35(3) of the BNSS, asking the petitioner to appear for the purpose of investigation. The petitioner has cooperated with the investigation is his submission. The issue is whether the account of the petition, entire account of the petitioner can be frozen for a transaction of 4,850 rupees. In that light, 50 rupees. The account of the petitioner is akin to a right to property of the petitioner or any person who is holding the account. Therefore, in the light of the crime registered against other accused and not against the petitioner, and the petitioner cooperating with the investigation, I deem it appropriate to direct the respondent, first respondent to direct the second respondent to mark a lien of rupees 4,850 rupees in the account of the petitioner and permit account to be operated as it was operated prior to the date of freezement. Ordered accordingly.
Much obliged.
ಅಷ್ಟೇ. ಇನ್ನೇನು? ಹಿಂದೆ ಡ್ರಾ ಹಿಂದೆ ಬಹುಮಾನ. Next. Non-compliance. ಇಷ್ಟೊಂದು ಹಾಕಿದ್ರೆ ಮತ್ತೆ ಎಷ್ಟು 20 ಆಯ್ತಾ? ಟಾರ್ಗೆಟ್ ಆಯ್ತು. ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಹೆಂಗೋ ನಾಡಿದ್ದಕ್ಕೆ ಹೋಗೋದು, ಆಮೇಲೆ ಕರೀರಿ ಪರವಾಗಿ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ಅದೊಂದು ಇವ್ರದ್ದಿದೆಯಲ್ಲ ಅಮಿತ್ ಕುಮಾರ್ ದೇಶಪಾಂಡೆ, ನೋಡೋಣ. ಅದು ಅಮಿತ್ ಕುಮಾರ್ ದೇಶಪಾಂಡೆ 4:30ಗೆ ತಗೊಂತೀನಿ. ಗಂಗಾಧರ್, ನೀವು ಎಲ್ಲಿ ಇಲ್ಲೇ ಇದ್ದೀರಾ? 4:30ಗೆ ಬರ್ಬೋದು. Won't take much time.
Yes, no problem.
4:30 or 4:40 I will start.
Yes.
In 20 minutes we'll finish it. Amit, we'll start at 4:40 and finish it. Let me just run through this.
Shilvan, CV Angli.
The petitioner applied for the retail outlet of the IOCL and he was selected, and LOI was
2018 ದ ಇಲ್ಲಿವರೆಗೆ ಏನಾಗ್ತಾ ಇದೆ?
ಅಲ್ಲ 2018 ಅಲ್ಲಿ ಮತ್ತೆ ಫ್ರೆಶ್ ಕರೆದ್ರು ಅವರು, ಬಟ್ ನೋಬಡಿ ಸೆಲೆಕ್ಟೆಡ್, ದಟ್ ಇಸ್ ದ ಮೆಮೋ ಫೈಲ್ಡ್ ಬೈ ದಿ ಅದರ್ ಸೈಡ್.
ಎಸ್ ಸರ್.
Yes, Milos. Lord,
ಯಾರು ಇಲ್ಲಿ
on the, on the, in the
There is
first
nobody?
instance, my lord,
in 2018 also they said that there is no eligible candidate, but I am selected. I was given a LOI, and I was directed to obtain NOC from all the departments. I obtained NOC. In spite of that, they were called in the year 2018, my lords.
plus in the year 2011, my lord.
You gave him some hope to purchase everything.
No, my lord, LOI is given, my lord, but during the field verification of credentials, he didn't meet out the eligibility criteria.
What did it not meet out?
Lord, there are two notifications that have been referred in this writ petition. The first notification was issued in the year 2011, calling for applications for.
Which is the impugned notification?
The subsequent notification he has impugned, my lord. That will not survive for consideration because for that notifications there are only two applicants and both failed to meet out the eligibility criteria.
Not there.
He was not. He
He was
didn't.
selected in 2011 notification, is it?
In that particular notification, my lord, it was meant for establishment of Kisan Seva Kendras, KSK
Which
retail outlet
notification?
of the year 2011. And one of the conditions is that the sites offered by the applicants, my lord, should not be abutting the state highway or national highway. So though letter of intent was issued, my lord, at a later stage, another rival retail outlet operator had filed a petition, my lord, alleging that this particular property abuts state highway, and subsequently on verification, also during field verification of credentials, it was observed that the site offered by the petitioner did abut the state highway, my lord. Therefore, he failed in the eligibility criteria. Thereafter, my lord, though letter of intent was issued, further proceedings were dropped, my lord. So he doesn't qualify eligibility criteria point of view insofar as the first notification is concerned.
2011.
11 and
Second irle ilvalla bidi.
second, he was not a participant, and in that there were hardly two applicants.
But third comes.
Pardon, my lord?
Innond madidira amele?
Only two, my lord.
Only two.
Only two. So in the prayer also.
Not qualified.
ಅಲ್ಲ, there is a
Before issuing LOI, won't you see all that? Letter of intent issue madak munche, you see all that, or just like that blindly?
The scrutiny of applications, it is made based on the information they furnish, my lord. That's why there will be undertaking clause that.
But letter of intent yak kodtira before you verify everything?
Thereafter, field verification of credentials would
Now
take
what
place.
has happened after 14 years?
That particular location, my lord, it appears. It appears, my lord, there are not other applicants also.
So
That I have to ascertain, my lord. First notification.
If the location is still available,
Yes, ma'am.
his application we will then consider. If it is given to someone else, we are not going to interfere.
That is not the moot point, my lord. Here he doesn't qualify at all because he fails.
That we'll see. But even if I hold him to be qualified now, where is the place to give? You should give me the place. If it is not given to someone else, then we'll consider it.
That I will ascertain, my lord. Even otherwise, my lord, he has failed in meeting out the eligibility criteria because the site he offered, it abuts.
Ascertain and give. Yes. ನಿಮಗೆ ಗೊತ್ತಿಲ್ವಾ?
There is a ಇಲ್ಲ ಇನ್ನೂ ಮಟ್ಟ ಯಾರು ಕೊಟ್ಟಿಲ್ಲ.
ಇನ್ನೂ ಮಟ್ಟ ಕೊಟ್ಟಿಲ್ವಾ?
ಹೌದು. And there is a letter from the PWD that it doesn't abut the highway, my lords.
ಇನ್ನೂ ಮಟ್ಟ ಕೊಟ್ಟಿಲ್ಲ. Not abutting ಅಂತಂದ್ರೆ ಇವ್ರಿಗೆ ಕೊಡ್ಬೇಕಾಗತ್ತೆ.
That letter is of the year 2017. The eligibility criteria should be as on date of advertisement and submitting the application form.
2017 ಗೆ it doesn't abut the highway ಅಂದ್ರೆ ಎಲ್ಲಿಂದ 14 ಅಲ್ಲ 11 ಅಲ್ಲ?
That letter just states that it comes within municipal limits, but state highway remains. State highway remains the same.
ಕೇಳ್ಕೊಂಡ್ ಬನ್ನಿ.
I'll ascertain, not next week.
ಅದೇ Wednesday in the fresh matters list. Yes.
70 adjourned. 71 Jagdish Patil, SD Kadatkatti.
Last time.
No.6. Jagdish Patil sir, ಏನಿದೆ?
Third time mitigation melody.
1954, this land was 1950.
History at
Yes, sir, that's what may make on submission. Meantime, government advocate should get the records because it has been handed to the undivided Congress. Now the 2012 vargu they have not attended
Congress.
Undivided Congress because subsequently it has become a Samstha Congress and Congress I. Indira Congress, if I'm specifically. Up to 2012, they have not made any efforts. We have constructed a Samudaya Bhavan with the help of the government fund. Nobody has challenged it. Meantime, in the year 2020, it has been handed over to the Kannada's Sanskriti Bhavana. That is, they have not till today they have not challenged. That's what I made, sir. Let them get the records. Government will also that.
Get the records.
Get the records.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಮಿಲಾಡ್
ನೀವು ಕಾಂಗ್ರೆಸ್
ಹೌದು ಮಿಲಾಡ್ 1954 ಅಲ್ಲಿ ಗ್ರಾಂಟ್ ಆಯ್ತು ಮಿಲಾಡ್ 2012 ಕ್ಯಾನ್ಸಲೇಷನ್ ಮಾಡ್ತಾನೆ ವಿತೌಟ್ ನೋಟಿಸ್ ಕಾಂಗ್ರೆಸ್ ಪಕ್ಷ ಇಲ್ಲ ಅಂತಲ್ಲಿ ದೆನ್ ಆರ್ಡರ್ ಇಸ್ ಚಾಲೆಂಜ್ ಮಿಲಾಡ್ ಈ ಆರ್ಡರ್ ಕ್ವಾಶ್ ಆಯ್ತು ಸ್ವಾಮಿ ಕ್ವಾಶ್ ಆದ ನಂತರ ರಿಟ್ ಅಪೀಲ್ ಪಿಟಿಷನರ್ ಹಾಕಿದ್ರು ಅದನ್ನ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರು ವಿತ್ಡ್ರಾ ಮಾಡ್ಕಿ ಬಂದು ಇಲ್ಲಿ ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಇಲ್ಲಿ ಬಂದು ಆ ಪ್ರೇಯರ್ ಅನ್ನು ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂತ ಇದ್ದಾರೆ ಫಸ್ಟ್ ಪ್ರೇಯರ್ ಅನ್ನು ದೆನ್ ಅಗೇನ್ ಮತ್ತೆ ರಿಟ್ ಆಗ್ತಾ ಇದ್ದಾರೆ ಅಲ್ಲ ವಿಟ್ರಾನೆ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಸೇಮ್ ಪ್ರೇಯರ್ ಮೇಲೆ ಅವ್ರು ಕ್ವಾಶಿಂಗ್ ಕೇಳಿದ ಪ್ರೇಯರ್ ಏನಿದೆ ಅಲ್ಲಿ ವಿಟ್ರಾ ಮಾಡ್ಕೊಂಡ್ರು ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಅಗೇನ್ ಇಲ್ಲಿ ಬಂದು ರಿಟ್ ತೆಗೆದು ಆ ರಿಟ್ ಅಲ್ಲಿ ವಿಟ್ರಾ ಮಾಡ್ಕೊಂತ ಇದ್ದಾರೆ ಪ್ರೇಯರ್ ವಿಟ್ರಾ ಮಾಡ್ಕೊಂಡು ಆಗಿದೆ ಅಯ್ಯ ಹಾಕಿದ್ದಾರೆ ಅಯ್ಯ ಹಾಕಿ ವಿಟ್ರಾ ಮಾಡ್ಕೊಂಡ್ರು ಮತ್ತೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಮೇಲೆ
the first submission without notice, that's what I produced the document.
ಯಾರ್ದು ಅಂತ
ಈಗ ನಮ್ಮ ಹತ್ರ ಇದೆ ಅದನ್ನು they had specified at the time of making the observations by the assistant commissioner.
ಹೌದು ಮಿಲಾಡ್ ಇದೆ ಸ್ವಾಮಿ ಯಾಕಂದ್ರೆ 2012 ವರೆಗೂ RTC ಐತಿ ನಮ್ಮ ಹೆಸರಲ್ಲೇ ಇದೆ ಕಾಲಂ ನಂಬರ್ 9 ಅಲ್ಲೂ ಇದೆ 12 ಅಲ್ಲೂ ಇದೆ 1954 ಇಂದ 2012 ವರೆಗೂ ನಮ್ಮ ಹೆಸರಲ್ಲೇ ಇದೆ 2012 ನಲ್ಲಿ ಕಾಂಗ್ರೆಸ್ ಪಕ್ಷ ಇಲ್ಲ ಕಮಿಟಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ವಿತೌಟ್ ನೋಟಿಸ್ ಅಂತಲ್ಲಿ ತಹಸೀಲ್ದಾರೇ ಹೇಳಿದ್ದಾರೆ ತಹಸೀಲ್ದಾರ್ ಹೇಳಿಬಿಟ್ಟು ವಿತೌಟ್ ನೋಟಿಸ್ ಇಲ್ಲಿ ಪಕ್ಷ ಯಾವುದೂ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಕೊಂಡು ನಿಮ್ಮ ವಾಪಸ್ ತಗೊಂಡಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ ಇದ್ರ ವೈಲೇಷನ್ ಆರ್ಡರ್ ಕಂಡೀಷನ್ ಆಗಿಲ್ಲ ಏನೂ ಆಗ್ಲಿಲ್ಲ that order is challenge that is mailed in the court is mailed in the
records
please
any day on the Wednesday also or the next Tuesday also no
next Tuesday. Wednesday 19th list on 19th preliminary hearing yes
72 Hemant Kumar how are you
challenging the Anganwadi worker ಭಾಷಾ ಜ್ಞಾನ gets the instruction ಅಂತ ಹೇಳಿ
I may be permitted to file
ಏನು instructions with regard to selection committee so constituted
the appointment of the respondent is your lordship in accordance with the appointment of respondent is in accordance with the selection committee proceedings your lordship
then what
how
ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ ಸೆಲೆಕ್ಷನ್ ಆಗಿ ಈಗ
ಇಲ್ಲ ಸರ್ 2020
ಹೇಮಂತ್ ಕುಮಾರ್
22 your lordship
22
document number 1 your lordship page number 5 your lordship
ಶೇಕಡ 25 ಏನು ಗ್ರೌಂಡ್ ಏನು
petitioner is widow my lordship petitioner is widow
all right
my lordship widow my lordship must first round is my lordship should be considered my lordship they have not considered the petitioner my lordship
who is appointed now
fifth respondent is appointed my lordship
she served under representation
page number 26 your lordship
served all right
the page number 26
ground ಹೇಳಿ we'll close it now yes
the petitioner has given an objection my lordship challenging annexure H my lordship
ground ಹೇಳಿ sir 6 what is wrong with the appointment of the fifth respondent
please my lordship
first
petitioner is a qualified candidate my lordship
ಅದು ಗೊತ್ತು ಗ್ರೌಂಡ್ ಹೇಳಿ ಅಂದ್ರೆ qualified candidate ಅವ್ರದ್ದೇನು ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಹೇಳಿ
the petitioner secure more marks
first one more meritorious ಎಷ್ಟು percentage
please my lordship my lordship the petitioner secure marks 9th classes my lordship 477 my lordship
percentage
and fifth respondent my lordship percentage 70 above my lordship
ಆಯ್ತು fifth respondent ಎಷ್ಟು
284 my lordship 9th
477 284
please my lordship
all right ಆಮೇಲೆ next
widow must be considered my lordship
ಆಯ್ತು you are a widow
please my lordship
she is not a widow
she is also widow your lordship
ಆಯ್ತು anyway ಆಮೇಲೆ next
my lordship have given an objection my lordship but they are not considered my lordship
ಅದು ಎರಡೇ ಗ್ರೌಂಡ್
ಎರಡೇ ಗ್ರೌಂಡ್
Yes, madam.
Please, Your Lordship. Page number 26 of the petition, Your Lordship. The 20, more than 25% of the people are minority population, Your Lordship. Hence, the person knowing that particular community language should be selected, Your Lordship. According to that, Your Lordship, an interview have been conducted, Your Lordship. That is passed by the committee, Your Lordship. Selection committee.
ಈಗ
Your
ನಿಮಗೆ
Lordship.
ಬೇರೆ ಎಲ್ಲೂ ಕೊಟ್ಟಿಲ್ವಾ?
ಪ್ಲೀಸ್
ಯಾರೋ ಮಾಡ್ತಾ ಇದ್ರಲ್ಲ, ಮಾಡ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಭಾಷೆ ಬರಲ್ಲ ಅಂತ ಅವ್ರನ್ನ ತಗೊಳ್ಳಿಲ್ಲ ಅಷ್ಟೇ.
ಯಾರಿಗೂ ಇವ್ರಿಗೆ ಭಾಷೆ
ಅವ್ರಿಗೆ
ಬರಲ್ಲ?
ಭಾಷೆ ಬರಲ್ಲ.
ಯಾವ ಭಾಷೆ ಬರಲ್ಲ?
ಮೈನಾರಿಟಿ ಕಮ್ಯುನಿಟಿ ದಟ್
ಮೈನಾರಿಟಿ ಭಾಷೆ ಅಂತ ಇದೆಯಾ?
ಅಲ್ಲಿದೆ.
ಏನಿದೆ ಮೈನಾರಿಟಿ ಭಾಷೆ ಅಂತ?
ಅಲ್ಲಿ more than 25% of the people
ಭಾಷೆ
are
ಯಾವ್ದು ಅಂತ
Muslim.
ಕೇಳ್ತಾ ಇದ್ರೆ ಮೈನಾರಿಟಿ ಭಾಷೆ
ಉರ್ದು,
ಅಂತ
ಉರ್ದು,
ಇದೆ.
Your Lordship.
ಉರ್ದು.
ಅಸಿಸ್ಟೆಂಟ್ ಅಂಗನವಾಡಿ ವರ್ಕರ್ಗೆ ಏನು ಉರ್ದು ಭಾಷೆ?
ನಿಮಗಿಲ್ವಾ?
ಅಲ್ಲ, ಈ ಸೆಲೆಕ್ಷನ್ ಆದವ್ರಿಗೂ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅದು ಸೆಲೆಕ್ಷನ್ ಇಸ್ ಆಲ್ ಅಷ್ಟು
ಅವ್ರಿಗೂ ಇಲ್ವಾ?
ಇದೆ ಸ್ವಾಮಿ. I have produced that
ಅಲ್ಲ,
document, Your
ಜ್ಞಾನ
Lordship.
ಅವ್ರಿಗೂ ಇಲ್ವಾ?
ಅಲ್ಲ ಅವರು ಸೆಲೆಕ್ಷನ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
I have produced that document, Your Lordship.
ಯಾರು ಸೆಲೆಕ್ಟ್ ಮಾಡಿ? ಮೇಡಮ್, ಇವ್ರಿಗೆ ಬರುತ್ತೆ ಅಂತ ಹೆಂಗ್
Your
ಗೊತ್ತು
Lordship,
ನಿಮ್ಗೆ?
ಇಲ್ಲ. ಅಲ್ಲ,
ಅವ್ರೇನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದಾರಾ?
ಇಂಟರ್ವ್ಯೂ ತಗೊಂಡ್ರು.
ಏನು ಯಾವ ಕನ್ನಡದಲ್ಲಿ ಮಾತಾಡ್ಸಿದ್ರ ಇಂಟರ್ವ್ಯೂ ಅಲ್ಲಿ?
Some questions were put to Your Lordship.
Put what?
Hindi language, the knowledge of the
ಕ್ಯಾ ಹೈ?
maybe, Your Lordship.
ಮೇಬಿ ಅಷ್ಟೇನೆ.
ಯಾಕಂದ್ರೆ
ಇವರು ಹೇಳ್ತಾ ಇದ್ರು.
No, Your Lordship, for all the candidates, the interview was taken, Your Lordship. In that,
More meritorious. I thought you have selected some person who knows Urdu. Allo adene.
Another person or they
he knows that language, Your Lordship, but the
ಇನ್ನೊಬ್ಬ ಪರ್ಸನ್ ಕೂಡ ಅದಾನ್ ಸರ್ ಅಲ್ಲಿ ಅದಾರೆ. ಅಲ್ಲಿ
ಎಲ್ಲದಾರೆ?
ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಲ್ಲಿ ಮೆಮೊ ಅಲಾಂಗ್ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ.
ಅವ್ರ ಹೆಸರೇನು?
ಬಸಮ್ಮ ಗುರುಲಿಂಗಪ್ಪ ಅವರು ಇದಾರೆ. ಅವ್ರಿಗೆ ಹೌದಂತ ಭಾಷಾ ಜ್ಞಾನ ಐತಂತ ಅವ್ರಿಗೆ ಹೇಳ್ತಾರೆ. ಸೊ ಇವ್ರಿಗೆ ಹೇಳ್ತಾರೆ.
she is widow, Your Lordship. She should get more preference. Respondent, Your Lordship. The selected candidate, Your Lordship.
Widow.
Yes, Your Lordship.
Widow.
Widow plus this language, Your Lordship.
Language plus
the criteria
language
is the criteria.
ಎಲ್ಲಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ರ ಉರ್ದು ಬರುತ್ತೆ ಅಂತ?
Interview has been conducted, Your
Who
Lordship.
conducted the interview?
The committee which is
where is the committee?
Please, Your Lordship, I have find along with my memo, Your Lordship.
Committee li somebody is there knowing Urdu?
Yes, Your Lordship.
Where? Constitution of the committee ಅಲ್ಲಿ.
Please, Your Lordship. Document number 1, Your Lordship, page number 5. The committee proceedings 22 to 2022, Your
ಅಂಗನವಾಡಿ
Lordship.
ಕಾರ್ಯಕರ್ತೆ 22-1
22 to 22 ಅಲ್ಲಿ
ಎಲ್ಲಿದೆ ಇವ್ರದ್ದು?
ಒಂದು ನಿಮಿಷ. ಪೇಜ್ ನಂಬರ್ 11, Your Lordship, ಅಲ್ಲಿ ಹೋಗಿ. ಹನುಮಸಾಗರ ಗ್ರಾಮದ 10ನೇ ಅಂಗನವಾಡಿ ಕೇಂದ್ರದ ಸಹಾಯಕಿ ಹುದ್ದೆಗೆ ಇತರೆ ಅಲ್ಪಸಂಖ್ಯಾತ ಕೇಂದ್ರ ಮೀಸಲಾತಿ ನಿಗದಿಪಡಿಸಿ ಆನ್ಲೈನ್ ಮುಖಾಂತರ ಅರ್ಜಿ ಆಹ್ವಾನಿಸಲಾಗಿತ್ತು. ಈ ಗ್ರಾಮಕ್ಕೆ ಒಟ್ಟು 38 ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಅರ್ಜಿಗಳು ಸ್ವೀಕೃತಗೊಂಡಿದ್ದು, ಇದರಲ್ಲಿ ನೇಮಕಾತಿ ಮಾರ್ಗಸೂಚಿ ಅನುಸಾರ ವಿಧವೆ ಇವರಿಗೆ ಮೊದಲ ಆದ್ಯತೆ ಇದ್ದು 11 ಅಭ್ಯರ್ಥಿಗಳ ಅರ್ಜಿಗಳನ್ನು ಅರ್ಹತೆಯನ್ನು ಹೊಂದಿದ್ದು, ಉಳಿದ 27 ಅಭ್ಯರ್ಥಿಗಳ ಅರ್ಜಿಗಳು ಅನರ್ಹತೆ ಹೊಂದಿರುತ್ತವೆ. ಅರ್ಹತೆ ಹೊಂದಿದ ಅಭ್ಯರ್ಥಿಗಳಲ್ಲಿ ಆದ್ಯತೆ ವರ್ಗಕ್ಕೆ ಸೇರಿದ 1 ವಿಧವೆ ಅರ್ಜಿಗಳು ಇರುತ್ತವೆ. ಸದರಿ ಕೇಂದ್ರವು 25% ಅಲ್ಪಸಂಖ್ಯಾತ ಸಮುದಾಯದ ಜನಸಂಖ್ಯೆಯನ್ನು ಹೊಂದಿದ್ದು, ನೇಮಕಾತಿ ನಿಯಮಾವಳಿಯ ಪ್ರಕಾರ ಸದರಿ ಅಲ್ಪಸಂಖ್ಯಾತ ಸಮುದಾಯ ಭಾಷೆ ಬಲ್ಲವರನ್ನು ಪರೀಕ್ಷೆಗೊಳಪಡಿಸುವ ಪ್ರಕ್ರಿಯೆ ಪೂರ್ಣಗೊಂಡ ನಂತರ ಅರ್ಹ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಸದರಿ ಕೇಂದ್ರಕ್ಕೆ ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ಆಯ್ಕೆ ಮಾಡಲು ಆಯ್ಕೆ ಸಮಿತಿಯು ತೀರ್ಮಾನಿಸಲಾಯಿತು. According to that, Your Lordship, the committee has been formed at document number 2, Your Lordship, page number 14. ಸಂದರ್ಶಕರು and they have taken interview, Your Lordship, and page number 16 is the result, Your Lordship. ಬಸಮ್ಮ ಗುರುಲಿಂಗಪ್ಪ ದಿಂಡರ್ ಅರ್ಹ, ಪವಿತ್ರ
ಹೆಂಗ್ ನಾವು ಇಂಟರ್ಫಿಯರ್ ಆಗೋದು?
ಇಲ್ಲ, ಅವ್ರಿನ ಕಾಪಿನ ಕೊಟ್ಟಿಲ್ಲ. ಅದು ಏನ್ ಮಾಡಿದಾರೋ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಕ್ರಿಯೇಟ್ ಮಾಡಿದಾರೋ ಅವಾಗ ಮಾಡಿದಾರೋ ಗೊತ್ತಿಲ್ಲ. 5 ವರ್ಷ ನಂತರ ಈಗ ಅವರು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ 5 ವರ್ಷ ನಂತರ ಈಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಇಲ್ಲ, ಅದು ಇಲ್ಲಿ ಗಲಾಟೆ ಮಾಡಿದಾಗಿಲ್ಲ, ಅದು ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ. ಮೇಡಮ್ ಏನು ತರಿಸಿದ್ದಾರೆ ಅಷ್ಟೇ.
ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಗಿವನ್ ಕಾಪಿ.
ಅಲ್ಲ, ಅದು ಕೊಟ್ಟಿದ್ದೆ ಸ್ವಾಮಿ, ಅದು ಕ್ಲಿಯರ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ವಾಪಸ್
ತಗೊಳ್ಳಿ.
ನಲ್ಲಿ ಕುತ್ಕೊಂಡು ತೋರಿಸ್ತೆ ಸ್ವಾಮಿ ಇಷ್ಟೊತ್ತರ್ಗು.
ತೋರ್ಸಾಯ್ತಾ? ನೋಡಿದಿರಲ್ಲ.
ಇಲ್ಲ
ಕುಡಿ ಆದ್ರೆ
ತಗೊಳ್ಳಿ, ನಂದೇ
Yes. Next week, ಕೇಳುವ.
Please,
ಯಾರೋ
please,
ಮಾಡ್ತಾರೆ.
please.
See, committee constituted are persons knowing Urdu.
Please.
They have assessed the fifth respondent. How can I now sit and say you know Urdu or you don't know Urdu?
ಅಲ್ಲ, so many members are there, so many widows are there. ಅಲ್ಲ, ಅವ್ರ ಕಮ್ಯುನಿಟಿ ಅವರೆಲ್ಲ ಇದ್ದಾರೆ, ಅವ್ರನ್ನ ಸೆಲೆಕ್ಟ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, ಮೆರಿಟ್.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಮೆರಿಟ್ ಇದ್ದಾರೆ, ವಿಡೋ ಇದ್ದಾರೆ, ಅವ್ರ ಕಮ್ಯುನಿಟಿ ಒಳಗೆ ಇದ್ದಾರೆ. ಬಟ್ ಇಂಟೆನ್ಷನಲಿ ಇವ್ರನ್ನ ಸೆಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಯಾರು ಬಂದಿಲ್ವಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ.
ಅಲ್ಲ, ಆಸ್ ಪರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರಕಾರ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಕಮ್ಯುನಿಟಿ ಅವ್ರು ಬಂದಿದ್ರೆ ಇಲ್ಲೇ ಕ್ವಾಶ್ ಮಾಡ್ಬಿಡ್ತಾರೆ.
ಪ್ಲೀಸ್.
ಬಟ್ ಲೆಟ್ ಮಿ ಸಿ, ಮುಂದಿನ ವಾರ ನೋಡುವ.
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್ ಪ್ಲೀಸ್.
ನೀವು ನೆಕ್ಸ್ಟ್ ಅಂಗನವಾಡಿ ಕೇಂದ್ರಕ್ಕೆ ಹೋಗಿ.
ಪ್ಲೀಸ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಡೇಟ್ ಮೀ
ಬರ್ಲಿ. ಎಸ್.
73 Sunita Picasso, Chetan Munoli.
Please, your lordships. This is 247A, your lordships.
247A na?
Rule, KCSR rule
Ah,
247A, pensionary benefits.
What pensionary benefits?
If I'm above 30 years, if I have been recruited after 30 years.
8 years qualifying service.
Please, your lordships. And there is already an order, annexure A1, A2, all the orders are there in my favor, where they
How
themselves.
many years of service you spent? 30 years.
30 years. I have.
Excluding qualifying service to be given at 247A.
Please, please.
So maximum pensionable service is 33.
Please, your
So
lordships.
beyond that you will not get. You will get 33 years to be added. 8 years can't be added.
Please, your lordships, for me, this is not 8 years or anything. They themselves have already passed the order saying that you are given this so and so many months and so many years of service for your qualifying service of pension and gratuity. There is an annexure, there is an order in my favor. In spite of that, now they are not giving me the pensionary benefits. That's my.
ಇಲ್ಲ, ಒಂದು submission, your lordship. 247A, your lordship. In case of persons directly recruited after completing the age of 30 years and on. The petition.
ಅವ್ರಿಗೆ ಏಜ್ ಆಫ್ 30 years ಆದ್ಮೇಲೆ
Please.
for them, because 30 years direct recruit ಆದ್ಮೇಲೆ it's 58 years. ಭಾಗವತ್ ಸರ್, ನೀವು ಕ್ಯಾಂಟೀನ್ ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಮಾತಾಡ್ತಾ ಇದ್ದೀರಾ? Yes.
Admittedly, your lordship, the petitioner.
No, that stands to reason. See, because 30 years ನೀವು ಸರ್ವಿಸ್ ಸೇರಿದ್ರೆ ಕಂಪ್ಲೀಟ್ ಸರ್ವಿಸ್ ಮುಗಿಸೋದು 28 ವರ್ಷ ಆಗುತ್ತೆ. So for 247A ಪ್ರಕಾರ to bring you to qualifying service 33 years ಆಗ್ಲಿ ಅಂತ ಅದಿರೋದು. ಅದಕ್ಕೆ ನೀವು ಎಷ್ಟು ವರ್ಷಕ್ಕೆ ಸೇರಿದ್ರಿ?
I have been appointed as a temporary worker, your lordships. The annexure A may kindly be taken.
247A comes into effect only from the date of regular appointment, not temporary.
Regular appointment, they say that, here they have said that to make, your regular appointment is done along with the giving you the benefit of 3 years service, 8 months service to give you the benefit of pension and gratuity. Their specific order is there.
Appointment ಆಗಿದ್ದು ಯಾವಾಗ ಮೇಡಮ್?
Regular appointment ಆಗಿದ್ದು, when they reached 30 years, but they were given the benefit of another extra years of whatever the temporary service. Temporary service. ಅಲ್ಲ, temporary service ನಿಂದ regularization ಮಾಡ್ಬೇಕಾದ್ರೆ ಅವರಿಗೆ
Regularization orderly, from what day regularization comes about? ಯಾವತ್ತಿಂದ regularization order ಯಾವತ್ತು ಮೇಡಮ್?
regularization after my 30 years of my age, they have regularized my service. But
you tell me one thing. When
Please.
did you get appointed on temporary basis?
before 30 years only I have been appointed.
Date ಹೇಳಿ ಮೇಡಮ್, ಶುರು ಮಾಡಿದ್ದು. Dates ಹೇಳಿ.
There are 20 petitioners, your
ಅದು
lordship.
ಒಂದು illustration ಕೊಡಿ.
Please.
In the page number 7, your lordship, they have stated that they are working from 1984. Sorry.
Tell.
Your lordships, annexure A1, page 14, your lordships. It is pertaining to one of the petitioners, wherein I have been appointed in the year 1991, your lordships. 1991, your lordships.
Regularized on what date?
Regularized on 2003, your lordships.
2003.
Please.
What was your age at the time of regularization?
As per the order, whatever they have passed here, ಆದೇಶವನ್ನು ನಿಯಮ ಅನುಸರಿಸಿ 3 ವರ್ಷಗಳ ಸೇವೆಯನ್ನು ಸಕ್ರಮಗೊಳಿಸಿ ಅವರಿಗೆ I'll read the better order, your lordships. Better copy, I'll just.
I think you should
please.
prefer a better petition.
No, there is a better copy of another petitioner.
Yes.
Please, ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದ್ದ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಗಣನೆಗೆ ತೆಗೆದುಕೊಂಡು ಸೋ ಅಂಡ್ ಸೋ ದ್ವಿತೀಯ ದರ್ಜೆ ಇವರ ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ನಿಯಮಗಳ ಅನುಸಾರ 248A ಅನ್ವಯ ದಿನಗೂಲಿ ಹಾಗೂ ತಾತ್ಕಾಲಿಕ ವೇತನ ವೇಳೆ ಸಲ್ಲಿಸಿದ ವೇತನ ಸೇವೆಯನ್ನು ಅವಧಿಯ ಬಗ್ಗೆ 1 ವರ್ಷ 11 ತಿಂಗಳ ಸೇವೆಯನ್ನು ಪಿಂಚಣಿ ಮತ್ತು ಗ್ರಾಚ್ಯುಟಿಯ ಉದ್ದೇಶಕ್ಕಾಗಿ ಅರ್ಹತಾ ಸೇವೆ ಎಂದು ಪರಿಗಣಿಸಿ ಲೆಕ್ಕಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲು ಆದೇಶಿಸಿದೆ. This is the order, your lordships. This is passed with respect to every petitioner. I have produced it in the entire series.
Difficult order. Can't be done at all. Regularization ಗೆ temporary service add ಮಾಡಿ regular employee ಅಂತ treatment. See, 10 years of completed service can be taken for the purpose of regularization. That doesn't mean you will get everything from day one of your daily wage, temporary, contract ಎಲ್ಲ. Regularizations ಈಗ 30 ವರ್ಷ ಸರ್ವಿಸ್ ಆದ್ಮೇಲೆ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ತಾರೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. We pass orders not for payment of arrears of salary, to take that period for the purpose of pension and gratuity, terminal benefits matra.
Please.
Why there is a purpose? Because you have served, you get it. That doesn't mean that you will get salary of a regular employee from that date. That's the whole
It is their own order, your lordships. It is their own order, and this order is of the year 2003.
Wait.
Please, your lordship. Proviso to section 247A, your lordship, wherein it stated that, your lordship, provided that addition of qualifying service under this rule is not admissible to employees who were earlier working on daily wage basis.
It can't be, that is correct. It can't be. Why did you pass that order?
Please, your lordship, and admittedly they are already, they have given the
When
benefit.
the rule is very clear, why did you pass that order?
248A benefit already they are enjoying, your lordship.
Why did you pass that order? Qualifying service ಹೆಂಗ್ ಕೊಡ್ತೀರಾ ಇವ್ರಿಗೆ? ಹಳೆ ಸರ್ವಿಸ್ ಸೇರಿಸ್ತೀರಾ?
But 247A.
ಈಗ ಪ್ರೊರೇಟ ಎಷ್ಟು ಸರ್ವಿಸ್ ಮಾಡಿದರೆ ಅಷ್ಟು ಪೆನ್ಷನ್ ಬರುತ್ತೆ.
And one more thing, in addition, this is one leg of my argument. The other one is, your lordships, my colleague gets the same benefit, 247A. The person who is working along with me, one person gets the benefit, and I am being deprived out of.
It's all right. Two wrongs can never make a right.
Negative
There is
parity cannot be
There is no
sorted.
concept of negative equality in law.
Your lordships, but the thing is that my right to equality is also.
Negative equality ಇಲ್ಲ, right to equality ಅಲ್ಲಿಂದ ಬಂತು. You are claiming parity, not equality.
I'm claiming clarity, your
You
lordships.
claim parity.
There is an order, 2020, they passed the.
In your claim of parity, there is no clarity.
Your lordships, judgment of yours also.
ಕೊಡಿ, ಕೊಡಿ. ನಾವು ತಪ್ಪು ಬರ್ದಿರ್ಬೋದು, ಹೇಳಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ, correct.
ಇಲ್ಲಿದೆನಾ? Grant of audit, I have followed another coordinate bench, madam.
Please, your lordships.
Not my order completely.
Your lordships have followed the order.
No, since I followed coordinate bench order.
Please, your lordships.
Not even. ಯಾವ್ದು benefits?
This proviso is not been taken into
ನೋಡಿ,
consideration, your lordship, ಅಲ್ಲಿ ಅದರಲ್ಲಿ.
Even that judgment also I am trying to take it, your lordships.
Trying, ಅದ್ರಲ್ಲಿ number ಇದೆ, trying in, yes.
ಅಲ್ಲ, that the only submission is, your lordship, daily
Day after
wage.
tomorrow I'll take it. Please, day after tomorrow. ಅದು ಅಮಿತ್ ಕುಮಾರ್ ದೇಶಪಾಂಡೆ ಅವ್ರ ತಗೊಳ್ಳಿ. ಇನ್ನ ಮುಗಿಸ್ಕೊಂಡು ಪ್ಲಿನರಿ ಮುಗಿಸ್ಕೊಂಡು ಕೊಡಿ.
24.
Tomorrow.
A.B. Ballari. Nagaraj C. Kolluri.
I'm appearing for respondent number 3, lordship.
It was the refer for settlement, my lord. Petitioner, he was ready to pay 24 lakhs. And now, my lord, my learned friend is now here, insisting that to pay 26 lakh 70,000, my lord. What I'm submitting, my lord, kindly refer the matter to the mediation, my lord. I tried to convince.
The parties to the list are in dispute over 2,70,000. The petitioner is ready to pay 24 lakhs.
24 lakhs.
The respondents are demanding 26,70,000. Therefore, the parties shall appear before the mediation. For mediation at the mediation center. Mediation center so and so on Saturday.
Please.
15th. Saturday district court working.
Any working day, my lord, otherwise.
Saturday is a working day.
mediation they got.
Okay, list on Monday at 4 PM. Agata?
Anytime, my lord. They will take
At
up
4
whenever
PM.
the parties will
The
come. my
report
lord.
of mediation shall be placed before this court on 21st.
Please.
List on 21st in the first matters list. Next.
Bill number 75, Suhas K. Usmani, Ramchandra Imani.
For petitioners, your lordship, the petitioners are before this court seeking a writ of mandamus for consideration of promotions, your lordship. They are-
Mandamus consideration promotion and you are
Like,
entitled.
they are eligible, your lordship. Their promotions have been withheld on the ground that there is a pending writ
Appeal
appeal.
ಏನಾಯ್ತು?
My lord's appeal in that pay scale will be subject to the writ appeal.
The division bench wide order on 28/1/2025.
21st, list on 21st. Yes.
Please.
Next.
Much obliged.
76, Kishore Sudhakar Sukha. Viraj Hiremat.
Lord, in this case,
It's a dismissal
I
for
will-
Gram Panchayat
I have to
employee
file
without
my
holding any
objection,
inquiry
Lord.
minutes. Without holding any inquiry minutes, Gram Panchayat
Covered,
employees.
sir.
no, my lord, it is not at all like a termination ಆಗೋದಿಲ್ಲ. Termination ಅಲ್ಲ ಇದು. This is not the termination.
Conviction.
Termination ಅಲ್ಲ.
ಮತ್ತೆ ಏನ್ ಮಾಡಿದೀರಾ?
My lord, the order is that
What? Where is the impugned order?
My lords, annexure F, my lords.
Annexure?
F, my lords.
Page.
Page number 34, my lords. It's a defective order, my lords. I receive a show cause notice on 26th.
Page.
34, my lords, page number 34.
ಮನ್ರೇಗಾ ಯೋಜನೆ ವಿಭೂತಿ ಪರಶುರಾಮರ ಪಂಚಾಯತ್ ಇಲ್ಲಿಂದ ಕೊಡುಗೆ ಮಾಡಿ ಅವರ ತಾಲೂಕು ಪಂಚಾಯತ್ ಮಾಡಿಕೊಟ್ಟು ಪಾಸ್ ಮಾಡಿ 34 ಏನಿದೆ ನಿಮ್ ತೆಗ್ದಿದ್ದಾರೆ ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
My lords, third line, my lords, last third line.
ಏನು?
ಶ್ರೀ ಜ್ಯೋತಿಬಾ ಪರಶುರಾಮ್ ಪಾಕ್ರೆ ಇವರಿಗೆ ಪಂಚಾಯತಿಂದ ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋರ್ ಇಂದ ಇಲ್ಲಿಂದ ಕಡಿಮೆ ಮಾಡಿ ಅವರು ತಾಲೂಕಾ ಪಂಚಾಯತಿಂದ ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಳ್ಳಬೇಕು. My lords, I am not a, my lords, I am not a, I am not an employee under section 113, my lords.
Yes. Learned counsel Shivraj Hiremat seeks 2 weeks time to file statement of objections. Objections, if any, by the 25th of so and so. List on 27th.
Please.
77, Y. Lakshmikant Reddy.
Lordship, may I seek?
Huh? Thank you. Yes. List after 2
78,
weeks.
Sir Hiremat.
I think compromise decree challenge ಮಾಡಿದ್ದೀವಿ. We have challenged the compromise decree.
Respondent.
For the respondent.
What happened is the ancestor property, this is admitted. Ancestor property is admitted, my lord. Ancestor property is admitted. What happened is, the father brothers are not made as a party to the proceedings.
You are for the respondent. You're ready.
Please.
Monday or Tuesday, Monday,
Much
fresh matters. Next.
79, SB Deyananavar.
ex parte interim order came to be allowed, my lord.
Ex parte maintenance.
Ex parte came to be allowed.
ಎಷ್ಟು?
3,000 per month.
Enhance ಮಾಡೋಣ?
My lord, she is not married wife.
Not what?
Valid marriage, not valid marriage.
Not?
Not valid marriage.
Page ಸ್ವಲ್ಪ.
Page number 30 may take into consideration, my lord.
Mike.
Page number 30. I have filed
You are the husband.
Husband.
3,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರಾ?
3,000 rupees, sir. My lord, she has already married. Her husband is dead. The suppressing the genuine fact. She has married with this petitioner. So I have taken the contents and she is not.
She has married you, right?
Married. But
so-
husband is there. Married life is.
ಅದು ಗೊತ್ತಿಲ್ಲ. She has married you.
My lord, suit for
Partition.
Suit for wide marriage null and void I have filed. Family court.
ಸೂಟ್ ಡಿಗ್ರಿ ಆದ್ಮೇಲೆ ತೊಂದ್ರೆ ಇಲ್ಲ. ಅಲ್ಲಿವರೆಗೂ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ಬೇಕು.
My lord, husband is there. First husband is there.
Can't help. You are also the husband.
At least we will deposit the amount with this court.
Oh no.
At least
1,000 rupees.
But not to withdraw the amount. We will deposit the amount this honorable court.
Where is with whom is she living now? Her husband?
I have taken the name of this first husband, page number 33, my lord.
If you have taken the name, what should the court do for that? In name is important. Husband ashte.
Husband, but not valid marriage. Suppressing the genuine fact that he
That
is
is
married.
before the court. Anything else, sir?
This much is, sir.
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ
It's my-
ಅವ್ರು ಬಂದಿಲ್ಲ ಇಲ್ಲ ಜಾಸ್ತಿ ಮಾಡ್ಬೋದಿತ್ತು ಸರ್.
ಅಲ್ಲ ಶೂಟ್ ಡಿಗ್ರಿ ಆಗೋ ಮಟ್ಟ ಒಂದು ಸ್ವಲ್ಪ
ಆಗು ಮಠ ಇಲ್ಲ ಆಗು ಮಠ ಕೊಡ್ತಾ ಇರಿ ಆಮೇಲೆ ನಿಲ್ಸಿದ್ರೆ ಆಯ್ತು.
She has got every right to claim the maintenance from her first husband.
ಅಲ್ಲೂ ತಗೊಂತಾ ಇದಾರಾ?
ಅಲ್ಲಿ ಕ್ಲೇಮ್ ಮಾಡ್ಬೋದು ಅವರು.
ಮಾಡ್ಬೋದು.
ಮಾಡ್ಬೋದು.
ಯಾಕೆ ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ ಅವ್ರೀಗ?
ಅಲ್ಲ
ಇಬ್ರು ಹಸ್ಬೆಂಡ್ಸ್ ಇದೆ, ಜಾಯಿಂಟ್ ಅಂಡ್ ಸೆವೆರಲ್.
My lord, immediately after marriage, he came to know about the first marriage. She denied to lead married life.
Yes, sir. ಅಷ್ಟೇನಾ?
No marriage consummation, my lord. Immediately after coming to know about this fact.
But your dissolve ಆಗಿಲ್ವಲ್ಲ ಇನ್ನು. ಡಿಸಾಲ್ವ್ ಆಗೋವರೆಗೂ
ಅಲ್ಲಿ ಮಟ್ಟದ ಸ್ವಲ್ಪ at least
ಅಲ್ಲಿ ಮಟ್ಟ
we
ಕೊಡ್ಲೇಬೇಕು.
will close immediately.
ಅಲ್ಲಿ ಮಟ್ಟ ಕೊಡ್ಲೇಬೇಕು.
Expert order are in place. At least I may permit to file objections and take the contention before the family court takes the order.
ಇಂಟ್ರಿ ಮೇಂಟೆನೆನ್ಸ್.
Interim maintenance.
ಮತ್ತೆ ತೊಂದರೆ ಇಲ್ಲ. ಎಷ್ಟು ವರ್ಷದಿಂದ ಕೊಟ್ಟಿಲ್ಲ?
ಈಗ ಒಂದು ವರ್ಷ ಆಯ್ತು.
ಈಗಾಗಿದೆ. The petitioner is before this court calling in questions also. The petitioner is the husband. According to the learned counsel appearing for the petitioner, he is the husband, is the second husband. During the subsistence of the marriage with the first husband suppressing the same, the respondent wife is said to have married the petitioner. After the relationship between the husband and the wife flounders, the wife is said to have instituted proceedings invoking section 125 or Hindu Marriage Act. ಯಾವುದರಲ್ಲಿ?
Hindu Marriage Act.
Invoking section 24 of the Hindu Marriage Act seeking interim maintenance at the hands of the husband hyphen the present husband hyphen the petitioner. The learned counsel, the husband is at the doors of this court on the score that the wife has married the present petitioner without divulging the fact that the first marriage was still in subsistence, and therefore on coming to know of such marriage has filed an appropriate petition before the concerned court seeking declaration that the marriage with the present petitioner is null and void, and therefore submits that the amount of maintenance at 3,000 rupees should not be permitted to be executed. The submission is noted only to be rejected. The petitioner and the petitioner husband and the respondent claimant wife are married. Whether the marriage is valid or not is still to be tested before the concerned court, where the petitioner has instituted proceedings to declare the marriage is null and void. Reasons may be manifold, but as long as the petitioner is as long as the marriage between the petitioner and the respondent wife is in subsistence or unless dissolved by a manner known to law, the petitioner is bound to maintain the wife, and the amount so awarded is at rupees 3,000, which is not so exorbitant for this court to intervene on the said submission and obliterate the said order. Finding no merit in the petition stands rejected.
Lord, he is executive coolie. It is 1,500,000.
Coolie?
Coolie. He is executive coolie. He is not having any other.
Skilled, unskilled. Skilled labor.
My lord. He has mentioned he is agriculture coolie in his fits.
Parole, yes.
1,500 marks. It is 1,500,000.
No bargain. Yes.
No other source of income, my lord.
No, sir.
Except coolie, no other source of income.
Except coolie, search a better job. Yes. You have to fight litigation also. You have to search now. Yes. Next.
81 Sirajuddin Ahmad.
ಏನಿದು?
Parole petition, my lords, 12 year 2 months, my lords.
ಎಷ್ಟು?
12 year 2 months, my lords. 3 months he has been availed parole earlier, my lords.
General parole, my lords.
ಗಂಗಾಧರರು ಬಂದಿದ್ದಾರಾ? ಇದು petitioner is before this court calling in question, seeking grant release of ಯಾರು? ಹಸ್ಬೆಂಡ್ ಯಾರಿದು? Husband on parole.
No, my lords. Is son, my lords.
Son of the petitioner. Sorry. The mother of the convict is before this court seeking release of his son on grant of parole, who has now been in prison for the last 12 years and 2 months pursuant to the order of conviction of the Court of Session for offences punishable under section 498A 304B read with 302 of the IPC. It transpires that the petitioner, the son has availed parole on earlier
3 months.
occasion and 3 months parole on earlier occasion and has returned to the goal. And there is no report that is adverse to the petitioner at the time when he was out on parole. In that light, I deem it appropriate to grant to the petitioner general parole for a period of 60 days to commence.
Application is 30 days. ಅವರೇ ಹಾಕಿದ್ದಾರೆ.
30 days.
30 days.
For
No,
a period
my
of that-
my lords, application is according to the rules they have presented 30 days,
for
my
a
lords.
period of,
After 30 days.
for a period of 60 days from the date of, to commence from Saturday. To commence from Saturday. With reserving liberty to the petitioner to seek extension of parole on his return to the goal after the expiry of period of parole, subject to the following conditions.
Next to put. Next to
ಅದೇನಾ?
ಅದಿದೆ. ಅದರಲ್ಲಿ
82 also same, my lords.
24.
6 year, my lords.
20th May 24. There is 30 days.
6 years.
6 years?
6 years, 6 months he has undergone, my lords.
6 years, 6 months. And earlier had been granted parole anta ಮಾಡಿ. ಇದರಲ್ಲಿ ಸೇಮ್ ಕಂಡೀಷನ್ಸ್ ಇಲ್ಲೇ ಇದೆ. ಕೃಷ್ಣಕುಮಾರ್ ಅವರು ಇದನ್ನ ಇವ್ರದೇ ಸೇಮ್. ಎಸ್ ಡಿಸ್ಪೋಸ್ ಸಾಕು ಐದು ತೋಡಿ ಗಂಗಾಧರ್ ಅವರು ತೋಡಿ.
158. Serial number 158. Procedural. J. Gachimad.
Others need not wait. This may take some time.
Let's one submission, let's.
Serial number 1.
ಗೊತ್ತು ಏನು ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ ಮತ್ತೇನ್ ಪ್ರಾಬ್ಲಮ್ ಅದು ಇಲ್ಲೇ ಇರ್ಬೇಕು ಎಲ್ಲೂ ಹೋಗಲ್ಲ ಇಲ್ಲಿದೆ ಟೈಮ್
Submission. 119 Malords have filed an application for direction. There is an interim order, but still, Malord, there is some violation by the.
We'll see.
Tomorrow, may I request?
ಏನ್ ಸರ್
ಅಲ್ಲ ಅಂದ್ರೆ ಅದು the annual Malord Urs and Sandal are to be held from 18th of this month.
ಬಲ
Urs and Sandal, it's a masjid, Malord. Urs petitioner is the Mutwalli since his days of his fathers in the year 1954. Now, Malord, the person acting under Malord the district.
Matters which have not reached. ಯಾವ್ದಾರು ಆಗ್ಲಿ.
Malords 155 Malords.
ಸರಿ ಏನಾಯ್ತು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅದನ್ನ ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕರೆದ್ಬಿಡಿ.
Serial number 160 Malord. For the hearing.
Tuesday.
19 may I seek on Thursday at least, Malords.
1 minute. 151 ಎಲ್ಲಿ ಇವರು ದಿನೇಶ್ ಕುಲಕರ್ಣಿ ಇದ್ರಲ್ಲ.
Tuesday 4 p.m. Malord.
10 days time is granted to do the next.
But serial number 160 Tuesday at 4 p.m. Malord.
Sir, wait sir. ಪಾರ್ಕ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಇದ್ದೀರಾ?
wait sir.
ಕೋರ್ಟಲ್ 2A ಎದುರುಗಡೆ.
Yes. Learned Counsel submits office 152, 153, 154. 156. Learned Counsel submits office objections have been complied with office to verify, and in the event they stand complied, list those matters on Friday in the fresh matters. ಮಾಡಿ yes. Typed copy ಆಗತ್ತೆ ಕಷ್ಟನಾ ಮೇಡಮ್? ಡಾಕ್ಟರ್ಸ್ ಅರ್ಥನೇ ಆಗಲ್ಲ, ನಮ್ಗೆ ಅರ್ಥ ಆಗಲ್ಲ, ಅವ್ರಿಗೆ ಅರ್ಥ ಟೈಪ್ ಕಾಪಿ. Yes. ಯಾವ್ದ್ರಲ್ಲಿ ಟೈಪ್ ಕಾಪಿ? The demand of typed copy by the registry stands dispensed with, except this objection, every other objection is said to have been complied. In the event they stand complied, list the matter on Friday in the fresh matters.
Malords 155.
Registry ಹೇಳ್ಬೇಕು. Yes.
My lord, serial number 102 and 103, same objection, my lords. Typed copy. my
Parole
lords.
kotte ಆಯ್ತು 102 103 wait sir. FDT 155.
Please, my lords.
Girish, FDT na?
FDT, my lords.
FDT covered, disposed.
Please, my lords. Much obliged.
155. FDT Forest Development Tax. Huh? For what? For what?
Memo with documents, Your Lordship.
ಅದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ, ಫೈಲ್ ಇಟ್ ಇನ್ ದಿ ರಿಜಿಸ್ಟ್ರಿ. ಎಸ್
136 and 139.
ಎಲ್ಲ ಟ್ಯೂಸ್ಡೇ ಎಲ್ಲ ಟ್ಯೂಸ್ಡೇ, ಬೇರೆ ಯಾವ್ದಕ್ಕೆ ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ಕೇಳ್ಬೇಡಿ.
147 ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್
ಎಲ್ಲ ಟ್ಯೂಸ್ಡೇ. ಪಾಸ್ ಓವರ್ ಯಾವ್ದು? ವೇಟ್, ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಮಾತಾಡ್ಲಿ ಬಿಡಿ ಅವರು, ನಿಮಗೇನ್ ಪ್ರಾಬ್ಲಮ್? ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫ್ ಮಾತಾಡ್ತಿದ್ರೆ ನಿಮಗೇನ್ ಪ್ರಾಬ್ಲಮ್?
119 may seek on
election
Thursday, my lords.
147 election matter.
ಕವರ್ಡ್
ಇದೆ. Fresh matters ಎಲ್ಲಾರು at least, my lords.
ಅಲ್ಲ, BMSPG ಆರ್ಡರ್
147
ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಸಾಹೇಬ್ರ ಆರ್ಡರ್
ಅಲ್ಲ, ತಮ್ದೆ ಇದು ರೈಟಿಂಗ್ ವೋಟ್ ಕೊಟ್ಟಿರೋದು. ಎಲೆಕ್ಷನ್ ಇದಾಗಿದೆ, ರೈಟಿಂಗ್ ವೋಟ್ ವಾಸ್ ಗ್ರಾಂಟೆಡ್.
Not to declare it.
ನಾಟ್ ಟು ಡಿಕ್ಲೇರ್ ಅಂತ ಇದೆ ರಿಸಲ್ಟ್ ಅಂತ.
ನೀವು ಪೆಟಿಷನ್
produce all the records, lordship.
ಆಯ್ತಾಯ್ತು. ಓ, ಅದನ್ನ ತಂದಿದ್ದಾರೆ ರೆಕಾರ್ಡ್
ಇದೆ.
ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅಂತ ಅವರೇ ಹೇಳ್ತಾರೆ. ಅವ್ರು ಮತ್ತೀಗ
ಯಾವತ್ ಬೇಕು?
ಟುಮಾರೋ ಮೇಲಸ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್.
ಟುಮಾರೋ ಆಗಲ್ಲ ಸರ್.
ಅಲ್ಲ, ಡಿಕ್ಲೇರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತಿಲ್ಲ. ಉಳಿದ ಕಾನ್ಸ್ಟಿಟ್ಯೂನ್ಸಿ ಮಾಡಿದ್ದೇವೆ.
ಆಗ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಅದು ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ತಗೊಳ್ಳು. ಎಸ್,
ಇನ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಎಸ್, ಎಲೆಕ್ಷನ್ ಅಲ್ಲ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಪ್ಲೀಸ್.
ಮಿಕ್ಕಿದೆಲ್ಲ ಟ್ಯೂಸ್ಡೇ. ಎಸ್, ಟ್ಯೂಸ್ಡೇ.
Your Lordships, serial number 99.
Next Tuesday or this Tuesday?
Your Lordships, this is a matter remanded by division bench matter, Your Lordship.
No problem. ಹಾಗಾದ್ರೆ next Tuesday.
Your Serial number 105. ಅದು ಒಂದು ವರ್ಷ they are enjoying
the demand by division. Yes.
The direction to the submit the report.
ಆಯ್ತು, ಅವತ್ತು ನೋಡಿ ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕ್ಸ್ತೀನಿ. ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಎಸ್, ನೆಕ್ಸ್ಟ್
87
ವಿಲ್ ಕಂಟಿನ್ಯೂ.
ಪ್ಲಸ್ 95 ರಿವ್ಯೂ ಪಿಟಿಷನ್ ನೆನ್ನೆ ಮೂವ್ ಮಾಡಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 95.
ಏನ್ ರಿವ್ಯೂ ಪಿಟಿಷನ್?
ಅದೇ they have suppressed the earlier writ petition filed which has been dismissed by 95. ತಮ್ಮದೇ ಆರ್ಡರ್
ಇಲ್ಲಿ ಬಂದ್ಮೇಲೆ ಮಾಡಿರದ ಮುಂಚೆ
ಮೊನ್ನೆ ಲಾಸ್ಟ್
95
order is quashed by Lordships on 17th.
ಕೊಡಿ ನೋಡಿ, ಒಂದೇ ನಿಮಿಷ. 95 ಕೊಡಿ ಮಾಡಿ. There is suppression, we'll see.
Before the work order was issued to me, the very petitioner files a writ petition before this honorable court.
Where is dispose? Copy ಬಂದಿಲ್ಲ ಇನ್ನು?
ಇಲ್ಲ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. ತಮ್ಮ ಆರ್ಡರ್ ಪೇಜ್ ನಂಬರ್ 14 ಅಲ್ಲಿ. The earlier order minutes which he had filed a writ petition seeking a mandamus to issue work order.
ಒಂಟಿ ಅವರು ಇದ್ರಲ್ಲ ಇಲ್ಲಿ.
Page number 28 ಅಲ್ಲಿ earlier order. Same contentions were urged and his writ petition was dismissed. Stage was
ಅದೇ ಕ್ಲಾರಿಫಿಕೇಶನ್, ಎರಡು ಕ್ಲಾರಿಫಿಕೇಶನ್
that contentions were already urged. This petition was
which judgment is that?
The Lordship said page number 28.
You were present that day.
My colleague, no, to this we were not parties.
Who was? Gayatri was present, is it?
No, the Mike Joshna and Vishwanath had appeared.
Yes, Vishwanath had appeared.
Yes,
correct.
No, for this we were not parties. Only the government was made as a party and a mandam was sought to issue a work order to them.
Oh, earlier order.
Yes. Whatever contentions were urged before your Lordship's minutes, all those were urged, including the clarification which was now interpreted.
Same petitioner?
Same petitioner.
And this is suppressed?
This is suppressed in the writ petition.
ನಿಮಗೂ ಗೊತ್ತಿಲ್ವಾ?
ಗೊತ್ತಿಲ್ಲ. That's why my lords are given that circular.
ನೀವು ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಈಗ?
Now supply ಮಾಡ್ತಾ ಇದ್ದೀವಿ. Your Lordship said protected that. No, but your Lordship's direction to now evaluate the entire process.
This court, by an order dated 17 January 2025, disposed the petition by observing as follows. Para 17 matra quote ಮಾಡಿ. The learned counsel Mallikarjun Swamy Hiremat now files a petition for review on the score that there has been suppression of facts by the petitioner who secured the order at the hands of this court. He had approached this court on the very same ground, very same contentions in writ petition 105309 of 2024, and the coordinate bench by its order dated 20th September 2024 had dismissed the petition. Suppressing this fact, the subsequent petition is preferred and an order is passed. In the light of the aforesaid fact, the order and the effect of the order dated 17 January 2025 in writ petition 100919195 shall remain stayed.
Serial number.
Sir, 120.
Serial number 105.
ಎಲ್ಲ RP ಒಂದೇ ತರ ಇರಲ್ಲ ಮೇಡಮ್, ಇಟ್ಸ್ ಸಪರೇಷನ್ ಟ್ಯೂಸ್ಡೇ.
Serial number 105. May I request on 13th, senior counsel is appearing, my lords.
No, I beg to appear for the petitioners in this matter, my lords.
Which one? Which one?
Serial number 105. In that, my lords, they have taken an interim order. They have neither paid the process or nothing, my lords. We had to do.
ಏನಿದು?
Process. Surfacey matter. Interim order is granted by this honorable court. Process was not paid till yesterday or day before yesterday.
Yes, Ajay.
My lords, we have intimated the bank, my lords, as on the day when the my lords order was passed by this honorable court. My lords,
Anyway, let it come
day
on
before
Tuesday.
yesterday, my lords, 45 lakhs has already been paid. My lords, ultimately, my lords, what should the bank be interested in? Bank, my lords,
ದುಡ್ಡು ಬಂದಿದೆ ಅಲ್ವಾ?
my lords, 45 lakhs has been paid day before yesterday.
It's on Tuesday, same, no change. No, nobody please ask for any change, all on Tuesday.
Your lordship, serial number. Your lordship, serial number 121, your lordships. Interim order may be extended, your lordships.
It will be extended, don't worry about that, yes.
My lord, serial number 92.
120?
Tuesday ಬರುತ್ತಲ್ಲ?
1. Yes, ಅಷ್ಟೇ.
My lord, I had moved a memo for 2:30 today. I had moved a memo in the morning session.
Withdrawal?
Not withdrawal, my lord. The matter did not reach. Kindly have that matter tomorrow.
ಯಾವುದು? withdrawal ಮೂವ್ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ withdrawal ಅಲ್ಲ ಸರ್, 2:30 ಗೆ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ದೆ.
ಬಂದಿಲ್ವಲ್ಲ?
ಬಂದಿಲ್ಲ. Kindly have that matter.
ನಾಳೆ ಬರುತ್ತೆ.
ನಾಳೆ.
serial number 8. ಎಲ್ಲ ಟ್ಯೂಸ್ಡೇ. Please stay. ಎಲ್ಲ ಟ್ಯೂಸ್ಡೇ. Yes.
158 Shiva Shirur. Intimate Prakash Patil.
My lord, sir. Annexure A is the order which is challenged. Page number page 25 and 26, my lords, I only had to point out.
Oh, there's a detailed order passed. I think the AAG had to submit. Yes.
Please.
My lord, the entire case of the petitioners depend upon annexure C and E, my lord. As per annexure C, my lord, they claimed that this is a grant given by under the Bombay Revenue Code. So therefore, they are entitled the land as per the annexure C. They construed this document as a grant certificate. Annexure C, my lord. Page 29, my lord. Typed copy of that is at 31.
All right, that is 1952.
Please, my lord. This they claim that this is a grant, my lord.
1953. All right. Yes.
That is issued on 1952, my lord. This they claim that this is a grant certificate. And correspondingly, they also argued that annexure E is a document. It is an D utar, which mutation copy, which is re-grant was made in favor of the wife of the person who is grant has been made. These two primary document, their entire case is rest upon these two documents. My most respectful submission is that, my lord, the first document is not a grant, it is a lease for the period of limited purpose.
What purpose?
They can hold the land to every year. It is ek saal lavani.
Ek saal?
Ek saal lavani. It is not a grant at all. So therefore, they can't claim that there is a grant in favor of the petitioner. I will demonstrate, my lord, why it has been not a grant. It is only a lease. Second, my lord, document number E, that is a mutation entry. They claim that was after the death of their husband.
it has been re-granted in their favor. It is their case that it is re-granted in their favor. These two documents they relied upon, and now in the year 2021 they started agitating that they approach this honorable court saying that there is a grant in favor, so therefore you either give that land or pay the compensation under 2013 Act. These are the two prayers. But I request my lord to kindly see the mutation, the records of rights produced by the petitioner at page 40, which categorically says it is a ek saal lavani. And if there is a re-grant in favor of the wife in the year 1966, kindly take the annexure G, page 67, the representation. They are contending that on 24/1965 there is a re-grant in favor of the petitioner's wife. Annexure G, Malad, is a representation submitted by the wife, Yashoda Bai, saying that in the 1963, I was advised by the Malamdar not to cultivate the land. So also they are saying that in the 1965 there is a re-grant. If there is a re-grant as per annexure E, the annexure G, she could have been say that I have already re-granted by this number, so corresponding entries have been made in.
According to you, it is no grant at all.
Not grant at all. It was they are in the possession of the property till 1964 as a X. The revenue records are indicating that it's X Lavani. The document about the X Lavani, status of X Lavani. This is then from the collections of government orders under the Bombay Revenue Code, original book itself I am producing, which indicates that it is all renewable one. Those who are third. The third one, the extension of period of Eksa Lavani, a period of Eksa Lavani, lease, that's second one. Emerged areas where the forest areas have not been demarcated and the permanent disposal of land is likely to be take a time. Iduk ಮಾಡ್ಕೊಟ್ಟಿದ್ದೀನಿ ಫಸ್ಟ್ ಫ್ಲಾಗ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದೀನಿ ಎರಡನೇ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಅದು 24th November 1953 ಅಲ್ಲಿ period of lease. Correct. In merged areas where the forest areas have not been demarcated and permanent disposal of the land is likely to take time, the lease of land such area may be continued for a period of 3 years as on the case of initial leasing instead of annual basis. So all this next again extension of period of
acres is
15 acres.
Now they are claiming ownership of 15 acres.
15 acres. It is now after, and they are, admittedly they are not in a possession from 1965. No litigation. Only few representations they have given. Subsequently, it was granted in favor of the one cancer hospital cooperative society in the year 1965. They are in the possession. They have not been constructed the hospital. They have not constructed the hospital. They have not constructed. Therefore, their order has been cancelled. The grant has been cancelled.
Now, in whose position is the land?
Now it has been it is declared as slum area.
Oh, slum. Yavaga? Section 3 order yavaga madare?
Adu first order has been done in the year 1920. Subsequently, 1923 second order has been. Two orders have been passed.
1923.
Sorry, 2023. 2023 ಅದಕ್ಕಿಂತ ಮುಂಚೆ 2021 ಅಲ್ಲಿ ಮಾಡ್ತಾರೆ. That was in the litigation that was quashed by this honorable court. The final order was passed on 73/2023. From the 1964, as per their own admission, they are not in the possession of the land. Their entire claim is depend upon the interpretation of annexure C as well as annexure E.
It is grant order.
Grant order. They claim that it's a grant order. So, but the revenue records are indicating that it's only X allowed. So therefore, my lord, the annexure C and E cannot be construed as a document. And moreover, my lord, if they are claiming that the re-grant, in the petition, they have stated that the re-grant in favor of the wife. That is in the year 1964, after the Land Revenue Act came into force. There is no provision to re-grant 15 acres of land in favor of anyone. And the document, they have mentioned.
But ex allowance can take place.
Ex allowance can be take place. That is till it was extended till 1964, till it was given to the cancer hospital.
Presently it's a slum.
Slum, and they are not in a
declared slum.
Declared
slum.
slum.
Section 3.
Yes.
Where are those notifications?
Please. In the statement of objection filed by the state, which we have. Annexure R13, page 95.
Page 95.
Annexure R30. We have filed two statement of objection. 17/12/2024 one objections have been filed. In that annexure R.
Objections ಎರಡು ಹಾಕಿದ್ದೀನಿ.
ಎರಡು ಹಾಕಿದ್ದಾರೆ.
ಅದೇ ಏಕೆಕ್ಸಾಲ್ ಒಂದೊಂದು ಹಾಕಿದ್ದೀರಾ. ಎಸ್. ಇಲ್ಲಿ ಒಂದು
page 95.
ಇದು additional, I am holding additional statement of objections.
This way of
ಯಾವುದು ನೋಡಬೇಕು?
Additional statement of objection filed on 17/12/2024.
Page 95
Page 95. Yes.
ಯಾವುದು ನೋಟಿಫಿಕೇಶನ್ ಇದೆ?
ನೋಟಿಫಿಕೇಶನ್ ಅದೇ
ಅಂತಿಮ ಅಧಿಸೂಚನೆ. Section 3 notification.
Correct.
Declaring it to be a slum.
ಹೌದು ಸರ್. But before that, there was a litigation between the cancer hospital and government. That order at annexure L. In respect of the same land, annexure L, page 54, and the writ petition. We have cancelled the grant in favor of the cancer hospital. They have questioned it
without notice. So
that was questioned. That is again there may be one more order at annexure E. They said, give me the opportunity of hearing. Ultimately, that all the revenue records, the name of this government has continued for last 40 years. Now, because of the continuation, because of the unauthorized occupants of this thing, because of that, under the notification section 3, it was declared as a slum board. Property belonging to the slum board. So therefore, my first submission is that, this is the annexure C cannot be construed as a lease, or sorry, as a grant. It's only lease. And annexure E never confirmed the title. It's a only revenue entry, and the original documents are also not available. And we are not accepting that. In terms of the representation at annexure G, J, they have categorically stated they have not in a possession from the 1964. And also, kindly take another representation at annexure J. They requested for the grant of 2 acres. Kindly take the annexure J, the representation, page 72. Page 72 also. 72 page. This was representation given in 87. She has claimed that ಈಗ ಸದರಿ ಜಮೀನು 15 ಎಕರೆ ಗುಂಟೆ ಇದ್ದು ಇದರಲ್ಲಿ ಇಂದಿಗೆ 13 ಜಾಗೆಯು ಅತಿ ಅಕ್ರಮ ಇದ್ದಲ್ಲಿ ಹಲವಾರು ಮನೆ ಕಟ್ಟಿಕೊಂಡು ವಾಸವಾಗಿರುತ್ತಾರೆ. ಈಗ ಕೇವಲ 2 ಎಕರೆ ಜಾಗ ಮಾತ್ರ ಉಳಿದಿರುತ್ತದೆ. ಈ ಬಗ್ಗೆ ತಹಸೀಲ್ದಾರ್ ಒಬ್ಬರು ಸರ್ವೆ ಮಾಡಿ ವರದಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಈಗ ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸಿಕೊಳ್ಳುವುದರಿಂದ ಈಗ ನಮಗೆ ಕುಲ ಇರುವ ಜಾಗವನ್ನು ಮಂಜೂರು ಮಾಡಬೇಕಾಗಿ ಕೇಳಿಕೊಳ್ಳುತ್ತೇವೆ. They requested for remaining 2 acres of the land. So nowhere in any of their representation, nowhere stated that the land is re-granted in favor of the wife as claimed by the petitioner at annexure E. And there is a delay of 50 years.
Yes, Amit.
My lords, may I?
You have heard everything?
Yes.
I'll take it at the same time on Thursday. Please.
Grateful.
Yes, same time on Thursday. We'll close it on Thursday.
Yes.
Heard the learned Additional Advocate General, who has completed his submissions. To hear the learned Senior Counsel Amit Kumar Deshpande list the matter on Thursday at 4:30 p.m.
Great.
Yes. ನೀವೆಲ್ಲ ಕೆಲಸ ಮುಗಿಸ್ಬಿಟ್ಟು ಆಮೇಲೆ ಬನ್ನಿ ಇಲ್ಲಿ. We will hear it. Yes. All right. Parties ಕಾಯ್ತಾ ಇದಾರಲ್ಲ ತಗೊಳ್ಳಿ. Husband and wife.
157.
ಏನ್ ಸೆಟ್ಲ್ ಆಯ್ತಾ?
ಇಲ್ಲ ಅಂತ ಇದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು.
ಯಾರು?
ಹಸ್ಬೆಂಡ್. ದುಡ್ಡು ಆಗಲ್ಲ ಅಂತ ಇದ್ದಾರೆ.
ಎಷ್ಟು? 3 lakhs?
ಅದಕ್ಕೂ ಇಲ್ಲ ಅಂತ ಇದ್ದಾರೆ.
ಸರಿ, ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ. No problem. We'll pass orders on merits.
Please,
List the matter on 20th.
fresh matter.
Fresh, don't worry. List the matter on 20th.
Please,
Yes. ನೀವೆಲ್ಲ ಯಾವ್ದು ಕಾಯ್ತಾ ಇದ್ದೀರಾ? ಅದು ಇದೆಯಾ? ಸೇಲ್ ನಂಬರ್? ಸೇಲ್ ನಂಬರ್? ಹ್ಮ್. 15 ಆಯ್ತು. Let's see, ಕೊಡಿ. No, that I know. Facts, fine. Yes, Girish, ನೀವು ಯಾರಿಗೆ ಅದರಲ್ಲಿ?
I'm not for.
ನೀವಿಲ್ವಾ? ನಿಮ್ದು ಯಾವುದು?
Was waiting for that same matter 119. My lords have said on Tuesday. Tuesday itself the urus starts. ಅದಕ್ಕೆ Thursday if I can.
Friday ಹಾಕಿ.
Thursday.
This Friday. Oh, you ಆಯ್ತಲ್ಲ ಹೌಸ್ ವಾರ್ಮಿಂಗ್.
ಇಲ್ಲ ಇನ್ನೂ ಆಗಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಇನ್ನೊಂದು ಮನೆ ಕಟ್ಟಿದ್ದೀರಾ?
ಒಂದೇ ಒಂದು ಊರಲ್ಲಿದೆ ಅದು ಕೂಡ ಮರಾಠ.
ಅದಕ್ಕೆ ಹೌಸ್ ವಾರ್ಮಿಂಗ್.
ಫಾದರ್ ಅಂಡ್ ಮದರ್ ಅವ್ರು ಇಬ್ಬರೇ ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ. I have to be there for 1 week so ಮರಾಠ.
All right, ಸರಿ. ಯಾವತ್ತು ಬೇಕು?
Thursday. I'll requested my friend also.
Thursday.
Objections if any by then he may file. Please.
119. 119 Thursday ಹಾಕಿ.
Please, I'm so grateful.
ಗವರ್ಮೆಂಟ್ ಯಾರು ಗಂಗಾಧರ್ ಸರ್ ಅದರಲ್ಲಿ ಇಲ್ಲ? ಯಾರು? ನೀವು ಗಂಗಾಧರ್ ಇಲ್ವಾ ಇದರಲ್ಲಿ? ನೀವು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ವ್ಯಾಲಿಡಿಟಿಗೆ ಮಾತ್ರ ಬರೋದಾ?
That require consideration because
there is no precedent. It requires consideration.
Because once they are selected under the they applied under the 371J. However, they are selected under the general quota. Subsequently, they are not.
I asked you, Ramesh Ram adella illa kodi. See, the principle is this: reservation to SC and ST is on caste lines constitutionally determined.
Please.
Reservation in 371J is constitutionally determined, but it is not caste; it is domicile.
Please.
All right.
Correct.
Somebody who comes first rank,
please,
on his own merit, though he has applied under 371J, will not lose that status of being a domicile of that place to say that you will be brought back into the mainstream. He will still continue to be the person belonging to 371J and his seniority should be in 371J.
Otherwise, enter purpose of the 371J will be defeated.
Defeated. Become otious. It's correct. Not, nothing remains. That's exactly the point. Dictate ಮಾಡಕ್ಕೆ ಟೈಮ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಷ್ಟೇ. Yes. ರಿಸರ್ವ್ ಮಾಡಿದ್ರೆ ಏನು ಇಲ್ಲಿದ ರಿಸರ್ವ್ ತಗೊಂಡು ಹೋಗೋದು ಬೆಂಗಳೂರಿಗೆ ನಾನು. ಯಾವ ವರ್ಷ 24th ಇದು. But this requires an answer.
Reservation under Article 1415 manner. That is not purpose oriented. But Article 371J, it is a purpose oriented.
Definitely.
It is a purpose oriented.
In Article 14, it is an enabling provision.
Please.
If it enables grant of reservation, it is given, you take it.
Please.
If there is no enabling provision, nothing. If it is not given, not given. But 371J, purpose itself is, that is why those are caste based and this is domicile based.
And also 371J, but also birth also been added. See, that was there as a discussion by birth also. So
no,
like
that is true. That is by birth.
Even by birth, even 371J also by birth.
That is domicile agade.
Hello, need not be
domicile, not by residence, but by birth.
By birth. That is the difference.
This is not answered by this court anywhere. I will have to answer.
Devdas Sahib judgment allu illa sir.
Illa adralli point consider ಮಾಡಿ.
ಆಗಿಲ್ಲ. About promotion ಬಗ್ಗೆ ಇಲ್ಲ.
ಅಲ್ಲ ಪ್ರಮೋಷನ್ ಅಲ್ಲ, ಸೀನಿಯಾರಿಟಿ ಬಗ್ಗೆ ಇಲ್ಲ.
ಸೀನಿಯಾರಿಟಿ ಬಗ್ಗೆ
ಯಾವ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹಾಕಬೇಕು, ವಾಟ್ ಹ್ಯಾಪನ್ಸ್ ಇಫ್ ದಿ ಮ್ಯಾನ್ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಫಸ್ಟ್ ರ್ಯಾಂಕ್ ಆದದೆಲ್ಲ ಇಲ್ಲ. ದಿಸ್ ಪ್ರೊಜೆಕ್ಟ್ಸ್ ಅನ್ ಇಂಟರೆಸ್ಟಿಂಗ್ ಥಿಂಗ್. ವಿಲ್ ಹ್ಯಾವ್ ಟು ಆನ್ಸರ್. ರಿಸರ್ವ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ನಾನು. ಎಸ್, ಐ ವಿಲ್ ರೈಟ್ ಅ ಡೀಟೇಲ್ಡ್ ಆರ್ಡರ್. ಎಸ್, ಜಡ್ಮೆಂಟ್ಸ್ ಏನು ನಾನು ತಗೊಂತೀನಿ. ರಮೇಶ್ ರಾಮ್ ಆದ್ಮೇಲೆ ಬೇಕಾದಷ್ಟಿದೆ. ಕೊಡಿ ಅಲ್ಲ, ಜಡ್ಮೆಂಟ್ ಏನ್ ಬೇಡ, ನಿಮ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಕೊಡಿ ಸರ್. ಜಡ್ಮೆಂಟ್ ನಾನು ಹಾಕೋದು
ಅಲ್ಲ, ತಮಗೆ ಜಡ್ಮೆಂಟ್ ಕೊಡೋಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ, ಬೇರೆ ಸರ್ವಿಸ್ ಲಾ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದೀವಲ್ಲ, ಗೊತ್ತಷ್ಟೇ. ಹಂಗಾಗಿ this I will write because this has not been answered anywhere. We will answer that. Merely because he jumps to the first rank, he cannot be domicile indane ಹೋಗಕ್ಕಾಗಲ್ಲ.
The purpose will be defeated. Reservation purpose will be.
I will trace the order.
Otherwise, no one going to be claimed.
This arose in 371D when Andhra was given. Andhra Pradesh was given of an IPS officer in the case of 371D, there is a detailed order passed by the apex court. Why that reservation, what kind of reservation and all that. Our lines ಮೇಲೆ 371J was brought in.
Okay.
So 371D was Andhra Pradesh.
Similar, right?
Same amendment. 371J is this. We'll see. I'll answer. So that it becomes, clears the controversy.
Yes, yes. Otherwise, my lord, it is, otherwise, even no one going to be appointed the claiming under the general category. If they are not entitled for promotion.
Indication is 371J. He belongs to that area. He is a person of domicile and birth of that area. So reservation is created, 371J is created only for that purpose. He stands higher in merit and melodra, you come into the mainstream and agala. According to me, it borders upon that. I'll answer that. Heard reserved. Yes.
And people of that area, my lord, hesitate to take the meritorious candidate, meritorious seat because of these provisions, because of these anomaly. So
this will, I think this will set right several problems.
All the police constable selection and all those things, the government issued the notification making the watertight compartment. They are not promoting to the general quota. So subsequently that was questioned before the
dilute madidangide.
Madi Yur Saibrudu Sanjay Gowda Saibrudu judgment bantu. They have said they are entitled as per the other general reservation. They are entitled for the general merit. They should be considered as general merit, and other person should be accommodated as a 371J.
We'll see. We'll solve this problem. Yes. Before I go, I will write and go. Yes. ಏನು ಸಪ್ರೆಷನ್
ಇಲ್ಲ ಅವ್ರೇನೋ ಇವನ್ ಹೆಗಡೆ ಅವರು ಇದ್ರು ಅವರು ಹೇಳಿಲ್ಲ ಅದನ್ನ ಅವ್ರ ಕೌನ್ಸಿಲ್ ಇಲ್ಲ ನಮ್ಗೇನು ಇಫ್ ದೇರ್ ಇಸ್ ಐ ಜಸ್ಟ್ ವೆರಿಫೈ ಲಾರ್ಡ್ಶಿಪ್
ನೋಡಿ
ಇಟ್ ಮೇ ಬಿ
ಜಸ್ಟಿಸ್ ಸಂದೇಶ್ವರ್ ಆರ್ಡರ್
ಇದೆ ಅಂತೆ ಬಟ್ ವೆರಿ
ಅಂತ
ನಾನು ಬಂದಿರೋದು ಆಫ್ಟರ್ ಇದು
ನೀವ್ ಇರ್ಲಿಲ್ಲ
ಅಲ್ಲಲ್ಲ ಅಂದ್ರೆ ಇದು ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಆದ್ಮೇಲೆ
ನೀವ್ ಇರ್ಲೇ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ. The whole problem is the same petitioner had questioned that.
Please, if it is because short date ಹಾಕ್ಬಿಟ್ಟು ನಾಳೆ ಹಾಕಿದ್ರು just I'll come with it.
ಯಾವತ್ತು ಹಾಕಿದೀನಿ ಮೇಡಮ್?
ಅಂದ್ರೆ ಅವ್ರ ಕಾಪಿ ನಾಳೆ ಕೊಡ್ತೇನೆ ಅಂದಿದ್ದಾರೆ.
ಯಾವತ್ತು ಹಾಕಿದೀನಿ? ಮಂಡೇಗೆ ಹಾಕಿರ್ತೀನಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
ಫ್ರೆಶ್ ಹಾಗೇನ್ರಿ ಇದ್ರೆ ನಾನು ಲಾರ್ಡ್ಶಿಪ್ ಮೇಟ್
ಹಂಗಿದ್ರೆ ನೀವು ಮಾಡಲ್ಲ ಅಂತ ಗೊತ್ತಾನೆ.
ಅಂಡ್ ಆಫ್ಟರ್ ಇದು ನಮ್ಗೆ ಬಂದು ಇನ್ನೊಂದು ಹೆಗಡೆ ಅವ್ರಿಗೆ ಸ್ಟ್ರಾಂಗ್ಲಿ ಕಂಟೆಂಟ್ ಮಾಡಿದ್ರೆ ಅದನ್ನ ಕಾಪಿ ಏನಿದ್ರು ತಂದು ಕೊಟ್ಟಿದ್ರೆ ನಾನೇ
ಅದೇ ಅವತ್ತೇ ಹೇಳ್ಬೋದು.
Please,
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್ 101, 102 ಎಲ್ಲ ಏನ್ ಆರ್ಡರ್ಸ್ ಏನ್ ಡೇಟ್ ಕೊಟ್ರು ಮೇಡಮ್? ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
ಸರ್ ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ 102, 103 ಅದೆಲ್ಲ ಆರ್ಡರ್ಸ್ ಯಾವಾಗ ಕೊಟ್ರು ಮೇಡಮ್ ಡೇಟು?
ಯಾವಾಗ ಬೇಕು ಸರ್ ಡೇಟ್ ಅದು?
ನಾಳೆ ನಾಡಿದ್ದು ಹಾಕೊಂಡ್ರೆ ಸರಿ ಇರುತ್ತೆ.
ನಾಳೆ ನಾಡಿದ್ದಿಲ್ಲ 14.
ಆಯ್ತು 14 ಆಯ್ತು ಮೇಡಮ್ 14th ಹಾಕಿ ಮೇಡಮ್.